Let us pray. Almighty God, we willingly acknowledge you as a supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations so that, setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honorable Senators, I have granted leave of absence to Senator Jerlene John, who is out of the country, and Senator Sharice Sipasad, who is ill. Honorable Senators, I have received the following correspondence from Her Excellency the President, Christine Carla Kangaloo, ORTT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Christine Carla Kangaloo, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. To Karuna Bisram Singh, whereas Senator Jerlene John is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago, now therefore I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)A and Section 44(4)B of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Karuna Bisram Singh, to be a member of the Senate temporarily with effect from the 30th of June 2023 and continuing during the absence of Senator Jerlene John by reason of her absence from Trinidad and Tobago. To Mr. Josh Drayton, whereas Senator Sharice Sipasad is incapable of performing her duties as a senator by reason of illness, now therefore I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)B and Section 44(4)C of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Josh Drayton, to be a member of the Senate temporarily with effect from the 30th of June 2023 and continuing during the absence of Senator Sharice Sipasad by reason of illness, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 30th day of June 2023. Honorable Senators are required to take the oath.
I, Karuna Bisram Singh, having been appointed a Member of Parliament, do swear by the Bhagavad Gita that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Josh Drayton, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Bills brought from the House of Representatives, the Administration of Justice Indictable Proceedings Amendment Bill 2023, in the name of the Attorney General.
Attorney General.
Mr. President, thank you. In accordance with Standing Order 62(1)B, I beg to move that the next stage of the bill be taken later in the proceedings.
Honourable Senators, the question is that the next stage of the bill be taken later in the proceedings. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The next stage of the bill will be taken later in the proceedings.
Petitions, papers.
Leader of Government Business.
Mr. President, I have the honor to lay on the table the following papers as listed on the order paper and the supplemental order paper in the names of the Minister of Finance, the Minister of Housing and Urban Development, and the Minister of Sport and Community Development. The reports of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Airports Authority of Trinidad and Tobago for the years ended December 31st, 2018 and 2019. The ministerial response of the Ministry of Housing and Urban Development to the 8th report of the Joint Select Committee on Local Authorities, Service Commissions and Statutory Authorities, including the THA, on a follow-up examination into the recommendations contained in the first report of the Committee on the Administration and Operations of the Land Settlement Agency in relation to squatter regularization, 11th Parliament, 2015 to 2020. And the ministerial response of the Ministry of Sport and Community Development to the 9th report of the Public Accounts Enterprises Committee on the examination of the audited financial statements of the National Commission for Self-Help for the financial year 2016 and follow up on the implementation of the recommendations in the committee's 14th report from the 11th Parliament.
Reports from
Senator the Honourable Randall Mitchell.
Thank you very much, Mr. President. Mr. President, I have the honor to present the following report as listed on the order paper in my name. The report of the Joint Select Committee appointed to consider and report on the Shipping Bill 2020, 3rd Session 2022-2023, 12th Parliament.
Senator Dr. Varma Dayal Singh.
Mr. President, I have the honor to present the following report as listed on the supplemental order paper in my name. The 7th report of the Joint Select Committee on Local Authorities, Service Commissions and Statutory Authorities, including the THA, 3rd Session 2022-2023, 12th Parliament, on an examination of the institutional strengthening initiatives of the Service Commissions Department. Thank you.
urgent questions.
Senator Mark.
Thank you, Mr. President. to the Honorable Minister of Housing and Urban Development. Given the HDC's commitment to repair the destroyed roof at Building 4, Trumaka, by July 2nd, 2023, can the Minister indicate whether any temporary housing or immediate financial support will be provided to displaced residents in the interim?
Yes.
Thank you, Mr. President. Responding on behalf of the Minister of Housing and Urban Development to this urgent question, the answer to the question posed is yes. The 15 individuals comprising 4 families affected within Trumakak were offered on Tuesday, 27 June 2023, the provision of temporary accommodation at a nearby location. However, the residents offered instead to stay with close relatives and friends. One particular neighbor housed a family of 2. I'm pleased to report that today roof repairs did commence at the location with the erection of scaffolding very soon after the incident, with an estimated completion date for all of the repairs of 21st July 2023. The Housing Development Corporation put out a media release which provides, Mr. President, the public with a comprehensive accounting of the response to this particular unfortunate development. Thank you very much.
Senator Mark.
Yeah, Mr. President, through you to the Honorable Minister. Honorable Minister, can you inform the Senate the nature, or should I put it another way, Mr. President, what type or kind of accommodation was provided by the HDC to the 15 or 16 displaced residents of Building 4 at Trumaka? Can the Minister identify?
Well, Mr. President, just to reaffirm with respect to the question and the answer, there was no accommodation taken up. So if the supplemental is what was provided, the response has already been indicated that the individuals took up accommodation with family and friends, as happens from time to time after temporary unfortunate circumstances. With respect to what was offered, if that is being sought, an emergency shelter accommodations were immediately offered at a nearby community center, as has been applied in past issues of natural disaster and unfortunate circumstances. Thank you, Mr. President.
Senator Mark. Senator Richards.
Thank you, sir. Thank you, Mr. President. Through you to the Minister, can the Minister or the Ministry indicate if a structural audit has been done by the Ministry on similar buildings, given this is the hurricane season and similar issues may arise, posing a challenge to safety of clients?
Minister.
Mr. President, I'm not in a position to comment on a structural audit, but I'm certain that the Ministry would take note of the question as posed by the Senator. What I can indicate, as has already been referenced, immediate work has been initiated on this particular location, and a completion date has been offered. Thank you, Mr. President.
Questions unnoticed, questions for oral answer.
Leader of Government Business.
Mr. President, there are 3 questions on the order paper for oral response. The government is in a position to answer 2 of them, and we seek a deferral of 2 weeks on question number 81. Thank you.
81. Question 81. Honourable Senators, the deferral, question 81, that the member seeks is so granted. Senator Mark.
Mr. President, seeing that this Parliament may not be here next week and we go into recess, this would become, redundant because we come back in September. So I'm wondering if the minister could not really get this answer to us before the close of today. I just wanted to bring that to your attention.
Senator Mark, a request was made and the request was so granted. Senator Mark.
Thank you, Mr. President. Question number 80 to the Minister of Foreign and CARICOM Affairs.
And CARICOM Affairs.
Thank you, Mr. President. The Ministry of Foreign and CARICOM Affairs is seeking to identify an appropriate candidate to fill the post of Inspector of Missions. It is not possible at this stage to state precisely when that process will be completed, but every effort is being made to do so as quickly as possible. In the interim, the Ministry of Foreign and CARICOM Affairs has ensured via internal arrangements that key functions of that post are being dealt with appropriately. An appropriate candidate with respect to Part 2 of the question, an appropriate candidate has not yet been identified. This particular position requires some significant knowledge and experience specific to the ministry's operations. And the ministry must therefore ensure that it identifies a candidate with the relevant extensive expertise. Thank you, Mr. President.
Senator Mark.
Through you, Mr. President, to the Honorable Minister. Honorable Minister, why has it taken almost 4 years to locate, as the Honorable Minister has said, the expertise required to fill and to fit for purpose this particular office? Can the Minister explain, Mr. President, why it has taken almost 4 years to fill such an important office in the Ministry of Foreign and CARICOM Affairs?
Thank you, Mr. President, and thank you to the Senator for repeating the question, the supplemental, twice. Basically, Mr. President, as indicated, this position requires specific peculiar knowledge and expertise relevant to the ministry's operations, and therefore such a search must be conducted carefully and is ongoing at this time. With respect to the time frame posed in the supplemental question, I can respond specifically in the more recent period and to assure the poser of the question that such an undertaking is underway. As indicated, we last had an inspector of mission in 2019, and efforts are being made to fill this position. I assure that in the interim, during that reference period, a technical team has been put in place, led by a senior foreign service officer, a dedicated public servant, supported by 3 technical staff members and associated administrative staff to ensure that the functions of this division are appropriately carried out and the missions have been receiving the relevant support. Thank you, Mr. President.
Senator Mark.
Mr. President, through you to the Honorable Minister. Honorable Minister, can you indicate what form or forms are being executed to attract this personnel to fill this office? In other words, Mr. President, is the government pursuing public advertisement as an example to fill this post? Because he said ongoing efforts are being made. So all I'm asking, Mr. President, is what are these ongoing efforts?
Thank you very much, Mr. President. Within the supplemental, there was a suggestion. That certainly is an avenue being considered for this post and several other posts of a sensitive nature in support of the ministry's functions. At this time, the search is ongoing via other means. There is consideration being given to the option of a public advertisement. Thank you, Mr. President.
Mark.
Can I ask through you, Mr. President, for the Minister to identify for this Honorable Senate, what are the other means that are being pursued by Ministry of Foreign and CARICOM Affairs to access and make available to the ministry that important office holder? What are the means
Minister.
that are being pursued?
Mr. President, it's an interesting question because my recollection of the last time another administration filled this position, it had nothing to do with public advertisement. So the member should be familiar that in filling such lead positions, very often there's reliance on awareness and knowledge of persons with experience within the system, reference to retired officers and other individuals of the citizenry who have the capacity and the experience that can be considered. So that involves careful consideration, vetting, inquiries among the cadre of officers within the ministry and others that we are associated with through the work of the Ministry of Foreign and CARICOM Affairs. Thank you, Mr. President.
Senator Mark.
Mr. President, through you again. Honorable Minister, through the Honorable President, given the importance and significance of this office to the functioning of the Ministry of Foreign and CARICOM Affairs, can the Minister identify to this Honorable Senate what are the essential skill sets required of this office holder to carry out those responsibilities necessary within the framework of the Ministry of Foreign and CARICOM Affairs? Can he share with us?
The question is on the rise, Senator Mark. Next question on the order paper.
Question number 82 to the Minister of National Security.
Thank you, Mr. President. Mr. President, at the outset, it should be noted that while pieces of equipment, including items of uniform, have been discovered at crime scenes by the Trinidad and Tobago Police Service, TTPS, bearing the word police or containing markings such as police emblems, not all such items are necessarily the property of the TTPS. Nevertheless, the Commissioner of Police has advised that the TTPS is currently taking several steps to address the issue of police equipment being found at crime scenes, including the conduct of 1, thorough investigations into all cases where these items are discovered to determine the ownership and source of the items. 2, an audit of all arms and ammunition issued to divisions, branches, sections, and units of the TTPS. Thus far, no irregularities have been identified, but the process remains ongoing. 3, a re-examination of the TTPS's procurement practices as it relates to the procurement of firearms and ammunition. 4, a review of its standing orders related to the distribution of items of uniform, as well as the development of new strategies to ensure that police officers are compliant with those standing orders, properly securing their items of kit and uniform. And 5, an audit of all items of uniform issued, which is anticipated to be concluded by the 31st of March 2023. Yes, let me reread. And 5, an audit of all items of uniform issued, which is anticipated to be concluded in the near future. It is expected that any discrepancies identified by the audit will be thoroughly investigated and forwarded to the Complaints Division for consideration and appropriate disciplinary action as necessary, Mr. President. Additionally, the Commissioner of Police has further advised that instructions have been given for the ascribing of all items of uniforms assigned to police officers with their full name and regimental number to facilitate proper identification and tracking of these items in the future. The TTPS also plans to hold discussions with security companies as it relates to the use of uniforms resembling that of the TTPS. And therein, Mr. President, lies a comprehensive answer to the question.
Senator Mark.
Mr. President, through you, to the Honorable Minister. Having regard to the frequency and regularity of police uniform, arms, ammunition being found on crime scenes in this country, can the Minister advise this Honorable House whether the government, given the rogue element that exists in the police service, I'm getting to it, sir. Can the Minister advise through you whether the Commissioner of Police is contemplating establishing an independent forensic criminal investigation into this matter? It's a very serious matter.
Minister.
Mr. President, if the poser of the question would have listened very carefully, you would have identified that several audits are currently underway, being undertaken by the TTPS, led by the Commissioner of Police, who has given very specific assurances and information in response to this question. Of note, it should be noted that no irregularities have been identified, but that this process is ongoing. We can be assured that if there's any indication of irregularity in these ongoing audits, then further steps would be taken as contemplated. Thank you, Mr. President.
Senator Mark.
Mr. President, again, through you, seeing that citizens have been murdered by police bullets, allegedly, right? Yes, Mr. President, I'm going to question. Mr. President, I would like to ask the Honorable Minister if he can share with this Honorable House how many specific audits are being currently conducted. We hear several. Can he identify how many audits are being conducted?
Mr. President, I preface the response to the last supplemental by saying if the member had listened carefully, but there was a specific indication of 5 responses, 2 of which are audits. I will further specify an audit of all arms and ammunition issued to divisions, branches, and sections and units of the TTPS. That's 1, Mr. President. And the second audit is a specific audit of all items of uniform issued, which is anticipated to be concluded in the near future. It is expected that any discrepancies identified will be further investigated and forwarded to additional divisions such as the Complaints Division for disciplinary action where such is deemed necessary. Thank you, Mr. President.
Senator
President,
Mark.
through you again. Honorable Minister, through the President, given, as I said, the irregularity of this occurrence in this country, can the Minister indicate whether the government is contemplating seeking external assistance and intervention to get to the bottom of this frightening, disturbing, and troubling situation in our nation?
Mr. President, the government has taken note of the phenomenon as described, has received the responses and actions from the Commissioner of Police and the indications that have been identified in the response to this question. I would want to further elaborate that many of the items that are ascribed and bear the word police do not necessarily stem from the Trinidad and Tobago Police Service. So in the adjectives used, the dramatic adjectives used by the senator should not assume that all of these items originate within the TTPS, and that area is the subject of investigations and audits as identified at this time to make those determinations.
Mark?
President, can I ask through you to the Honorable Minister, how soon in the near future will these reports will these audits rather be completed? It is a bit vague.
Minister.
So could the minister give us a specific time frame for the completion of these?
Senator Mark. Minister.
Thank you, Mr. President. Mr. President, just by the nature of an audit into an exercise like this, the member should have sufficient experience to recognize that it would be impossible to put a specific end date to a process such as this, depending on information revealed, items disclosed, evidence identified, then an audit can be further elaborated. So it is very difficult. We are assured that these matters are ongoing, receiving the appropriate attention, and will be concluded in the near future. That is as specific as the government can indicate at this time.
Motions relating to the business or sittings of the Senate and moved by Minister.
Leader of Government Business.
Mr. President, having regard to the report of the Joint Select Committee appointed to consider and report on the Shipping Bill 2020, third session 2022-2023, 12th Parliament, I beg to move that in the fourth session of the 12th Parliament, a committee be re-established to consider and report on said bill, and that this committee be mandated to adopt the work of the committee appointed in the third session.
Honourable Senators, the question is that in the fourth session of the 12th Parliament, a committee be re-established to consider and report on the Shipping Bill 2020, and that this committee be mandated to adopt the work of the committee appointed in the third session. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Leader of Government Business.
Thank you, Mr. President. Mr. President, in accordance with Standing Order 77.3, I beg to move that the following bills be restored to the order paper in the fourth session 2023-2024 of the 12th Parliament. The Private Security Bill 2022 and the Supplemental Police Amendment Bill 2022.
Honourable Senators, the question is that in accordance with Standing Order 77.3, the following bills be restored to the order paper in the fourth session 2023-2024 of the 12th Parliament. The Private Security Industry Bill 2022 and the Supplemental Police Amendment Bill 2022. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
Public Business, Government Business, Bill second reading.
Attorney General.
Thank you, Mr. President. I beg to move that a bill entitled An Act to Amend the Administration of Justice, Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. And may I put at the masthead of everything that I will say today, Mr. President, the fact that we are today considering legislation to abolish preliminary inquiries, which concerns the pre-trial stage of the criminal trial process. We must not lose sight of that in the context of all that will be said and the significant moment that we now are at in this august chamber. Mr. President, the bill before the Parliament is a significant tool in reducing the endemic delay in the criminal trial process. The statistics demonstrate that as of March 2023, there are approximately 37,933 pending indictable matters at the district courts. This means that there are 37,933 criminal offenses, serious criminal offenses, including murders, attempted murders, robberies, rapes, trafficking in persons, misbehavior in public office, and other types of fraud, which are currently pending at the pre-trial stage. A pre-trial stage, Mr. President, which in the norm in Trinidad and Tobago over the past several years, going into more than a decade, ordinarily takes 2 to 3 years, on certain occasions, including matters which are still current, as much as 15 years. These numbers, Mr. President, do not merely represent pending matters or charges. They represent thousands of persons whose lives have been disrupted, who wait in abeyance on some form of progress and/or closure to serious criminal matters and charges which have followed them like a shadow for many years. Every one of those 37,933 matters, Mr. President, involves an accused person or multiple accused persons, a victim, sometimes multiple victims, tens of witnesses, interested family members, and of course the affected public. This is the reality of our criminal justice pre-trial system. To add to this staggering number, Mr. President, is the average of 8,835 indictable matters filed annually, which now join the queue of the 37,933 pending matters. Critically, we accept that the work of conducting preliminary inquiries is shared between the Office of the Director of Public Prosecutions and the Trinidad and Tobago Police Service. At current, the Office of the DPP has under its conduct approximately 2,120 preliminary inquiries. For the period 2013 to 2023, the office has concluded 900 preliminary inquiries. We have requested statistics from the Trinidad and Tobago Police Service, and the data from the Court and Process Branch of the Trinidad and Tobago Police Service reflects that there are currently 1,326 preliminary inquiries under the purview of that branch. In looking at those statistics, Mr. President, with an overall average of 37,933 pending matters and an additional approximate 8,835 matters joining the list every year, it is clear that the pre-trial stage of our criminal justice system is in dire need of complete overhaul. This is an undisputed fact and cannot be allowed to continue. There can be no dithering. In my respectful submission, there can be no interference in the discussion and the decision-making process which we are going to engage in by introducing personal or political differences. We have to put those aside because the people of this country demand better, demand decision, and demand action on our part. Mr. President, from the outset, may I say, from as early as 2015, the government has prioritized the abolition of preliminary inquiries as a significant step in the improvement of the criminal justice system. In 2022, we made a final call, including previous calls, to stakeholders and received feedback from the Office of the Director of Public Prosecutions, the Judiciary, the Public Defender's Department, the Trinidad and Tobago Police Service, and engaged in substantial consultation processes. From the Law Association of Trinidad and Tobago, from the Criminal Bar Association, and from 2021, Mr. President, the reconstituted Criminal Justice Committee, chaired by the Honorable Chief Justice, has continued and engaged that process of consultation. That committee is composed of, among other heads of departments, the Attorney General, the Chief Magistrate, the President of the Law Association, the Commissioners of Police and Prisons, the Chief Public Defender, and the Director of Public Prosecutions. The time has come, enriched by that process of consultation and significant hard work, Mr. President, for us to engage today to pass the bill which is before this House and to abolish the lethargic and indolent system of preliminary inquiries and move to a fast-track trial process. The current pretrial system, Mr. President, is governed by the Indictable Offences Preliminary Inquiry Act, Chapter 1201. In 2005, we saw the introduction of paper committals, which was an attempt then to improve the system. The harsh realities, those paper committals have led to the use of written statements and documentary evidence and the use, and one might even say the abuse of multiple cross-examination, multiple pre-trial processes that have allowed for inordinate delay in the disposition of preliminary inquiries, with 88% of preliminary inquiries into capital matters taking over 2 years to completion. It has led to an undue incarceration of accused persons who are eventually found, many of whom are eventually found not to have had a prima facie case made out against them after close to a decade of imprisonment. It has led to the obvious depletion in the quality of evidence, both at the preliminary and subsequent trial stages, to the failing memory of eyewitnesses, and to the increase in the number of witnesses who have died or cannot be located to provide testimony and subject themselves to cross-examination, which cross-examination is sometimes prolix and conducive of even further delay. We begin our conversation on this piece of legislation before this House today, Mr. President, by reminding ourselves that we have the ruling of our highest court that it is not in any way unconstitutional to abolish preliminary inquiries. The case in point out of Antigua is Hilroy Humphreys and the Attorney General of Antigua and Barbuda, 2008 UK PC, in which the Privy Council held that the defendants in criminal proceedings do not have a vested right to any particular procedure, and there will generally be nothing unfair in applying whatever procedure is in force when the case comes to court. Section 53 of our Constitution, Mr. President, charges us with the responsibility to make laws for the peace, order, and good government of Trinidad and Tobago. And that is what we are here about today. Mr. President, the bill before us, if I may speak with some measure of emphasis, involves us taking a hard look at our systems and introducing a new system which is going to be allowing defendants, accused persons, the right to a fair trial, allowing a fulsome role for the Office of the Director of Public Prosecutions, the independent office charged with the conduct of prosecutions under our system, and is going to divide the pre-trial process substantively into two compartments, the initial hearing and the sufficiency hearing. I will come to that. But may I, in anticipation of comments which I have no doubt will be made, may I say, Mr. President, that in the process of coming to this House with this bill, among other persons who have been consulted on this piece of legislation, I have listed them all, but I would emphasize the Office of the Director of Public Prosecutions has been consulted. Several letters have been written to him inviting his input, and he has made input. And may I say, Mr. President, with reference to the Office of Director of Public Prosecutions, that I continue to engage with that office, an important part of the criminal justice system, in order to ensure that we make progress in improving our criminal justice system. I have personally participated in meetings with the Director of Public Prosecutions and the Chairperson of the Judicial and Legal Service Commission as recently as April 2023 to address some of the challenges. I'm informed that interviews for State Counsel were conducted as recently as early May 2023, and of course, I give the assurance to the public, the citizenry of this country, that the Office of the Attorney General continues to place the Office of the Director of Public Prosecutions, the independent office, at a most pivotal stage in the improvement of our criminal justice system. Mr. President, I would move to the clauses of the bill. I will emphasize some at the outset. Clause 4 of the bill before us, among other things, which deals with definitions, introduces the concept of electronic filing, which reduces our archaic paper-based systems. Clause 15 introduces the early filing of the indictment, that most important document which commences, really, the process of the criminal trial, and which has been for far too long delayed at the latter end of the process. We are now bringing it in to the first stage of the criminal trial process. And clause 15 will deal with the scheduling order. I will come to that, and we will get to the sufficiency hearing. What we are seeking to do by this bill is to reduce the extent to which the pre-trial stage of a criminal trial becomes mired in a lengthy and unduly delayed process, as if it were the trial itself, when it is not, because all that the pre-trial stage is intended to do is to satisfy, under the system that exists now, the magistrate, and under the system that we are going to introduce under this bill that is before this House, the master, that a sufficient prima facie case has been made out, at which stage the case is transferred to the High Court judge so that the actual criminal trial can get moving. And if we do what we are going to accomplish under the bill that is before this House, we will move, Mr. President, and I emphasize this, we will move a sea change in our criminal trial process, because we will move from a process by which persons are incarcerated during the pre-trial phase for up to 3 years, sometimes as much as 10 years, to a period of, hopefully, not more than 6 months, at which stage, if a prima facie case has been made out, the case goes to trial and is dealt with at the trial stage. Mr. President, the bill before this House is long, 45 clauses long, and I am hoping not to spend an undue period of time going through the clauses clause by clause, but rather to highlight the relevant clauses, the more important clauses. So an example of the highlight is clause 2 of the bill, which provides for a proclamation clause. And that proclamation clause is important because what it means is that often, I say this with confidence and optimism, after we pass this bill this evening into law, a period of time will be permitted before proclamation so as to enable further consultation, training, and sensitization so that when the bill is finally proclaimed, all shoulders are to the wheel of an improved criminal justice machinery. We have a definition section, Mr. President, Clause 4. And Clause 4 of that definition section deals with a number of different definitions. The term appropriate adult is one of the terms used in the definition section, which simply means, with reference to Section 3 of the Children's Act, that appropriate adults who are listed in Section 3 will be available to accompany the children who come before the courts under different offenses before the different children's courts. It also includes, Clause 4, an expansion of the prosecutor, because what this bill seeks to do through Clause 4, as it introduces the concept of police prosecutor, is to encourage, by an amendment to Section 64A of the Police Service Act, to encourage police prosecutors to comply with the requirements of the Legal Profession Act so that fully legally qualified police officers can function as prosecutors to assist and support the Office of the Director of Public Prosecutions in prosecuting cases at the indictable stage, at the initial hearing, at the sufficiency stage. Mr. President, Clause 5 of the bill before us seeks to amend Section 4 of the Preliminary Inquiries Bill. And among other things, it empowers magistrates to determine those cases in certain circumstances which are to be determined in accordance with the new act when we pass it, or whether they will remain before the magistrate at the stage before this act came into force. Mr. President, Clause 6 seeks to amend Section 5 of the act. And that Clause 5, Section 5, was further amended in the House of Representatives before we came here today. And may I just emphasize that the purpose of that amendment, which I brought before the House of Representatives, was to ensure that premises which are referred to in Section 5, when they are to be searched or seized, have the protection of due process and the protection of law if ultimately the magistrate, the master, under this new legislation, were to authorize the search of premises which are not named in the search warrant, but have to be satisfied. The master has to be satisfied that the provisions of Section 1 of Section 5 are satisfied. And that was the purpose of the amendment which we brought in the House of Representatives. There were other amendments that were made to Section 5, which is identified at Clause 6, and we will address those in due course, Mr. President. We also make provision, Mr. President, for the initial hearing stage of the preliminary trial stage. And the initial hearing stage, Mr. President, is a very important stage, and I have asked for members of this Senate to be provided with the consolidated version of the legislation which is being amended. And the initial hearing stage of the trial is introduced at Section 11 of the Act, and that is a section which is being amended in significant terms. So if members would stay with me as I look at Section 11, which is being amended under clauses 15 through to 19 of the bill before this House. That initial hearing stage brings significant features to the improvement, Mr. President, of the pre-trial process. Significantly, what is introduced by the amendment to Section 2, Roman H3, is that the prosecutor, and I am now at Section 2H, Roman 3 of the consolidated, the unofficial consolidated bill, the prosecutor shall file in the High Court and serve on the accused the indictment and all witness statements and other documentary evidence that he intends to use at the sufficiency hearing, which date shall be no later than 3 months from the making of the scheduling order or such longer period as the master thinks fit. The significance there is that the indictment is being introduced at the very beginning of the process. We have cases before our courts right now, Mr. President, in which persons are on remand yard for 3 years and the indictment has not yet been served. It is mandatory from the minute this case comes before the master, when you look at the amendment that is being proposed, that the indictment shall be served by the prosecutor on the accused, all witness statements, and I've already addressed that, and that he intends to use it at the sufficiency hearing. The sufficiency hearing date shall be no later than 3 months from the date of the making of the scheduling order, which the master is managing at this very early stage. Roman 4, the accused shall file in the High Court and serve on the prosecutor any witness statements and other documentary evidence that he intends to use at the sufficiency hearing, which date shall be no later than 28 days. So again, strict timelines are being introduced. Roman 5, the sufficiency hearing shall commence, and we will get to the sufficiency hearing when we come to sections 19 through to 37 of the consolidated version. The sufficiency hearing shall commence, which date shall be no later than 28 days or such longer period as the master thinks fit from the date specified under subparagraph 4. So we see that with the introduction of the amendment that is brought by Clause 15, that the indictment is filed immediately, we immediately introduce a timeline under robust court management by the master to ensure that the trial is taken forward in an expedited manner. I cannot stress too much, Mr. President, the importance of the filing of this indictment at the initial hearing stage in ensuring that the pretrial proceedings are conducted with greater efficiency. And significantly, Mr. President, this does not interfere with the Director of Public Prosecution's ability to amend, add, or withdraw counts on the indictment as needed. So, Mr. President, that is, in my respectful submission, one of the most significant introductions, one of the most significant amendments that is being made by the clauses 15 through to 19 of the 11 through to 19 of the unofficial consolidated act, which is introduced from clause 15 of the bill before this House. And then we get, Mr. President, to clauses 20 through to 27. Clauses 20 through to 27 then introduces the sufficiency hearing. And at this stage, what we have before the master at the sufficiency hearing stage is the indictment and all of the witness statements and other documentary evidence which has been filed by the prosecutor and the defense, the accused persons, assisted by legal aid. All of that is prescribed in the earlier sections of the unofficial consolidation. And at this stage, the master will address the sufficiency hearing on the paper before her or him without engaging in the protracted preliminary inquiry process which currently bedevils our criminal justice system of lengthy cross-examination, prolix cross-examination, a multiplicity of witness statements that are introduced over time. Clauses 20 to 37 of the bill provide for the sufficiency hearing. Mr. President, Clause 20 of the bill will amend Section 19, and the Clause 19 will improve the language by deleting and substituting certain chapeaux in order to improve the language and ensure that the procedure is properly explained. The clause will also repeal subsections 6, 7, and 8 and substitute new subsections 6, 7, and 7A in order to adequately deal with adjournments at a sufficiency hearing. Another ill that bedevils our criminal justice system. Undue adjournments that are allowed in the absence of a robust judicial management. One of the things that this bill is introducing is a very robust judicial management process. Clause 21 of the bill will insert after Section 19, Mr. President, a new Section 19A dealing with witnesses and witness statements as it pertains to the sufficiency hearing. It is proposed that the attendance of a witness shall not be required at a sufficiency hearing unless, on application, the master makes an order for the attendance of a witness who filed an unsworn statement. This, Mr. President, is a pivotal change to the way pretrial procedures are conducted. The addition of oral evidence by way of further evidence and cross-examination has been identified as a major cause for the protraction of the current preliminary inquiry process. Clause 23 of the bill, Mr. President, will amend Section 21 of the Act by deleting subsection 2 and paragraph C and D and inserting new paragraph C and D to ensure that there is clarity in procedure as it relates to the admissibility of prosecution witness statements. This clause will also amend sections 21.3 and 21.3a by deleting the words adult of choice and substituting the words appropriate adult, and I've already addressed that with reference to clause 4 and the definition of appropriate adult, which one finds in section 3 of the Children Act, and deleting the words or any other person qualified, substituting the words child psychologist, social worker, counselor, or other person who is similarly qualified, respectively. Clause 23 of the bill, Mr. President, will delete DA in relation to section 21.4a and substitute a new DA in order to clarify the procedure as it relates to a statement by a person who does not speak fluent English. Additionally, this clause will amend section 21.5 by repealing it and amend section 21.8 by repealing and substituting a new section 21.8 which pertains to a transcript of proceedings and evidence obtained under a treaty to be admissible as evidence at a sufficiency hearing. Clause 24 of the bill will amend section 23 of the Act by deleting paragraph B and substituting a new paragraph B to clarify the procedure and to provide for the Criminal Procedure Act relating to orders under section 25 concerning a master's final decision at a sufficiency hearing. Clause 25 of the bill, Mr. President, will amend section 24 of the Act by inserting in subsection 1 the words on the indictment, which concerns the discharge of the accused. This clause will repeal subsections 4 to 11 of section 24 of the Act and substitutes it with new subsections 4 to 6 in order to allow the Director of Public Prosecutions to appeal the decision of the master if the director is of the opinion that the accused ought not to have been discharged. It also allows for the appeal of a master's decision to the Court of Appeal in accordance with Section 65C of the Supreme Court of Judicature Act. I pause there just to emphasize this point, Mr. President, because in the other place, much was said about the fact that the jurisdiction of the independent director under Section 90 of the Constitution was being eroded to the extent that the master was being given the power to second-guess the decision of the Director of Public Prosecutions. And what this section does is to allow the Director of Public Prosecutions to appeal to the Court of Appeal in accordance with Section 65C of the Supreme Court of Judicature Act if the master has made a decision with respect to the sufficiency hearing that the decision that the director is not happy with. So there is no erosion of the function of the director, because to the extent that he is allowed to appeal the decision to the Court of Appeal, the Court of Appeal will be able to review the decision of the master, and if the director makes out a successful appeal, will restore the decision of the director. Clause 26 of the bill, Mr. President, will amend Section 25 of the Act by repealing subsection 1, substituting new subsections to deal with an offense under the Criminal Procedure Act. It allows for the indictment to be amended accordingly. The clause also amends Section 25 by repealing subsections 2 and 3, deleting and substituting words in subsections 4 and 5 to ensure clarity of language as it pertains to the Criminal Procedure Act. Clause 27 of the bill will amend Section 26 of the Act to clarify the language relating to the procedure of transmission and custody of documents and exhibits relating to a case. Mr. President, clauses 28, 29, and 30 of the bill will amend Section 26A of the Act by repealing Section 26A, which has now become obsolete, would amend Section 26B of the Act by repealing Section 26B and amend Section 26C of the Act by repealing the current Section 26C. Section 26C allowed for the DPP to determine which case is to be dealt with summarily or indictably after the completion of an entire sufficiency hearing. And this, in our respectful view, defeats the purpose of this fast trial law. While this has been repealed, the idea is that the DPP has early notification of whether or not a matter will be dealt with summarily or indictably, and does not have to wait until after an entire sufficiency hearing is completed to exercise that power. In our respectful view, this is a waste of judicial, prosecutorial, and other resources. Clause 31 of the bill, Mr. President, will amend Section 27 of the Act by repealing Section 27. This effectively removes Schedule 6 matters which were exempted from discharge. This is better aligned now, as the indictment is now being filed at the beginning of the sufficiency hearing process, so there's no longer a need to have a schedule which exempts matters from discharge due to delayed filing of the indictment. Clause 32 of the bill will amend Section 28 of the Act by deleting paragraph C of Section 28(1), inserting a new subsection 1A to account for where a master has referred an accused to a judge for sentencing following an early guilty plea, and the Director of Public Prosecutions must be given notice of that referral. Clause 32 of the bill amends Section 28 by repealing subsection 2, substituting a new subsection to allow for when a master refers an accused to a judge for sentencing, for the statement of the accused to be reviewed in evidence upon its mere production without further proof. Clause 36 of the bill will amend Section 29(2)(b) by allowing the oath of a credible witness whose attendance is not reasonably practicable as a result of being outside of Trinidad and Tobago, and for that person to be secured, that person's evidence to be secured either physically or by electronic means. This clause will also amend Section 29 of the Act by repealing Section 29(7). Clause 37 of the bill will amend Section 30 of the Act by repealing subsections 1 through 6, substituting subsection 6 with a new subsection to account for an indictable offense being dealt with by the High Court in accordance with the Criminal Procedure Act. And I emphasize the point throughout, Mr. President, that the Criminal Procedure Act, an involved, detailed piece of legislation, remains in place as the legislation which regulates the trial at the assizes, where the real trial takes place after the preliminary pre-trial stage has been expedited by the amendments that we bring by reason of this bill. Clause 38 of the bill, Mr. President, will amend Section 32A of the Act by deleting and substituting words to clarify the procedure, deleting subsection 5, substituting a new subsection 5 to state that when notice is given to the registrar under subsection 3, the registrar shall issue a notice to the accused to appear before a master on the date specified in the notice. Clause 39 of the bill will amend the Act by inserting a new Section 32, new Section 32B to deal with anonymization of documents for a variety of reasons. For example, the protection of witnesses. Importantly here, the original version of the document is always retained for court and internal purposes. And again, in the other place, Mr. President, a lot of time was spent criticizing the anonymization process on the mistaken assumption that this had to do with anonymizing of witnesses. This is not the anonymizing of witnesses. It is the anonymization of documents. The witnesses, their witness statements have been served, but they are vulnerable persons, and it's all spelled out in the legislation. Persons who have to be protected, and therefore there is a process of anonymization of documents in order to give some comfort to persons who are identified in what can sometimes be a very harsh spotlight of the criminal justice system. Clause 40 of the bill will amend the Act by amending Section 33(2), deleting the words, neither the prosecutor nor the accused elects to have the case determined in accordance with this Act, and substituting the words, no order is made under Section 32A, in order to allow for savings under the Indictable Offences Preliminary Inquiry Act. Clause 41 through 44 of the bill will amend Sections 34 throughout. Clause 42 of the bill will amend Schedule 5 by deleting Form 1 and substituting a new form. Clause 43 of the bill will repeal Schedule 6. Clause 44 of the bill will amend Schedule 7 to the Act by repealing Schedule 7 and substituting a new Schedule 7. And finally, Mr. Speaker, Mr. President, Clause 45 of the bill deals with consequential amendments as a result of the passage of this legislation. The Summary Courts Act, the Criminal Procedure Act, the Criminal Procedure Change of Venue Rules, the Police Service Act, and the Family and Children Division Act. Mr. President, this bill, when we pass it today, will complement a host of reforms which this government has already brought to the Parliament and has brought to this country. And I can identify a few. The backlog identification at all levels of the court and prosecutorial division, the creation of divisions of court, the introduction of judge-alone trials, the decriminalization of road traffic offenses, the introduction of new plea bargaining legislation, the increase in judicial capacity and support systems, the creation of a public defender system, the enhancement of the prosecutorial system, the introduction of criminal procedure rules, the implementation of a fully computerized case management structure. Mr. President, when we look at the benefits to be gained by the passage of this act, I could give an example in terms of timeline. The new trial procedure from charge to discharge or committal for trial is approximately 6 months, as opposed to 2 to 3 years, or in some cases, as much as 15 years. Search warrant, the constable is to complete and file the report in the High Court within 14 days. The accused appears and is brought before a master for an initial hearing. At the initial hearing, the prosecutor is to file and serve on the accused the indictment no later than 3 months. The master, of course, has a discretion. At the initial hearing, the accused must file and serve evidence on the prosecutor no later than 28 days after the prosecutor has filed and served the indictment, of course, with the master having a discretion. In the case of adjournments, the adjournment shall be for no longer than 28 days unless with the consent of the parties. The accused must serve notice of his alibi within 28 days from the initial hearing. The sufficiency hearing must commence no later than 28 days after the accused files and serves evidence, of course with the master preserving a discretion to manage the fairness of the process. And at the sufficiency hearing, where an accused is remanded to stand trial, An adjournment shall not be for more than 28 clear days.
Attorney General, you have 5 more minutes.
Thank you very much, Mr. President. At the sufficiency hearing, the accused can be discharged by the master on the written request of the DPP and must transmit within 14 days the record of the sufficiency hearing. Again, if at the sufficiency hearing the accused admits guilt, he must appear before a judge for sentencing within 3 months. The trial witness statements must be tendered 21 days before trial. At trial, the DPP shall, at least 28 days before the date fixed for trial, give notice to the registrar of the information on witnesses whom he desires to attend at the trial of an accused at the High Court. And that is the stage at which one then introduces the fairness of the process involving cross-examination of witnesses and the like. Mr. President, the reality is that we really simply do not have a choice. If we are to progress our criminal justice system, we have to move out of the lethargic and indolent system which has been characterized by the preliminary inquiry stage, which I said at the beginning, and I repeat now as the masthead of my submissions, is no more than the pre-trial stage. What we are seeking to do is to shorten the pre-trial stage to give an accused person his entitlement to a fair hearing at the assizes if he's committed, and if he's not committed because a prima facie case has not been made out, then within 6 months from when he was charged and brought before the master, he can walk free and get on with his life. Mr. President, with leave of this court, this House, I beg to move.
Honourable Senators, I shall now propose a question for debate. The question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Senator Lakshmi Dayal.
Thank you. Thank you, Mr. President. Mr. President, I am pleased this afternoon to join in this debate and make a few comments about the proposed amendment to the Administration of Justice Indictable Proceedings Act, which we have over the years shortened to AJIPA. And Mr. President, the state of the criminal justice system in Trinidad and Tobago is well known, I think, to everyone in here, and certainly to most persons who are in the public. It is a topic of grave concern. It is something that has been discussed, I don't want to say ad nauseum, because I do believe that further discussion is needed, but it is a topic that continuously rears its head, whether it is from the Law Association, the ordinary man on the street complaining about what are the problems facing the country right now, when we are discussing the scourge of crime and our inability to deal with crime, because of course the speed with which we are able to convict or release persons from custody or discharge them from appearing before the court has a direct impact on our ability to have rehabilitative processes implemented in relation to those who need it. It has a direct impact in our ability to keep the country safe when the right persons are in fact convicted. And when perhaps, because we have to respect the presumption of innocence and the rights of persons accused, you may, in some cases, have persons who are repeat offenders being out on bail whilst they await their day before the court, and that in itself is not conducive to a country that is run properly. It is not conducive to a country that has to tackle a scourge of crime. And so, therefore, we are committed to ensuring that the criminal justice system improves. At a high-level policy, I would say, we support any improvement to the speed with which the criminal justice system can operate. We do wish to see matters move through the system faster, both to protect the public at large, to seek the interests of victims as well as to balance that against the rights of accused persons. The statistics provided here today, where there are some 38,000 matters, close to 38,000 matters pending before the magistrates' court, the district courts as they are now called in Trinidad and Tobago, is certainly a state of affairs that needs to be addressed. Where I would part ways, perhaps, with the Attorney General is that I don't necessarily characterize what takes place in the pretrial phase as totally irrelevant, perhaps, and maybe there being prolix cross-examination and an abuse of pretrial processes. Because you see, if you understand correctly what happens at the preliminary inquiry stage, and I think it is important for us to compare what happens now with what will happen under this bill in order to understand its value and to properly, I think, analyze the concerns that we will raise here today. We have a very heavy reliance still on witness evidence. And that's a fact. In fact, when the DPP appeared before the Joint Select Committee on National Security quite recently, he made a point which he thought was quite unusual, that when he began prosecuting many, many years ago and started as a prosecutor, he actually had more cases coming before him where police officers asked for advice to charge, where there was fingerprint evidence and evidence that did not depend on the veracity of witnesses, as opposed to now where you have cases built entirely on eyewitness evidence or the veracity of a witness who may come forward and say something. And that is the reason why you have such prolonged cross-examination in many cases that I have seen at the preliminary inquiry stage. Because in many of those cases, it is quite possible to attack the veracity of the witness at the preliminary inquiry stage through cross-examination and have the case dismissed. And I would have liked today, because we don't have that information, but I would have liked to see or like to hear how many of these cases, and I agree with the Attorney General that many people stay perhaps incarcerated or have a charge pending over their head for sometimes up to 10 years. The well-known case dealing with the no bail for murder matter, Achille Charles. Achille Charles waited 9 years incarcerated without bail, only to be released at the end of a preliminary inquiry because there was not sufficient evidence to move forward to an indictable, to indict him for a murder. And that, when we deprive people of that time of their life, is of course undesirable and wholly, unjustifiable. But I would like to know how many matters after cross-examination, as the Attorney General describes as prolix cross-examination. I've seen some very extensive cross-examination at the preliminary inquiry stage, but it often results in a person not being ultimately indicted. So when you remove that cross-examination from the preliminary inquiry stage, when you are dealing with several cases and many cases, and the DPP himself has said a lot of the cases now hinge on eyewitness testimony or other types of testimony, but it's witnesses to give evidence, not so much on forensic evidence, scientific evidence, DNA, CCTV, etc. Cross-examination plays an important part in determining whether or not the prima facie case is made out, because it may very well be that you can pass the stage of saying on the documentary evidence and on the witness statements, you can actually cross this hurdle of sufficiency based on those statements alone, but without that evidence being tested, you may very well have cases that will collapse or may collapse when they get in front of a jury. So I raise that concern simply to say that what happens now in a preliminary inquiry is not totally irrelevant, and it's not totally, just a waste of time and so on. And although it does take a lot of time, it does serve a purpose in many cases, because it results in matters, in a lot of cases, not even reaching the High Court due to the insufficiency, unreliability, and just, simple collapse of a prosecution case under cross-examination at the stage of the preliminary inquiry. The other thing that I want to mention, because the Attorney General stated that this law will be proclaimed, and one of the reasons for that is because, of course, they would give a period of time for training and for the rolling out of all the administrative procedures and so on. I only hope that this piece of legislation doesn't find itself sitting next to other pieces of legislation that we have sat here, that we have debated extensively, and that we've spent a lot of time analyzing and commenting on and consulting on, that is yet to be proclaimed, that were touted, those pieces of legislation that were touted to bringing massive reform and overhaul of our criminal justice system. I would make mention of the Evidence Amendment Act 2020, which was assented to since February of 2021, but has not yet been proclaimed. When the former Attorney General brought that piece of legislation to this House, Mr. President, I remember saying that, you're trying to fly before you could even creep, and that there were so many other issues to be addressed in the criminal justice system and with policing, etc., that could assist with securing convictions, that could assist with having matters move more expeditiously through the courts. And they said, no, this will revolutionize, and it's the opposition that we don't support no crime fighting bill, we don't this with it. Well, we supported it. I believe we supported it in the other house and so on. And it is yet to be proclaimed today since 2021 being assented to. And I really do hope that we are not going to go down the same road with this piece of law that is, again, being touted as something that is going to, overhaul our criminal justice system, because we acknowledge, we all agree inside of here and everywhere, and I think everyone in the country agrees, that an overhaul is necessary and something has to be done. So we really do hope that before bringing legislation, that the government would have identified specifically what needs to be done, what has to be put in place, what are the training needs, who are the people that need to be trained, and what kind of staffing requirements they are going to need in order to get this piece of legislation operationalized. Because we cannot afford to delay and wait whilst we have what the government is saying is good legislation that will achieve a particular end, just sitting down waiting, and we don't know what is happening with it here today. If we are speaking about things that need to be done with urgency, then we expect that sense of urgency from the government when they are treating with it. Mr. President, when I want to comment on a few provisions of this piece of legislation, and the first thing is that, again, and this is why I spoke about the proclamation and waiting on proclamation and resourcing, is because everything in the criminal justice system, procedure is very important, and you have to follow procedures, but procedures require the people to get it done, and it requires resources. And without resources, you can bring the best law to do away with preliminary inquiries, to get past the lengthy pretrial procedures, to get past extensive cross-examination at the stage of the preliminary inquiry or sufficiency hearing or whatever it is. But you still require resources to get this done. If we look at what has to take place at the initial hearing under the amended Section 11, you do require the prosecution to do quite a lot. And the Attorney General mentioned that they are starting to interview persons for the position of State Counsel and so on. But it was not very long ago that the Director of Public Prosecutions basically said that, the entire system might collapse. And we have, again, through Joint Select Committees of Parliament, through questions being posed, and quite unusually through media interviews being done with persons who hold very high office in this country, we have identified a number of problems, human resource problems, within the office of the DPP. And unless we address those, because you will interview people today for State Counsel 1 or 2 or whatever it is, you will staff the office. You may have another, and I spoke about this in the budget debate last year, where the creation of a number of positions and expanded positions in the judiciary ended up sucking all of the most senior staff out of the office of the Director of Public Prosecutions. And even the expansion of the Public Defender's Department took a lot of resources out of the DPP, and they went there, and then you had the DPP's office basically operating with bare-bones staff. So if you interview today, and you don't have proper planning, you don't have proper restructuring, you don't have perhaps the allocation of a core human resource function within that office that could be responsive to the changes that they are seeing and the change in their needs and so on. Because, again, the director mentioned that when the criminal proceedings rules were introduced, that put a whole different spin on how things had to be done at that office. And I don't think that any proper analysis was done in terms of what the needs of that office would be when you make changes and how to be responsive to those needs. So that without a policy being adopted by the Ministry of the Attorney General, which is the line ministry for that particular department, which is critical to the criminal justice system. And again, the system has a number of moving parts to it. And you cannot improve different parts. So we cannot improve the courts and expect that with procedures being changed, such as through this bill, that those procedures will work smoothly if one inherent component of the system isn't operating well, because it has to all flow and operate together, and there's a interdependence of certain of all the different components in the system, and it will not work properly unless you do that. So resourcing is very important. Police officers who do prosecute matters, and many of the matters that come before the court, require training. That is something that we have been speaking about over and over again. A lot of the matters and a lot of the, I would say, a lot of the challenges posed at the district courts, and even when you go before the masters now, it stems from the fact that there are police officers who are in charge. It stems from the fact that the appearance of the complainant police officers who are in charge of preparing all of these things and getting it into the court so that the court can actually move forward with the matter, that simply isn't happening, and we are not seeing enough disciplinary action being taken. The point of the criminal proceedings rules, although it introduced a sort of a management and case management system for the criminal system, the way we have it on the civil side, it doesn't have the type of penalties attached to persons who do not comply with directions of the court. And the reason for that, and I raised that issue recently again when we had members of the administrative side of the judiciary before us, and the reason and the thinking behind it is because you do not want at the end of the day the victim to suffer as a result of perhaps a prosecutor or a defense attorney or a police officer not doing what they are supposed to do. But without sanctions in the criminal proceedings rules, we unfortunately have a dereliction of duty in many occasions, on all sides, whether it is the prosecution, the defense, police, whoever it may be. And until we address that dereliction of duty in a particular way and we take action to address it, again, these procedural things that have to take effect and have to work in our favor would not generally happen. So getting into the clauses of the bill, the first thing is that I see the introduction of appropriate adult. Appropriate adult was introduced into the Children's Act, and you have now introduced a role for an appropriate adult, which I believe is modeled on what we call PACE in the United Kingdom, because PACE, which is a very advanced version of what we have here as our judges' rules, deals with how police officers interact with suspects, persons when they are, or even witnesses, and how you take statements from them, how you interrogate them, etc. Now, introducing the appropriate adult, which will include, I think, social workers, welfare workers, a justice of the peace, attorney, or any other responsible person, and who the child or the minor is comfortable with, into this piece of legislation can, of course, assist the prosecution with ensuring, and this is the purpose of it in the United Kingdom, you want to ensure fairness, you want to ensure that when you get to the stage of a trial, that it is less likely that statements taken from a minor would be subject to, doubt in the minds of the judicial officer or the jury or whoever it is, because you had the appropriate adult being there to seek the interest of the child. Again, resourcing is one issue because you want in all cases to ensure that the appropriate adult is in fact available. I feel that we need to clarify the role of that appropriate adult, because I am not sure that right now, I've done what we used to call duty counsel. I don't know if it's still called that, duty counsel through the Legal Aid and Advisory Authority, where legal aid would be called upon to send an attorney to a police station once there's a child who is in custody. And so I've sat with a lot of children who have been arrested and brought into a police station to be questioned. And I've seen the social workers interact with them. And the first thing is that there are social workers who are present at the children's courts, at all of the children's courts now that are operational at Faizabad and Port of Spain and so on. But getting a social worker to come in to police station and treat with a child and so on. I don't know that we have enough of that available. I don't know that even if the police are aware of how to go about having accessing a trained social worker to come to the police station where there is an issue with the child, because the types of crimes involving children, where children are arrested and brought before a police officer to be interrogated and interviewed. I've seen everything ranging from murder, robbery, sexual offenses. They're very serious offenses. And a lot of those cases, you have circumstances which require the input of a very highly trained social worker. So we need to improve the access of those social workers, and we need to ensure that they understand their role if they are going to be brought into this procedure now and to be part of the procedure as appropriate adults, and introduce them into this system where an appropriate adult is to be is to play a role in the administration of justice and in this whole process of taking statements and so on and moving forward to expedite matters. The other thing I wanted to comment on, please, Mr. President, would be the issuing of a warrant and the amendments made here with a search warrant. I've taken note that there are provisions here where the master, and this would be the amended section 5, the power to issue the search warrant by a master. So the master has to be satisfied by proof on oath that there is reasonable ground for suspecting, and they are taking, and we go down the road there of issuing the warrant. And it's very similar to the normal law of issuing a warrant. But it says that they may at any time issue a warrant under his hand authorizing any constable or any person accompanying him. And then the section goes on, and I'm looking at the unofficial consolidation that was provided to us. It goes on to speak about, for the purpose of obtaining communications data, stored data, and so on. And these are types of data that can be obtained by a warrant under the Interception of Communications Act. So I'm very concerned about the possibility that the powers granted to a master in this particular provision to issue the warrant to intercept private communications is really quite a much lower standard than what pertains under the Interception of Communications Act. Because under Section 8 of the Interception of Communications Act, there is a very high standard. First, to begin with, under the Interception of Communications Act, only the authorized officer is allowed to go to a judge for a warrant in order to get that, to intercept private communications. And this is certainly a much lower standard because it is not an authorized officer. And an authorized officer in the Interception of Communications Act is defined very clearly as the Chief of Defense Staff, the Commissioner of Police, and I think and the Director of the SSE, the Director of the SSE. So those three persons can go to a judge. They can go ex parte, but they must go before the judge in order to get that warrant. Here you have a master who is beneath the level of a judge, being able to issue a warrant to any person, even a constable. So this to me is a watering down of the protections included in the Interception of Communications Act. It is very, I think it is troubling. I do not think that it is, at the end of the day, we are here to make laws for the peace, order, and good governance of Trinidad and Tobago. And when you have two pieces of legislation that could potentially be conflicting with each other in terms of the procedure and what you can obtain and how you can obtain it, and creating a new avenue through this piece of legislation whereby you can get around another existing piece of legislation, I don't think that really bodes well for good governance of Trinidad and Tobago. So if it is that there's some protection to be offered, or if it is that it will not be applicable to private communications, and that the Interception of Communications Act and the standards set therein is still to be applicable, then I would like some clarification on that. The second thing is that in this particular section, this Section 5, it doesn't go into detail about what are the grounds for intercepting private communications and stored data and so on. It just speaks to where the master is satisfied on proof on oath that they may issue the warrant, and that it is a much lower standard. In the Interception of Communications Act, the judge is not allowed to issue the warrant under Section 8.2 unless they are satisfied that it's in the interest of national security for the protection, detection of an offense where there are reasonable grounds for believing that such an offense has been, is being, or is about to be committed. The information obtained is likely to assist in investigations and so on. So I believe that the standards in interception of communication for even getting to the stage of obtaining that warrant are a bit higher than what pertains in this particular piece of legislation. And of course, when you are dealing with private communication, stored data and so on, you want the absolute highest standard because you are interfering with fundamental rights. You are interfering with the rights of freedom, and we should not be, for the sake of, I don't even know, because I don't even think that making this applicable here when you already have a law that governs the interception of communications in specific circumstances, that it is necessary to have it in this law. If the purpose of this law is to make, cases move faster through the court and abolish preliminary inquiries, I do not see a reason why we have to include the interception of private communications when warrants are to be issued by magistrates and so on, by masters, sorry. The normal procedure under the Interception of Communications Act should continue to pertain because they have been used and they are being used currently by law enforcement, and unless somebody can say or somebody can produce a reason why it is interception of communication and that particular standard is not working, then that has no place in this particular piece of legislation. The other point that I wanted some clarification on and I wanted to raise is the issue of the sufficiency hearing after an indictment is filed. And I know that the Attorney General made mention of the saying that it interferes with the DPP's powers and so on. And yes, the DPP will continue to have the power to withdraw or amend the indictment and all of that. Let's talk about how it works right now. Right now, the prosecution, 99% of the time through the police, come before the magistrate. And they say, this is the evidence we have. These are the witness statements. Because we have paper committals, we don't always call the witnesses. You can file. You don't have to take evidence in chief. You just bring your witness statements. You can file them. And then the defense attorney has an opportunity to select which witnesses they want to cross-examine. This was actually a quite remarkable improvement from what pertained before. When I first started as a prosecutor in 2006, we used to have to lead all the evidence viva voce in a preliminary inquiry. I've had to lead evidence of people who saw the body, found it, called the police. Then I had to lead the evidence of the person who drove the ambulance because the man was wounded and he died en route. When all of these things, really, nobody was disputing that the man was dead. We had to call the DMO to say that I came, I saw the body, and I pronounced the man dead. No longer we do all of that. We file the statements, you select who you want to cross-examine. At the end of the cross-examination, you can make submissions, etc., and the magistrate will then determine whether there is prima facie evidence and commit the person to stand trial. And the DPP, upon reviewing all of the evidence, together with the cross-examination that takes place in the preliminary inquiry, will file the indictment, and he doesn't necessarily have to indict only on the charges that were initially brought by the police, but any charge that may be brought out. So I have actually worked on matters where, for example, someone is charged with wounding with intent, and the police would prosecute the matter. And by the time we get the bundle of proceedings from the magistrate's court and we look through it and we get advice and you consult with the DPP would say, no, this is an attempted murder, because he believes that it's a much higher, the way, all the peculiarities of the matter would lead to that particular conclusion. In sexual offense cases, you may have a number of other charges that would be included on the indictment because of the nature of what transpires and what is said in the viva voce evidence that comes out in the magistrate's court. So what we're going to have now, though, when you have at the initial hearing, and what the Attorney General thinks that it's a great improvement that the indictment will be filed at the beginning of the process, and the DPP will be directed and he will be given dates and so on at the initial hearing to file the indictment. Then the indictment, which is the sole purview of the DPP now, who reads all of the evidence, who reads the witness statements, who reviews the forensic evidence and the analysis reports and all of that, he determines what charges he believes should be on the indictment. So after he is completed with that process, you are now subjecting his discretion to bring these particular charges on the indictment to a sufficiency hearing, which kind of is the same thing, except that you're hoping without cross-examination and so on that it will move quicker, and because you're setting timelines. But you will still have a complete examination of all of the evidence. Now, I'll tell you a couple of challenges with this. And again, I refer to when the DPP himself appeared before the JSC recently, and I hope everybody had a chance to listen to that, because it identified a number of challenges that you were going to face. In the preliminary inquiry currently right now, in the majority of cases, you do not have the forensic reports. What you have is a police officer saying, for example, we took the victim to the hospital, we got, this sample, swabs, etc., and it has been submitted, and they will produce a receipt showing that it's submitted to the Forensic Science Center. We don't have it at the time of the preliminary inquiry in many of those cases. It is only when the DPP, the entire bundle of committal proceedings, gets to the DPP's office, and he's in possession of all the witness statements, and he gets the final forensics report, that he can properly analyze it. Because you know something, sometimes in a particular case, dealing with a firearm or something like that, the forensic report might come back and say something else, which will change what the indictment will be. You may have to withdraw the entire thing. You may have to amend, what you want to charge the person with. You may add additional charges. Those forensic reports play a very important point. So for the DPP to proffer the indictment at the beginning of the proceedings, for one, may pose a challenge if we don't have all those other things coming, faster and so on for him to be able to make a decision. And then you're going to subject the indictment to a sufficiency hearing. A sufficiency hearing in this case may very well turn out to be just like a preliminary inquiry, minus, I guess, cross-examination. But if you can examine all of the documentary evidence, will the documentary evidence be available? Because that's part of the challenge you have, and that's part of the delay. And the DPP himself identified that as one of the delays, and for the reasons, and people have been attempting to file judicial review and so on. Of course, the court ruled that they couldn't do it, but in most cases, attempting to file judicial review matters to say that the delay in filing the indictment between the committal by a magistrate and the DPP filing the indictment violate their rights. But what is going to happen now? How is the DPP to proffer an indictment when he's not in possession of all the information at the beginning of the trial that would normally inform his decision? And then, what purpose will the sufficiency hearing serve when you start it immediately after or within 28 days and so on? If you don't have all the information to really determine, you're going to come to the same conclusion of having a prima facie case. And if the information becomes available later on at the trial, it may very well be that the trial may collapse. It may be that you need to amend the indictment and so on. And so it could be a very untidy process. So I don't know why, if the DPP goes straight towards filing an indictment and we want to move away from preliminary inquiries for indictable offenses, if it is necessary to subject the indictment filed by the DPP to a sufficiency hearing. And I gather that the thinking behind it is you still want to ensure you have a prima facie case. But if you're giving the DPP the discretion, and it is his sole discretion to file an indictment, then he should be satisfied that there is a prima facie case that could move straight into the High Court. So what is the purpose of coming back now to go through that sufficiency hearing? I'm concerned about that, because I'm concerned that you will now have a master questioning his decision to have that indictment filed. The Criminal Procedure Act, which deals with the filing of indictments and so on, it says at Section 13, every indictment shall contain and shall be sufficient if it contains a statement of a specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the charge. So, and it says, notwithstanding any law, any rule or law of practice, an indictment shall, subject to this act, not be open to objection in respect of its form or contents if it is framed in accordance with the rules under this act. But that's exactly what we're going to do now when we have a sufficiency hearing. because the master who is at a sufficiency hearing will essentially be objecting. So I don't know if we've considered whether amendments to the Criminal Procedure Act will be necessary now, if you are going to subject the indictment of the DPP to review by a master coming after the filing of the indictment. It may be a much tidier process to have a sufficiency hearing within the specified time. I have no problem with 28 days and so on once it can get done, I hope, with the proper resources. But that, direction at the end of that sufficiency hearing, once the master is satisfied that that they've crossed the threshold of prima facie, that a direction be given at the end of the sufficiency hearing that the indictment be filed within a specified time, like 28 days or so on. But to file the indictment up front and then subject it to a sufficiency hearing, I can't see the logic, the reasoning, or sense behind that. And I do believe that there may be a conflict between that and what it says in the Criminal Procedure Act. So I would flag that again for the consideration of the Attorney General. And Mr. President, I just want to say that we may sound like broken records and people will complain and so on about us, but this is why sometimes we ask for these bills to be sent to a joint select committee. Because you see, listening to the list of people who would have commented on this bill and sent comments does nothing for anybody outside of the government, because we don't know what they say. We didn't get a chance to ask the DPP what's his view. He may very well disagree with me and say, well, no. And being the person who, that he is, he may very well give me a very long explanation as to why he believes it could work. But we ought to have that opportunity. And when you are bringing major changes to the criminal justice system and something like this that affects the rights of accused persons, victims, and so on, we want to make sure we get it right. And the process of consultation is not a process that belongs solely to the remit of the government. If you are asking the Parliament and all parliamentarians whose job it is to sit here and make law with you, instead of complaining every day that we do not support you and every opportunity, because sometimes I feel like they try to create opportunities to complain about us. So they want to create an opportunity to complain and say the opposition didn't support us on this and the opposition. If you give the opposition the opportunity to sit and interrogate the stakeholders in some of these pieces of legislation, then we may very well be able to be more supportive and have less comments to make on it and criticism when we get to this stage, because we would have been partners in the process. So the government needs to decide if it is they want us to be partners in the process with them and allow us the opportunity to interrogate these things, and the avenue for doing so exists through joint select committees or special select committees of the Parliament, and it can be done. So this whole concept of the conflict between the Criminal Procedure Act, the indictments, and when they are filed, and whether or not an indictment should be subject to a sufficiency hearing, was something that could have been very properly interrogated if we had wider parliamentary consultation with stakeholders on this particular bill. Mr. President, let me move on now to the issue of the what we call the election of a summary matter. Right, summary for what we call either way offenses. The amended section 12 of this bill will now mean that the DPP or a person acting under his instructions will inform the master that a case is to be dealt with summarily. This ties in with our debate that we have ongoing in this House about trial by judge alone or judge and jury. When you have a matter that is tried either way, it is very rare. It is quite rare. And I would say this, it is very, very rare.
Senator, you have 5 more minutes.
Sure. But the election is put to a person. When the recommendation comes from the prosecution, the defendant is permitted to elect whether he would like to have his matter tried summarily before the magistrate or master or district judge or whatever you call them now, or whether he wants to take his chances in the High Court before, as it still is right now, a judge and a jury. And this bill is essentially removing that election, because it is saying that the DPP will decide, I want to go summarily. And as rare as it might be that someone will say, no, I don't want to come and have my case finished here before a magistrate alone. I want you to say whether or not it's sufficient and let them file the indictment and take me to the High Court before a judge and jury. That is still the right of the accused, and the accused should be allowed. And I do not agree I really do not agree that the prosecution alone should be allowed to determine whether or not and how this matter should be tried. Who determines your guilt and innocence is still something, although there is no right within our Constitution, you still have a right to a fair trial. And part of that fairness of the trial is the fairness of the procedure. And if it is that there is a charge and you are charged with something which can be tried either way, I believe that the accused, they enjoy it now, and it is not something that we should just take away willy-nilly, but we should permit the accused to still have that opportunity, because some people still want to take their chance before a judge or before a jury and do not want to just have their matter determined before a magistrate at the district court. And there could be a multiplicity of reasons for that, please, Mr. President. And so this particular aspect of it, the amended Section 12, which gives the prosecution the sole discretion to determine where an either way offense ought to be heard, interferes with that right of the accused, something that currently an accused person enjoys when it comes to these types of offenses. And as rare as it may be, I believe that it ought to be preserved in this piece of legislation, and a simple amendment where the DPP can make the recommendation, and instead the master shall put the election to the accused person and then forthwith order that it be transferred once the person elects and agrees with the prosecution's recommendation, or they could keep it before the court and go through the sufficiency hearing and so on and then get to a trial. I understand the need and the desire, and I agree with it in principle that we want to move matters through the court as quickly as possible. But in any time you are dealing with persons' rights, when they are charged with a criminal offense, or the rights of a victim, because as I mentioned before, and I spoke a lot about the rights of even a victim when they choose the place of trial and how that trial is conducted and who is the forum that is going to determine guilt and innocence. You don't only talk about the accused, you also talk about the victim. And it may very well be that in some cases the prosecution, in a case like this, the prosecution may consider the rights of the victim, but what about the accused? The accused still has those rights, and the balancing of all rights in order to get this thing correct is very important. And so when we are, as much as this bill deals to a large extent with procedure, if we don't get the procedure right, none of it will get right. And if we don't get the resourcing to move that procedure forward right, then it will come to naught. And as I said before, I really hope that this piece of legislation will be carefully considered, carefully implemented. The right amount of training and resourcing will be made available for those who have to do it so that we get it right and that it can improve the administration of justice in Trinidad and Tobago, which is what we all want at the end of the day. I thank you.
Senator Thompson, aye.
Mr. President, I thank you for the opportunity to speak on the Administration of Justice Indictable Proceedings Amendment Bill 2023. This bill seeks to amend the Administration of Justice Indictable Proceedings Act 2011 to provide for the abolition of preliminary inquiries and for the conduct of initial and sufficiency hearings by a master of the High Court. Disappointed, dejected, depressed, disconsolate, despondent, and downhearted, I walked out of the Tenapuna Magistrates Court one day. It was my first and my last preliminary inquiry. I had been representing a 17-year-old boy who had been charged with murder. The victim was the son of a police officer. My case was based on self-defense. After I made my no-case submission, the experienced prosecutor from the office of the DPP, in the finest traditions of the bar, had said to the presiding magistrate that she agreed with my submission, that the prosecution had not negative self-defense. The magistrate, nevertheless, decided the case must go to the High Court. On my return to my office, my secretary looked at me and realized things had not gone well. She knew I would talk when I was good and ready, but needed space. Soon after I sat at my desk, the phone rang. She entered my office and said, "Mrs. A, you have to take this call." The person sounding really distressed and insists he must talk to you. Reluctantly, I took the call. The caller was incoherent. I gathered he was a police officer from the Tenapuna court. His words made no sense to me. I tried to calm him, but he kept repeating, "I see my gratuity and my pension running up St. Vincent Street." Was he mad? He was one of the cadre of police officers in the Tenapuna and Arima court who thought I was there to assist them with all their personal and professional problems. I kept referring them to Dr. Bontel, but they wanted to talk to me. Finally, I was able to put the pieces together. He had had the charge of my client until his return to prison. Feeling sorry for the youth and knowing he was my client, he decided to take the boy for a drink to cheer him up. I trust it was a non-alcoholic drink. My client decided to make a run for it, hence the officer's cry about his gratuity and pension running up St. Vincent Street because he could have lost everything. Luckily, the policeman was able to catch him. I told him what I thought of his actions, and I promised to talk to my client. The next day, I visited my client in prison and scolded him. He said he was sorry. He did not mean to put the police in trouble, but he knew it would be a long time before his court case would be called in the High Court. Each time he came to court, he said his little nephews and nieces would line up outside on the pavement by the court to wave to him and call out, "Uncle, uncle." He knew he would be caught, but he wanted to get another charge to start back coming to court every 8 days so he could see his family who could not visit him in prison. This case illustrates his understanding that it takes years after a preliminary inquiry for a case to come to trial. So he was willing to risk everything. It in fact took 3 years. And it also illustrates that juveniles do not think of long-term consequences, but think in the now. And that is why our stubborn stance in refusing to increase the age of criminal responsibility from age 7 is so tragically wrong. In case you're wondering what happened to my client, he was acquitted by a jury in one of the speediest verdicts in history. I also learned that some police officers are very honest, as the evidence of the victim's father and mother was crucial in this case. 2 years ago, he visited my office. I did not recognize him. He told me he was now 50 years old, had returned from abroad, and had been trying to find me. His case is one I will never forget. I recall the head of the community police saying to me, "I'm ashamed of my police officers. Your law students did more work than my police officers to gather evidence for this case." This bill, seeking as it does to abolish preliminary inquiries, is timely and of great importance, especially to youths who wait years for their matters to be heard. In this regard, I recall a teenager who had been charged with a sexual offense. In the intervening years, 6 years, between the PI and the trial, he had been out on bail. He was living an exemplary life. He was married with children and had a good job. He was sentenced to a term of imprisonment. His case evoked a great deal of negative comments on delays in our court system. The reduction and abolition of preliminary inquiries, or as is sometimes called committal hearings, is not a Trinidad and Tobago initiative, but a worldwide movement. Governments, the judiciary, and ordinary citizens agonize over delays in the criminal justice system. The lengthy trials, the protection of vulnerable witnesses, costs, and other concerns, and this has prompted movement towards the judicial case management models, sufficiency hearings, change of venue orders, remote appearances and disclosure, which are viewed as more efficient and effective methods of moving along the wheels of justice. Review of legislation in countries as disparate as Canada, United Kingdom, Australia, Switzerland, Germany, Portugal, and others, and in the Caribbean, Jamaica, Guyana, the Bahamas, and Barbados, reveal an onward march towards abolition of preliminary inquiries. In the interpretation clause, clause 3 of the bill, I have two queries. The first is a definition of appropriate adult. The bill states appropriate adult has the meaning assigned in the Section 3 of the Children Act. I could find no definition of appropriate adult in Section 3 of the Children Act or the Children's Authority Bill, but I did see it in the definition section of the Children Court Rules 2018. Is it that there is and also the Evidence Amendment Act. So is it that there was an amendment to the Children Act or some other act where there's a consequential amendment? Please clarify. But to say clause 3 of the bill and then you can't find it there, at least is puzzling. The second definition is that I have a problem with the definition of prison. Why would you include rehabilitation center under the definition of prison when the international instruments say a child should not be sentenced to prison? To save typing a few more words? For the want of a shoe, a horse was lost. So let us not do that. With regard to prosecutors, in the definition section, why are we including police prosecutors? Have we not abandoned their use? There has been talk about that for quite a while. What is the status? I am particularly pleased with clause 5.3 regarding seizure of items during a search warrant and the requirement for a signed report signed by both the warrant officer and the owner. This will eliminate some of the complaints repeatedly made over the years of items going missing while in police custody and disparity between what was reportedly seized and what the householder claims was in fact taken. Clause 619 speaks to complaints in respect of an accused who is a child. It states that a complaint shall be made to a judge, and if the judge determines that the matter is to be dealt with indictably, the matter shall be assigned to a master to be dealt with in accordance with this act. Mr. President, what guides the master in his or her dealing with a child's matter at this stage? There are no principles in law or practice in this area of the bill which makes me feel confident in that it tells me that the person determining the matter is cognizant of and acting under child justice principles. Compare this with clause 21, which I refer to later as containing the desirable provisions. I would have been happy, though, to see something like section 4 of the Guyana Child Justice Act 2018, which reads, that's section 4. It shall be presumed that no child under the age of 14 shall be capable of or guilty of committing an offense. Where a child is charged, the Director of Public Prosecutions, the prosecutor, or the attorney at law representing the child shall request of the court that an evaluation of the child be done, and the court shall order that the evaluation be conducted by a suitably qualified person at the expense of the state. Where an order has been made by the court under subsection 2, the person identified to conduct an evaluation of the child shall furnish the court with a written report of the evaluation within 30 days of the date of the order. The evaluation shall include an assessment of the cognitive, emotional, psychological, and social development of the child. The person who conducts the evaluation may be called to attend the court proceedings and to give evidence, and if called, shall be remunerated by the state. If the presumption is rebutted, the child shall be treated as a juvenile and dealt with in accordance with the provisions of this act. If the presumption is not rebutted, the court shall refer the child to the Director of the Child Care and Protection Agency to be dealt with under the Protection of Children Act, and the Director of Public Prosecution shall withdraw the charge. There is some hope, though, in clause 10A, which gives the Children Court jurisdiction to deal with children matters, especially 10B, which provides for programs for children, and I know that there are many programs in the Children Court. But there's little to give me comfort in the fact that in children charge matters, account is taken of the Doley Incapax rule by either the presiding officer or the person conducting the assessment doesn't seem to be taken. Jamaica Committal Proceedings Act specifically requires that the assessment of the child by a person who is considered qualified is to determine whether the child, who is duly incapacitated, that means incapable of crime, in Jamaica's case between 12 and 14 years, understands the nature of the oath, and if the child does not understand the nature of the oath, whether he possesses sufficient intelligence to justify the reception of the evidence and understands the duty of telling the truth. When, however, one comes to clause 21.3 and 3A, we see that child witnesses are well protected in our law, with safeguards for assessment of competence that I would wish to see extended also to child offenders. Clause 24, which provides for an appeal by the Director of Public Prosecution in cases of discharge of an accused by a master, is an important safeguard in the law of which I approve. The timelines in the bill which the Attorney General spoke of a while ago will certainly help to move the process forward. John Johnson, Deputy Commissioner of the Australian Federal Police, Australian Capital Territory, wrote a paper, A Case for Abolition. And in that paper, he quotes a study, if I may, by PricewaterhouseCoopers that revealed that estimates of the cost savings in having a guilty plea taken early in proceedings showed committal proceedings were financially beneficial. The study said the figures did not even take into consideration the Crown's preparation costs, the accused financial costs, or the emotional costs arising from a late guilty plea. I can see some criminal law attorneys here bemoaning the loss of fees. In that same paper, some of the effects of longer trial waiting lists that he quoted were deterioration of evidence, memories fade, prolonged stress on victims of crime, unnecessary stress on the accused, reduction in deterrent effects of the justice system, leniency in sentences, that is delays included in penalty, inconvenience to witnesses, loss of respect for the justice system by society, and tendency to rely more on plea bargaining. And you know, the effect of delays on the penalty is something that I have been watching in this jurisdiction, especially in sex offenders' cases. And we have to be very careful about the messages that we are sending to victims, in particular, the victims of domestic violence. All in all, this bill seems to be on the right track as far as international standards are concerned. It has brought us into the 21st century thinking about improvement of our justice system. So once this bill is passed, it's no longer open to the accused to reserve his plea as at a preliminary inquiry. It will certainly change the way matters are conducted in our criminal courts. It remains to be seen, though, as some naysayers have predicted, if it will change, if it is changed or exchanged, if the backlog, in fact, will be transferred from one arena to the next. I thank you, Mr. President.
Minister in the Office of the Attorney General.
Mr. President, I thank you most sincerely to jump into this debate. Of course, joining in with the Attorney General and echoing how critical, how important this legislation is in improving the criminal justice system. Mr. President, of course, I have to use the opportunity in my contribution, or part of my contribution will be to, of course, address certain comments and questions, and more so comments and statements that were placed on the record by Senator Lakshmi Dayal, and then, of course, try to address certain questions asked by Senator Thompson-I, and that's the place I will begin. before I jump into the crux of my contribution. I believe this is the best place to start because, of course, the AG would have given us a great, he would have done an excellent delivery in his piloting by going through the length and breadth of the legislation, and more so I appreciated that he focused on the clauses in the bill that seeks to really bring about a radical reform in the criminal justice system. Now, Mr. President, I would have to say, most respectfully, today in preparing to answer to some of the comments made by Senator Lakshmi Dayal was indeed quite easy. And the reason for that is because I'm not sure if her learned friend in the House of Representatives, I'm not sure who prepared whose speech, because the exact questions, it was a copy and paste, unfortunately, for the opposition, but fortunately for me, in preparing for this debate, because the exact questions and concerns that were raised by Senator Hussain in the House of Representatives, it was simply echoed through Senator Lakshmi Dayal. So, as I said, I'm not sure if it's one speechwriter who writes in whose speech, if it's a copy and paste that takes place on that side, but it certainly, Mr. President, makes it easier for us on the government bench in preparing for this debate, because we always can foresee what questions and what concerns they are going to raise. And of course, that being said, Mr. President, there are 6 issues that I will seek, 6 concerns that were raised by the Senator that was also raised in another place, which I would attempt to rectify and add my 2 pence to. And I'm sure, of course, the Attorney General in his winding up will deal with other issues, and of course, other members of this government bench, as they jump in, they will deal with those issues as they come up. One of the issues, and I want to jump into that issue first, is that because, of course, learned Senator Thompson-Ai would have raised that question. She would have asked the question. The comment was made on not seeing the definition for appropriate adult in the Children's Act. The Act was amended, Mr. President, by Act number 15 of 2018. And by virtue of Section 10, it amended Section 3 of the Children's Act to insert the definition of appropriate adult. So I just wanted to, mention that for the benefit of Senator Thompson-Ai. And go a little further, because Senator Lakshmi Dayal, in her contribution, also raised the issue and her concern of the term appropriate adult. And as I would have alluded to earlier, Mr. President, by virtue of Section 10, it amended Section 3 of the Children's Act to insert a definition. And for the purpose of the record, Mr. President, what I can say is that pursuant to the appropriate adult, is used in Section 3 of the Children's Act, and for the purpose of the record, for us to understand that there is clarity relative to this definition that already exists in the Children's Act, I will read into the record what it has been defined as, or what it is defined as in Section 3 of the Children's Act. And it means a person 18 years of age and over who is a social worker, welfare officer, justice of the peace, an attorney at law, any other reasonable responsible person with whom the child is comfortable, or there's also F, in the case of a person with a disability, the appropriate professional, but does not include G, an accomplice. And then we have H, a person not being a parent with previous convictions relating to a child or affecting that child within the last 10 years. Then we have I, a person not being a parent on probation. J, a person of the police service or any employee in the police service other than I, a family member, and then, 1, and then we have 2, a person who is well known to the child, 3, a person with whom the child is comfortable, and then that entire section, while Section 3, I'm reading it into the record, Mr. President, because the term appropriate adult for the purpose of the record is clearly and properly defined in the Children's Act, and what we would have done in this particular legislation, Mr. President, we would have simply transposed that definition into the bill that appears before the Senate today. So, for the benefit of course, Senator Thompson-Ai, and of course, for the benefit of the statement made by Senator Lakshmi Dayal, of course.
for amending the laws online. I have said in this Parliament more than once that researching the laws of Trinidad and Tobago is a researcher's nightmare. We have people all over the world who are checking laws, and you can go to other jurisdictions and you can see updates in the law. What is wrong? Is there nobody with that responsibility in Trinidad and Tobago?
If I may respond, of course, there are persons with a responsibility, but of course, Senator, you know, sometimes there's a real challenge in micromanaging persons with certain responsibilities, but I'm sure, and ensuring that they do what they ought to do. And that certainly, personally, I can apologize for that trauma that you would face, and of course, colleagues at the bench may face in doing their research. And hence the reason, Honorable Senator, I saw it was necessary just for your benefit, of course, to identify the piece of law that would have brought that necessary amendment. And I'm sure, given the modus operandi of the AG, who currently serves, I know he will go back to the office, and I will equally do my part, Senator, to ensure that the needful is done, so that at least we can assist, researchers like yourself, and of course the wider Trinidad and Tobago, in locating the necessary legislation when researching. But I do hope that the bit that I would have provided can now just respectfully guide you to where the amendments do exist. And just to continue, Mr. President, of course, the appropriate adult has been adequately dealt with in the Children's Act, and what we have done in this legislation is simply transpose that definition here. So that was one of the queries, of course, that was raised by Senator Thompson-Aye, and it was also an issue that was raised by Senator Lakshmi Dayal in her contribution. If I may go on to another point made by Senator Lakshmi Dayal, Mr. President, Senator Lakshmi Dayal stated that the criminal justice system is a topic of grave concern, which I agree with the Senator. She also said it's a topic that continuously rears its head, but then went on to speak about not agreeing with the Attorney General about the necessity to have cross-examination and lengthy cross-examination at a preliminary inquiry stage. If I may, I don't want to misquote the Senator, and these were the verbatim notes that I took. Senator Lakshmi Dayal stated that she didn't necessarily characterize what takes place in each pre-trial place as totally irrelevant. She spoke of there being a prolix of cross-examination and an abuse of pre-trial processes, and that at a PI stage we have a heavy reliance still on witness evidence. Mr. President, considering the purport and the intention of this bill, which is to inter alia improve the efficiency of the criminal justice system, respectfully, Mr. President, Senator Lakshmi Dayal's argument holds absolutely no weight. And I will say that because we are here to retain cross-examination, Mr. President, at the level of, we are here at the PI stage, it would continue. If we are here to continue cross-examination at the PI stage, respectfully, I place on the record, Mr. President, that it will to a great extent stifle the rate in which we are able to move these matters through the system. And, just from my very personal experience, Mr. President, and also in the benefit and the interest of the accused persons that appear before the courts, the AG, of course, in his piloting would have spoken when he dealt with the issue of cross-examination, particularly at the PI stage. Something came to my mind immediately. Yes, a PI, in essence, is a pre-trial, the trial before the trial on the indictment. And, there's one very reason why the accused person spends an exorbitant amount of money in hiring the best counsel that they could possibly find to represent them at the PI stage. And this is not the trial. This is just to determine if you have a trial to answer to. It's because of the issue of cross-examination. And the reason for that is because, Mr. President, if you have bad cross-examination taking place at the stage of the PI, what you have is the accused is now locked into that evidence, and there is no way of getting out of that evidence, that bad cross that he's locked into at a PI stage. And then he's committed, and this is what goes on to the High Court. This is what goes on, to the trial stage. And personally, in instructing Mrs. Elder on certain matters, I have seen where not even senior being creme de la creme in criminal law, based on what happened at the PI stage, it was absolutely difficult to try to even present a decent case for your accused person when the matter on the indictment was actually heard. And that is just something, at least in the interest of the accused as well, Mr. President, that I personally, when the AG would have spoken in his piloting, would have mentioned and spoken about cross-examination that take place at the preliminary inquiry stage. I can say, adding my own little 2 pence, that I believe that sometimes that botched cross at the PI stage, it actually negatively impacts on the accused person when they actually now have to answer, when they are committed and there's now a trial on the indictment. And as a consequence of that, Mr. President, from just that very personal experience and that personal place, I believe beyond just the whole argument of, not having lengthy cross and the system moving through the system quicker, beyond that argument, which of course is one of the fundamental reasons why we want to abolish these preliminary inquiries, I believe in the interest of the accused as well, Mr. President, by not opening a window for him to have botched cross-examinations. And of course, he's committed, and then he has a fairer chance, of course, at the trial of the indictment to be able to lead his evidence and, of course, to be able to lead his case. And I just wanted, just based on my experience, Mr. President, to put that on the record. Now, Senator Lakshmi Dayal, Mr. President, spoke about her concerns. She raised her concerns on the proclamation clause that exists in this particular piece of legislation. And of course, mentioned, in talking about the proclamation, the Senator would have spoken about, in essence, she's hoping that we don't wait too long before the bill is proclaimed. And in her contribution, she would have spoken about the issue of resourcing, and she mentioned, I know for sure, I took note of that, the issue of staffing requirements in order for for this bill to be able for us to breathe life into this bill. Mr. President, just for the purpose of the record again, I know on the judiciary's website, for example, in my preparation for this bill, I would have seen that the judiciary stated that currently there's an audit of 19 masters of the court, and it's public information that is available on the judiciary's website. But what I was even particularly pleased with is that I came across an advertisement that was placed on the website as well, where the judiciary has already started advertising for positions of masters. And that, to me, it shows that the judiciary has already been proactive and steps are already being taken to ensure that their current complement and their current audit of masters will be filled by the time that proclamation comes along. Mr. President, I want to also say that the issue of, staffing at the judiciary, the issue of the DPP, what has to happen at the DPP, most respectfully, I want to state that ought not to be a stumbling block in the passage of this bill today. The judiciary and the GLSC, of course, they have their which, as I said, I'm proud. I want to applaud the judiciary in particular, because I saw that advertisement that is already out, where they are recruiting masters, and there's the whole job the whole advertisement that speaks to the salary, the terms, the conditions, the requirements. I want to say, so I am pleased that has already taken place, and it's in stream, I believe, and I'm not doing PR for the judiciary, but I think applications close by, I think, the 3rd of July. So I'm hoping that the persons who are qualified and who wish to serve as masters, can go onto the judiciary website and, probably offer themselves to serve this country and, of course, the judiciary at that level. But what I wanted to say is that even though staffing is a real issue, whether it's at the DPP, whether it's at the judiciary, certainly that's not a reason why, or that ought not to be a stumbling block in the passage of this bill today. As a matter of fact, Mr. President, I had the benefit to sit at the LRC with our learned Attorney General. And that is in my substantive presentation, but as I raise the issue of the AG, I want to applaud the Attorney General. I have to commend the Attorney General, because the Attorney General came in at our new Attorney General. I sat at those LRCs and I saw his interest, his intent, his focus on delivering and ensuring that this bill, I saw the care and diligence that was applied by our current Attorney General in those consultations that took place with the judiciary and other stakeholders. Mind you, and the AG wouldn't say it, but I will say it because, of course, of the technology. We had LRCs sometimes that went into 8, 9, into the night, and the AG is there with all the energy, all of the enthusiasm with our stakeholders trying to make this thing right. And I have to use the opportunity again to applaud the AG and congratulate him for the work that he has done since he has come into the ministry, and more so for what the bill that currently appears before us. Mr. President, you know, the judiciary, and why I'm saying that is because in having the benefit of sitting in those LRCs, with, of course, I must recognize the chairman of the LRC as well, Minister Al-Rawi, and our AG, I understand fully that from the get-go, the judiciary supports this bill, and I have every confidence, Mr. President, that as it relates to staffing issues, that the judiciary is competent and they are able to manage their affairs, and they, of course, will work with the JLSC and the necessary entities to ensure that once this bill is proclaimed, that they are running on pure gas and on full cylinders, and therefore we can really see this system being operationalized and bringing forward the changes that I know both the judiciary and, of course, the government is looking forward to once we breathe that necessary life into a JIPA. And I just wanted to place that on the record as it relates to the issue of staffing raised by Senator Lakshmi Dayal. Of course, the AG would have already spoken in detail about his work and his continuous work and efforts with the Office of the Director of Public Prosecution. And I may sound utopic and I may sound optimistic, but you know what, Mr. President, in the times that you need leaders like myself who believe that there is hope and there is abundance in Trinidad and Tobago, just as every member of this government believes in. And I have every confidence that with the continued work of the Attorney General, his team that he has assembled, a very competent team that he has assembled to work with him in resolving whatever outstanding issues that may exist in the Office of the Director of Public Prosecution, I believe with that continued dialogue that we will be able in short order, Mr. President, to see the reformation and the improvements being brought to the Office of the Director of Public Prosecution, an officer whom I have the world of respect to, and I've always said that to the DPP's face, even behind his back, and I am sure that in short order, as I said before, those changes will be brought that will improve the complement and the issues that exist there. All that being said, Mr. President, I want to allay the fears of the general public as it relates to whether or not the proclamation clause is just going to be used as another stumbling block or another block to derail us from proclaiming a JIPA. I have every confidence that upon the passage of this bill, because systems are already in place, both in the Office of the Director of Public Prosecution, both at the judiciary stage, and certainly from the Office of the Attorney General stage, I have every confidence that this proclamation clause is not going to be used to further derail the bill. However, what it will be used, as all proclamation clauses are used for, it gives the additional little time that may be required for those who have not fully put their houses in order to put things in place so that once it is proclaimed, we can be able to see those changes. Mr. President, I now want to turn to the issue on the search warrants raised by Senator Lakshmi Dayal. And again, it is a copy and paste, unfortunately, from statements made, that I would have seen on the Hansard of in another place by MP Hussain. And Mr. President, like her colleague in the other place, the question was raised on the issue of search warrants. It was stated that the law now allows for a master of a high court to have jurisdiction under IOCA. Again, Mr. President, for the purpose of clarifying the record, the distinction here is made between an intercept warrant pursuant to Section 6 and 8 of IOCA. And I strongly suggest both her colleague in the other place and the senator, perhaps they would want to go back to the IOCA legislation and would want to pay particular attention to Section 6 and Section 8, and you will see the distinction that is made in the legislation between what we are speaking, the search warrants we are speaking about here, as opposed to the intercept warrant that IOCA deals with. So I wanted to place that on the record as it relates to the law. Mr. President, I also want to say that the search warrants that we're speaking about here is distinct distinctly different, all right? The IOCA, sorry, the intercept warrant is distinctly different to a search warrant, wherein stored, and I want to read it from the legislation, wherein stored communications, stored data, and communications data are required. These are currently issued under Section 5, Mr. President, of the Preliminary Inquiry Act and are obtainable by a police constable. So I had to make the distinction because they are tying up themselves when they talk about search warrant, Mr. President, respectfully. But what IOCA deals with is distinct and separate and apart from what is being dealt with under this piece of legislation. And I felt that there was a need for me to rectify and clarify the record as it relates to that. Mr. President, like her colleague in the other place as well, Senator Lakshmi Dayal Rekho, off the bat, verbatim stated, just like her colleague, this threshold for getting a search warrant is too low. It was, again, a copy and paste. To deal with that issue of the threshold being too low, Mr. President, again, I have to revert to the law as it relates to search warrants. Mr. President, the standard is the same. The standard for obtaining these search warrants is the same throughout other pieces of legislation in Trinidad and Tobago, Mr. President. As a matter of fact, this is the threshold which is currently upheld by the Criminal Procedure Act. And I see a criminal practitioner here who's representing the Senate, the opposition today. I'm sure Ms. Bisram is familiar with Section 37 as well of the Summary Courts Act. And as a practitioner of the criminal law, and again, I'm referring respectfully through you, Senator, that Senator Lakshmi Dayal and her friend in the other place, they go to the law again, go to Section 37 of the Summary Courts Act, and Section 37(1) in particular says the information is given on oath to a magistrate or a justice that there is reasonable cause for suspecting that, and of course it goes on to speak to in obtaining a warrant. So what we have is in Section 37 of the Summary Courts Act speaks to the same standard that they believe is low in this legislation, Mr. President. The Summary Courts Act of Trinidad and Tobago is the same exact standard that is applied when it relates to obtaining a search warrant. If I may take my colleagues in the Senate further, because my answer refutal to that is that the standard is not low, it is just simply in alignment with other pieces of legislation. The same standard apply in other pieces of law. One piece of law I would have spoken to is I spoke about the Criminal Procedure Act, I spoke about the Summary Courts Act. If I may also know, and I know Senator Bisram may be familiar with Section 30 of the Firearms Act. Section 30, Mr. President, as it relates to the obtaining of these search warrants, is the same exact threshold. And if I may read into the record, Section 31, it says a magistrate or a justice of the peace, on being satisfied by information and oath that there is a reasonable ground for suspecting that an offence, suspensory that, will then, of course, and the section more goes on to say, they will grant the search warrant, and so on and so forth. But what I had to simply clap, they came here, talking about these search warrants as if there's some kind of underhand reason. And Mr. President, this is good law, and I want to commit this law to the people of Trinidad and Tobago by saying that we have dealt, one, I made the distinction between that intercept warrant that they would have spoken about. I'd have respectfully, through you, suggested to my colleagues to go, my friends on the other side, to look at Section 6, Section 8 of IOCA. They will see the distinction, and then I would have gone a separate step, a further step, Mr. President, in disputing their arguments and their concerns about these search warrants. In looking at existing law, Mr. President, the Criminal Procedure Act, looking at Section 37 of the Summary Courts Act, looking at Section 30 of the Firearms Act, to say that the standard is not too low, what we have simply done is apply the same exact standard that is used in other pieces of legislation as it relates to the obtaining of search warrants that appears before us. And I had to clear that record. I would have hoped that, persons with their experience, Mr. President, that they would have familiarized themselves with the law. But it is what it is. That's why we are here as a government bench, to add clarity and clarification, and add and assist the opposition in understanding the good law that we are bringing to the people of Trinidad and Tobago today. Mr. President, and of course the issue of indictment was raised. And as it relates to the issue of indictments, Senator Lakshmi Dayal spoke about her concerns about where indictments are placed. And I have to say that one of my particular, all I want to say, Mr. President, especially in relation to the issues of indictment, I know Senator Lakshmi Dayal says if the DPP lays a voluntary bill of indictment, he is now subject to a sufficiency hearing. Mr. President, for the purpose of the record, Section 19(1) now requires all indictments, including a voluntary bill of indictment, and I want to read it, under Section 6(2) to be subjected to an initial and sufficiency hearing, yes. This upholds the power of the DPP to do his voluntary indictment. But at the same time, and this is the point that I want to make, Mr. President, but at the same time, it still allows for a matter to be adequately case managed so that all necessary documents are before the court for the trial. So yes, that is why particularly I'm supporting the place in which indictments we are requiring that indictments are filed, because we are not usurping the rights and the powers of the DPP. That is still intact. But by moving the indictment at the beginning of the sufficiency, to the place where we have now moved it, Mr. President, what we are doing is that we are now having an ability to aggressively and adequately, Mr. President, manage when that indictment is filed and ensuring that all documents are before the court in a timely manner. Mr. President, this is a real issue. I recall in preparation for this, I would have pulled some stats on indictments. And it is, and again, this is not, of course, to cast any aspersions on what happens in the Office of the Director of Public Prosecution at all. But I have my concerns as a citizen of Trinidad and Tobago. When I look at, for example, let's look at 2013 in the Port of Spain division alone, Mr. Port of Spain courts. We had 105 indictments alone that is filed. We have in 2014, you have 129 indictments. And this is from thousands and thousands of matters. If you fast track from 2013-14 to 2023, we have 41 indictments, Mr. President. If we are serious about improving the criminal, and that is in the Port of Spain area. If I look at San Fernando, in 2013, we'd have had 78 indictments. There was a year in 2020 where we only had, well, of course, I know COVID was around, but we had only 4 indictments filed, Mr. President. Currently, in 2023, we have 42 indictments, Mr. President. Certainly, if we are serious, which we are on this government bench, we are serious about, expediting the rates in which matters go through our criminal justice system. I have to agree with the Attorney General. I have to agree with the bill which appears before us at the stage and the place in which we have placed these indictments. And I'm hoping that, at least in the minds of the independent bench, that we get the support that we are looking for, recognizing if we go through, and I don't want to belabor the point of, what indictments have not been filed and what is outstanding, but but there is the statistics, sorry, Mr. President, are available, and it is concerning to me, not as a member of government, not even as an attorney at law, but just as a regular citizen of Trinidad and Tobago, because, I heard Senator Lakshmi Dayal said it, the AG said it. When we deal with these matters, and I will echo that as well, when we deal with matters, criminal matters, remember there are several stakeholders involved. We're not just dealing with the accused, and we're not just dealing with a government who wants to pass good law and manage a country. We are dealing with the witnesses, we are dealing with families, we are dealing with the police. There are so many stakeholders. And once you don't have these indictments brought at a reasonable time, once you don't have them being filed at a fast rate, we will continue to have not just the criminal justice system being affected, but the lives of real people, Mr. President, being put on hold because there is a matter looming over their head. And that was just, I wanted to just echo that I am in full support, Mr. President. I recall also, Mr. President, during our consultations on this point of indictments at our public defenders department, they showed, of course, support for the voluntary bill of indictment being subject to a sufficiency hearing. And of course, I want to also place that on the record. So we have stakeholders, the judiciary, we have public defenders department as well, also supporting the position of where we want to now place indictments in these proceedings. And I just wanted to, put that on the record. So, Mr. President, I mean, those were the six of the points that were made by contributions made by Senator Lakshmi Dayal that I just wanted to start my presentation looking at. Mr. President, you can tell me how much more time I have?
Finish at 4:23.
Well, I don't have much time, as I can see, but, Mr. President, based on what you would have said, Mr. President, again, I just want to start from the place. I know the AG would have mentioned the case of Hilroy Humphrey, and, of course, I'm not going to belabor that case, but, Lord Huffman, I just want to start by reminding the citizenry, reminding even the accused and the family of the accused who are paying attention to this matter, that, of course, we are not usurping the rights, we are not trampling over the constitutional rights of the accused by the removal of preliminary inquiries, Mr. President, and also jumping into the case that the AG would have mentioned too. I'm certainly not going to run afoul of tedious repetition, but I would look at a statement made by Lord Huffman in particular in that particular case, Mr. President, and for the purpose of the record, Mr. President, Lord Huffman stated that prospective litigants or defendants, open brackets, or defendants in criminal proceedings do not have a vested right to any particular procedure, and there will generally be nothing unfair in applying whatever procedure is enforced when the case comes to court. Therefore, Mr. President, and close quotation, and that's taken straight out of the Hilroy Humphrey case. Mr. President, and this is especially, as I started off saying, for the families of the accused persons themselves. Please, it is really for them to understand that certainly their rights to be heard has not been trampled upon, and there is no constitutional issue, Mr. President. An accused person will still be able, Mr. President, to enjoy the right of due process, and therefore, with this amendment, Mr. President, I reiterate there is no constitutional infringement by abolishing preliminary inquiries, as it does not, Mr. President, at all affect the accused right to a fair trial. Mr. President, I know the Honourable AG would have spoken in his piloting of the bill about this bill not being an infringement on the DPP's constitutional rights. In my presentation, of course, because time again is always my enemy in this hollowed place. Just briefly to reiterate and to join with the Honourable Attorney General in his position, I too agree as an attorney at law, Mr. President, that there is no infringement on the DPP's constitutional rights. All the rights of the DPP pursuant to Section 90 of our Constitution, Mr. President, is intact in this legislation, Mr. President. Mr. President, as a matter of fact, the DPP has control over, as we know, based on his constitutional rights, Mr. President, he has control over criminal proceedings, similar to other countries. In this bill in particular, Mr. President, if we look at Clause 8 of the bill, which amends Section 6, to my mind, that is a clause in this current bill that shows where the rights, that Section 90 rights of the DPP remains intact, Mr. President. And that example in coming out of this bill that appears before us deals with the issue of the discharge of the accused. In this particular clause, Mr. President, we see the director has a power under Clause 8, which amends Section 6(2) of the proposed bill to provide when he or she is of the opinion that a person should be put on a trial for an indictable offence, the DPP may prefer and file an indictment against the person whether or not a complaint is made against that person. Mr. President, if I go on further to the bill that appears before us, the proposed Clause 20 of the bill, which amends Section 6 of the bill, it goes on to state, and I quote, "A master shall hold a sufficiency hearing to determine whether there is sufficient evidence to establish a prima facie case or any indictable offence on an indictment." However, Mr. President, the proposed Clause 25 of the bill, which amends Section 24, provides, after reviewing the evidence submitted by the prosecutor and the accuser master, finds that there is insufficient evidence to establish a prima facie case on any indictable offence or indictment, the master shall discharge the accused, taken in respect of the charge, and taken in respect of the charge shall be void. However, Mr. President, there's a safeguard in the bill that appears before us. The constitutional function of the DPP is not trampled, it is not eroded, and that is seen at section 24(4) of the bill, Mr. President, that provides for instances where, and I quote from the section, I quote from the bill, where an accused is discharged, the master shall, on a written request of the Director of Public Prosecution, transmit within 14 days to the Director of Public Prosecution the record of the sufficiency hearing. It goes on, Mr. President, to provide at the proposed section 5 that the Director of Public Prosecution may appeal the discretion of the master if the Director of Public Prosecution is of the opinion that the accused ought not to have been discharged. And what we see here, the right of the DPP to appeal that decision, Mr. President, to my mind, that bolsters his section 95 rights pursuant to the Constitution. So I want, if there are any concerns, especially in the minds of the members of the listening public, who may believe that in some way or the other this bill seeks to trample the rights, the constitutional rights of the DPP, Mr. President, I simply suggest that they go to the bill, particularly pay attention to section 24(4) of the bill, which is clause 25, Mr. President, of the bill, which amends section 24, and more so section which amends section 24(4). Pay attention to that, and you will clearly be able to see that the powers of the DPP, the section 90 powers of the DPP, Mr. President, of course, it remains intact. And just as we are not trampling over the rights of the accused, Mr. President, as I would have alluded to earlier, similarly in this bill, we are not trampling over or infringing upon the section 90 constitutional rights, Mr. President, of the DPP. Mr. President, 3 more minutes. Okay, so in my 3 minutes, Mr. President, Mr. President, I just want to say there are many, many social benefits that, of course, that goes with the bill that we are dealing with today. We are looking at, by the removal of these PIs, I will strongly say, from a cost perspective, Mr. President, and cost for the accused, Mr. President, whereby now you have not having the trouble of having to hire well-learned senior counsels and the creme de la creme to run this trial for you. Accused is already in prison. Is the family tail to catch, unfortunately, Mr. President, to determine what are they going to sell. Sometime, God forbid, their kidney and liver, hopefully they don't have to sell in order to find money. And that is a reality. It's sad what families of the accused have to go through in order to be able to retain counsel. By the removal of these PIs, Mr. President, I strongly believe that there's going to be a significant social benefit to the accused persons, as well as from a cost perspective, Mr. President. We also have from him being the accused being or her being denied her freedom for the length of time that they remain waiting for these matters to even come up at a PI level, Mr. President. That too is another social benefit. The AG, I know he would have more or less timestamp. I think it was a 6-month period based on the deadlines that are now given in the bill that appear, the timelines that are given in the bill that appears before us. I myself calculated it. You're looking at, hopefully you would have the sufficiency hearing if you have the adherence to the timelines that presented, that these matters can be dealt with in a matter of 6 months' time. And if you calculate the 28 days there and the 14 days there and the 15 days there, it really works up to about 6 months. That is in the interest of the accused, Mr. President, because we are looking at, he's not just sitting there becoming a hardcore criminal waiting for his matter to be heard. We have that sufficiency hearings can be dealt. We have that their matters can come up. He knows whether he has a matter to answer to on the indictment or whether he is, whether he's discharged. That is a benefit. And more so, Mr. President, I believe by doing this is also a great benefit to the country. Mr. President, I remember In 2016, the then Attorney General would have revealed that the cost to the state to, let's say, maintain inmates on remand is about 10.6 billion per year to maintain 2,235 inmates. That was the cost, Mr. President. I believe we can reduce the cost and even save the country, Mr. President. Monies can be used elsewhere rather than taking care of prisoners who are waiting for their trial. I thank you, Mr. President.
Senator Bisram Singh.
Mr. President, I thank you for the opportunity to contribute to this bill here today. We all know the major crisis that our criminal justice system is currently in, and as a criminal defense attorney, I, for one, welcome any meaningful legislation that can adequately address and resolve the issues. But in order to address the issues, we must be able to correctly identify the issues. And in order to correctly identify the issues, we must understand how our current criminal justice system works in reality. We cannot just sit here and deal with the paper aspect and be disconnected from the reality of things. We cannot just be drafting and implementing legislation that on paper sounds and looks good, but will do nothing to help our criminal justice system. If we do that, we are just here wasting time, money, and paper. I was told that this bill is being referred to as the fast-track trial law. That sounds good. Anything to have the wheels in our criminal justice system moving. But we must never sacrifice fairness for speed. It is our criminal justice system, and we must be just, and we must ensure that justice is served. We must ensure that the legislation being drafted and implemented preserves our rights as citizens, and more so for an accused person. We must ensure that the legislation can achieve its aim. We must ensure the legislation is useful. And after listening to our Honorable AG, I began to wonder if the go-to or the fix-all for everything was to abolish, and whether abolition is synonymous to faster and speedier. The criminal justice system slow, so let we abolish the jury system. The criminal justice system slow, so let we abolish preliminary inquiries. What next would we want to abolish? I am not here to bash the government. As a practicing criminal defense attorney who is in the criminal justice system every day, I want change. I need change. And I am not even one of those accused persons sitting in a cell languishing. So I am open to any proposals or measures which would help our criminal justice system. But let me tell you why this bill, which seeks to abolish preliminary inquiries, will not help speed up the criminal justice system. The statistics and numbers were given with respect to how many indictable matters are at the magistrate's court currently, and how many indictable matters are added each year. As it stands, it is in excess of 37,000. So you have 37,000 persons fighting and competing to have their preliminary inquiry started and completed. But in an actual preliminary inquiry, the actual hearing of evidence where the witnesses would come to be cross-examined, you know that process itself actually just takes days. So if in the hearing of a preliminary inquiry, if the hearing of the evidence just take mere days, why do we have this backlog? Why does it take so long from the point of being charged to the point of being committed to stand trial in the High Court. One of the major delays is the actual filing of witness statements. I have been in many murder PIs where it takes upward of 6 months to have all the witness statements in a matter. So you have the accused going to court every 28 days just to be told how many statements filed so far and how many are outstanding. That is the norm. You would never get all of the witness statements in less than 6 months. And this is me being generous. Now, we all know and we are all aware that the actual filing of the indictment takes years. Accused persons thinking, okay, they completed their preliminary inquiry and they are committed. So now they are going to have their trial in High Court before a judge. But that is not the case. They have to wait upwards of 5 years before their matter could even come before a judge in the High Court. And again, I am being generous with the time of 5 years. If this bill seeks to circumvent the years it takes for the filing of an indictment, then well done. I will be in full support of a measure that can do that. But even if this bill may appear good on paper for the reduction in time in having indictments filed, it may not be so in reality. Because this is not the fast-track trial law. This is the shifting of the bottleneck law. What this bill does is that it just moves the bottleneck from the magistrate's court to the masters in the High Court. So we will have the 37,000 indictable matters before the masters in the High Court and then awaiting to go before the judge. So you're just moving the bottleneck that is currently in the magistrate's court and placing it before in the High Court. Why are we reinventing the wheels in hopes that it fixes the criminal justice system rather than just address and fix the real issues? Other measures need to be implemented in our criminal justice system. Measures like having more masters, more judges, more prosecutors, more courts. The required personnel must also be properly trained. We must have the proper infrastructure to support all of this. And I don't want to hear how many new masters were appointed and how many new judges were appointed, when in reality that figure does not represent the masters and judges that were positioned in the criminal division. We have the civil division, we have the family division, where some of that manpower went. How many times we have to hear the DPP begging for prosecutors, and the DPP department is in a deplorable state. This government implemented the PDD, which was able to supplement and support the very small defense attorney bar, and this PDD is very highly functioning. That was a good measure. The government heard the cries that matters were being kept back and taking too long because the criminal bar was just too small, and it was only a handful of attorneys in matters, and that these attorneys could only do one trial at a time. So that problem, that clog in the criminal justice system was addressed. When are we going to address the lack of prosecutors in the courts? It is the same prosecutors that are before the masters and the judges. I have appeared before masters on many occasions, and there are no prosecutors in the courts. Why? Because the same prosecutors are engaged in trial before the judges. So no prosecutors are available to appear before the masters to progress matters. Now, I know this bill seeks to have police prosecutors conduct sufficiency hearings as well as the state prosecutors from DPP office. But isn't that already the case with preliminary inquiries? Don't we not already have the police prosecutors there, and they who would conduct majority of the PIs before the magistrates? So we have them there, and we still have a backlog. We still have a bottleneck. So what is this clause going to change? This government implemented the grant of bail for murder accused in an attempt to reduce the prison population. Again, I commend that measure. I am in full support of that. But we should pull the statistics and numbers and find out how many persons have since applied for bail for murder, and from that number, how many persons have actually had a determination in their matter. I am certain that the number is not encouraging. And why is it taking so long? There are not enough prosecutors to deal with applications. The matters are being adjourned for months to allow for prosecutors sufficient time to respond to applications, as they are the same prosecutors before the masters, the same prosecutors before the judges. Now, this bill, I firstly want to deal with the sufficiency hearing itself. Pursuant to Section 19A1, the attendance of witnesses is not required unless there is an application made and the master makes an order for the attendance of the witness who filed an unsworn statement. So witnesses who have a sworn statement are not required to attend these sufficiency hearings. The rationale, I'm sure, for that clause was no witnesses being brought to court to give evidence, so no witnesses to cross-examine, no time to waste, no delay to the matters. Now, we currently have paper committals in courts at the moment, which means that witnesses do not come to the courts to give any evidence. Their evidence is already on paper. The witnesses are only coming to be cross-examined. This government again drafted and implemented the criminal procedure rules, and that is working well. Those rules achieve the aim of case management of criminal matters. Long gone are the days where you would cross-examine witnesses at length, and these criminal procedure rules, which were implemented, sought to limit the number of witnesses you would cross-examine. If a matter has 20 witnesses, you don't cross-examine all 20 witnesses. You can agree to evidence formally, because you don't want to cross-examine the police officer who escorted a dead body to the Forensic Sciences Center. You don't want to cross-examine the police officer who collected a post-mortem report. So in a preliminary inquiry, not every single witness is being cross-examined. In most cases, you would just find that the victims, the eyewitnesses, and the lead investigator are the witnesses to be cross-examined. But in that cross-examination of the main witnesses, you get to test the evidence that puts you in court at the first place. An accused person gets to challenge his accuser. You get to challenge the eyewitness account of what he allegedly saw. And this opportunity to challenge the evidence is very, very important, as your case could fall through right there and you could be discharged. You cross-examine the person who put you before the court and realize that his evidence cannot be relied on. Your matter does not then go to the High Court. Your matter would finish right then and there. But with this sufficiency hearing, you are not given the opportunity to cross-examine anybody. The master looks at the witness statements filed in the matter and makes a determination if there is a prima facie case for the matter to then go before a judge. Accused persons are now going to be robbed of an opportunity to have their matter finished right there. The accused would have spent extra time in prison if he doesn't have bail, when he could have been discharged right then and there at the end of the PI. An accused person is now going to be robbed of the second limb that is available to him in making a submission of no case to answer. Usually, after evidence is heard in a preliminary inquiry, an accused person can make a submission of no case to answer in that the cross-examination of the witnesses has been so discredited, the evidence was poor, it was inherently weak, that a jury cannot convict on it. This bill in Section 23 gives an opportunity for submissions to be made to the master to help in reaching of the final decision. But if you are robbing accused persons of the opportunity to make a submission of no case to answer on one of the limbs, is that fair? Further, we have also had instances in court where, during a preliminary inquiry and cross-examination of witnesses, the case would unravel right there. The cross-examination of witnesses was so poor, and that during the preliminary inquiry, the prosecutor would often go back to the DPP to get instructions as to how to proceed with the matter, whether to continue with the matter. And sometimes, these cases are stopped right then and there. So all of these are cases which appear good, which appear strong on paper, on the witness statements, and then after the cross-examination, they are unraveled. If with this sufficiency hearing, witnesses are no longer required to attend, then this could never happen, and persons will be made to languish in prison even longer than they should. Now, Senator Sagram Singh spoke of her experience of being locked into a bad cross-examination from a preliminary inquiry and then not being able to navigate in the High Court and a High Court. And all I would say is that you don't need a bill which will take away the cross-examination. You just need a better lawyer. And you know, cross-examination of a witness in a preliminary inquiry sometimes saves a trial before a judge. And let me tell you how. We have many instances where witnesses die or they become unavailable before they are able to attend their trial and before they are able to be cross-examined. But because this now deceased or this now unavailable witness was cross-examined in the preliminary inquiry, the state makes an application to put that evidence, to put that cross-examination before the jury. Because the state will essentially be saying, look, the witness was cross-examined in the preliminary inquiry, and that the jury can use that evidence to determine the credibility of the witness. So now, if we are to have sufficiency hearings and no cross-examination of witnesses, and then that witness comes and dies before the trial, what is going to happen? Because it would certainly be unfair to put a witness statement which has been untested, which has been unchallenged, which did not give an accused an opportunity to challenge his accuser before the jury. So now the judge may rule that it would be unfair to do that and would not allow that witness to give evidence before the jury. And then that's it. The whole case falls down there, and the accused would have spent time in jail for nothing. Again, why are we reinventing the wheel when, if these measures, if passed, are not going to help the criminal justice system? I feel like we are running a relay in circle. We are just passing the baton, passing the bottleneck from the magistrate's court to the masters, and we are just running in circles. Now, at the initial hearing as proposed in this bill, it asks for an accused person to file his witness statements or other relevant documents for the sufficiency hearing. But how is an accused person who has a right to remain silent, who does not need to advance a defense, but rather challenge the prosecution's case, how is he now being made to file witness statements before his trial even starts? Usually, it is at the end of the prosecution's case in a trial before a judge that an accused person will make a decision whether he wants to call evidence, whether he wants to call witnesses. Why is an accused person now being forced to show his hand? And this is before his trial even starts before a jury. Now, a next part of this bill that I take great issue with is Section 32B1, which speaks to anonymization of documents. The Honorable AG said that it's not the anonymization of witnesses, but that it is the anonymization of documents. But what other documents it have to anonymize other than a witness statement? We're going to anonymize a forensics report. We're going to anonymize a certificate of analysis. We're going to anonymize photographs. It has to be the witness statements that are being referred to. So with this measure, we would not know the names of the witnesses. We don't know if it's a man, if it's a woman. We don't know who are making these accusations against us. We don't know if it's someone who we have noise with, if it's someone abusing this section and hiding behind this section for whatever hidden agenda they may have. And this cannot be the case. An accused person must be able to know who his accuser is. This section is only going to allow for spurious allegations to be made against persons and now enabling persons to hide behind it. Currently, we already have legislation to deal with all of the scenarios which this bill wants to deal with. When a witness is in fear, when a witness does not want to come to court to give evidence, we have legislation for that already. Witnesses can give evidence via video link. Witnesses can give evidence behind screens. We have the witness protection program that can be used. So is it that the government is now saying that these measures are not working? And with this measure, how are accused persons going to ask for disclosure if they don't even know the persons who are making the allegations? How would an accused person know if these witnesses have convictions, have pending matters, if a bad character application should be made? How is an accused person going to properly prepare their defense if they don't know who brought the allegation against them? This cannot be. Mr. Vice President, this bill will not help the current state of our criminal justice system. All that this bill does is just move the bottleneck. The criminal justice system will still have a backlog. It will just be before the masters at the High Court. This is not a fast-track trial law. This is a move the bottleneck law. This bill is not going to achieve its aim. We need to go back to the drawing board for this. Our criminal justice system demands more and deserves more. I thank you.
Senator Dr. Varmadiyal Singh.
Thank you, Mr. Vice President. I must say that this proposed, the amendments to this AJIPA 2023, I've been hearing that this is really to expedite the system of justice in Trinidad and Tobago. So persons who have started in the process would have a faster means of getting to trial and a faster means of being able to get justice. So therefore, the intention seems to be very good. It's an intention that I'm pleased that the government is at this stage trying to somehow get the wheels of justice turning faster. As we all know, justice delayed is justice denied, and so we are now moving to try and see if we can get this justice going a bit quicker. Recently, I read where it took, I think, 13 years for a case to reach the High Court in its determination, where there was the death penalty handed down to an individual. 13 years. And you see, this to me, it's a fact that we know we have a slow pace of justice. We know that the judiciary is trying to improve the system. We know the fact that the government has been even providing more courts, more judges, etc. So there's a trust to see if we can get this going forward. But 13 years, I think it's an injustice to the relatives of those victims of crimes waiting this time, not knowing what's happening. It's an injustice to the eyewitness who, if involved in the cases, who now have failing memory, who would be frightened if their case is not heard, if it's not heard quickly. Their safety out there would be something that they have to be a bit worried about in our crime environment. Then again, the personnel in the court who has to be seen about these matters, being up and down, to and fro, police officers for 13 years. This, to me, it's a horrendous weight, and it is a great mental strain even on the persons and the relatives of victims if they have to be waiting this long. Even the plight of an innocent person who might have been framed and waiting for his case to be held, waiting for the trial, waiting to get that out there that, look, I am innocent, I've been set up. So all these, it can be unfortunate both for victims and both for the accused if he was innocent. So we all know that there was a need to do something better, and this bill here serves to try to expedite matters now. And the thing is, we have the fact that preliminary inquiries has its function. This whole process serves to weed out the persons coming there, the police officers come in, minor cases, cases going to the High Court, where it weeds out those cases where there's not enough evidence. And at least it makes sure that the case going to trial would have had enough evidence to proceed, to go forward. And I heard speakers before mention there is the whole justice in that system, where we can weed out those cases quickly. We allow the magistrate to end cases based on the fact that if there were insufficient evidence. So it sounds good in the sense that it has a great function to weed out the cases, to try and prevent these cases from going forward. But you see, the fact remains is when you hear the figures of the backlog, something went wrong. So even though it was there to serve its function, if you're hearing figures like 37,933 serious offenses are still pending in the pre-trial phase, it means something is not right. If we heard the figures, there's 8,835 coming per year, again, something is not right there. So definitely having these cases hanging over a person's head, having those cases there, shows that even though the preliminary inquiries may have had a function, serves a function, probably prevent cases from going forward, I would have liked to know like the amount of cases that went before the magistrates. the percentage that they were able to say, listen, these cases did not have enough evidence to go to the High Court. And that would have kind of give me the success of the preliminary inquiries, because it would tell me now, like if there is 75% of cases not going to High Court, it would have given me the idea, well, hey, these magistrates and the prelim probably doing something well, something to prevent cases from going up to the High Court, which is a higher level of the judicial arena. So the figures would have helped me somewhat to make a determination. The other thing too, if we figure it's the delay and the bottleneck is at the magistrates' court. I know the government has given us more High Court judges. I think I've heard the figures in the Court of Appeal it has increased, and also in the High Court itself. So we have gotten that commitment from the government that we heard about, and we have gotten more courts. We have gotten some improvements that we should be proud of. That we are on the threshold of going forward. But then coming here today, I'm wondering, is it that having more magistrates, putting some more efforts in giving these magistrates, increasing their numbers, would this have now been able to solve this problem? In the sense you now have more magistrates sitting, you'll be able to hear the evidence, and be able to get these cases expedited quicker. Some go up, some stay, some will just have to get out. So therefore, this was one thing I'm looking at. Why not increase that capacity in the lower, the district magistrates courts? Because we've heard that the magistrates courts are now district courts, and we have heard there's a trust there to improve the system there. And I think doing this would have probably helped that situation somewhat, and not needing to change so much. But be as it may, we are here and we are looking at changes, and government said they're going to be trying to get this bill passed. I had the fact, I had the disquiet that when I'm looking at cases going before magistrates, sometimes it is not a quick system. It comes like it's a mini trial. You have not just listening to the evidence, and I heard the speaker before mentioned that they don't look at every piece of evidence. Sometimes a police go in with some report, they wouldn't look at those things. But the fact remains, a lot of attorneys, they think that if they could abort that trial at this stage, this would be beneficial. So it came like you're having trials there within the magistrate's court. You have those smart attorneys wanting to look at every piece of evidence, question the eyewitness, and sometimes that delays it also. Sometimes the eyewitness also may feel that they are badgered in court, and some of them lose their strength of their braveness to say, hey, we are going to the High Court, because after you facing the music in the magistrate's court, you may lose your courage and say, look, I have no time for this, I don't believe in going forward. So sometimes, even though we have heard the advantages, there were some disadvantages. And again, I heard my independent colleague before spoke about it's like a gravy train for attorneys, the amount of money that they would have probably gotten in these cases. So the fact is, all these numbers show me that something went wrong and something needed to be done. And this is why I would like now to look at some details in this piece of this bill that is here to see what I may be concerned about, what I may decide that I may want to get some clarification. Remember, this whole bill serves to expedite the system, to get rid of some cases, to get it faster track. But you have to remember, sir, the last time when we tried to expedite cases, it was when we looked at Section 34 that came here, and the whole good intention was to get rid of cases 10 years and older. What happened then, what transpired then was like it created something more than that, So we have to say expedition of the judicial system, getting it faster, getting rid of certain cases, even then 10 years and older, seemed to have been a good idea. And at the time it was passed, all benches had agreed to it, and that was close to midnight when they were agreeing to it. So things may sound good, but then you have to realize if there's any sting in the tail. So are there anything in this piece of legislation that we have to be concerned about? Well, the opposition did mention that the excursion into the powers of the DPP was a cause of concern. And I also may have had a little concern, but I heard members on the government's bench speaking about it. The minister in the Attorney General's Office, Legal Affairs, mentioned about the concerns. She had tried to address some of the concerns. But if history served me right, the DPP, it was in 1975, I think the DPP got the powers to have the powers to indict. I think it was in the AG before, and in our 1975 legislation, it came over to the DPP. So therefore, the powers there now simply that rest with the DPP is something that I am cautious to see any piece of legislation which may be perceived as trying somehow to erode his powers. And this is why I had some concerns, because you have to remember the DPP did mention he had 114 members of staff that was deficient in his department. And he cried out for this, and there was a public spot, I want to put it, where other persons came in and said it's really not, he's not running his office properly and he doesn't need that staff. So it came from different quarters. So right now he may be on the defensive, where he may think he had a need to try to expedite the system of justice. He said he needed his staff, but he was pushed back. So therefore, I just want the assurance from the Attorney General that the DPP was in fact consulted on these changes that were made. Because you see, if there's a public perception, there's some sort of well, they're not, seeing eye to eye on certain matters in terms of staffing and how we could expedite system, we would not want to create any sort of a problem there. So I was really looking at the piece of legislation here where we actually attempt now here to strike out some of the old pieces of the legislation. So I look at Part 3, where it's mentioned sufficiency hearing. And it's under 19(1)(a), which is now being struck off, where a sufficiency hearing shall be held by a master to determine whether there is sufficient evidence to establish a prima facie case of any indictable offense, unless the Director of Public Prosecution prefers and files on indictment under Section 6.2. So that is being struck off, and what it is replaced with, and Part 2 is also struck off too. A sufficiency hearing shall be held in open court unless a written law of rules made under this Act provide or the master determines elsewhere. So we are striking off 19(1) and 2, and we're replacing it with a master, but just one part. A master shall hold a sufficiency hearing to determine whether there is sufficient evidence to establish a prima facie case of any indictable offense on an indictment. So we actually remove the DPP from this equation. And probably there may be a good reason, but I would want to know that the DPP was actually consulted on this and will think, hey, this is probably a good idea. It makes sense by taking me out of that. And there were different areas where the DPP again was, to me, excluded. And again, under consultation, I have no problem with that. And I look at also Section 24, Part 4, where we are looking at discharge of accused. And what we want to introduce is Part 4, where we say where an accused is discharged, the master shall, on written request of the Director of Public Prosecutions, transmit within 14 days to Director of Public Prosecution the record of sufficiency hearing And also 5, the Director of Public Prosecutions may appeal the decision of the master if the Director of Public Prosecution is of the opinion that the accused ought not to have been discharged. So now, here we are seeing that if some power is taken away from the DPP, but yet still you're giving him that right to appeal, he needs the staff. He may need that staff to mount that appeal. Else, if you're not giving him that, it again would go against the grain of that. He may want to appeal, but because of staff restriction, he may have to hold back. And I was always under the impression that the DPP had the power to even initiate the criminal proceedings, and even if it was dismissed, to restart it. So I just wanted that clarification and that sort of comfort to know that the DPP would have been consulted on these matters. And then I look at section 26C again, which says, if after the receipt of the statements and other documents mentioned in section 26 or 26.1, the Director of Public Prosecutions is of the opinion that the accused person should not have been committed for trial, but that the case should have been dealt with summarily, the DPP may, if he thinks fit, refer the case to a magistrate for summary trial. So again, all these things were depleted. So my point is made. DPP consulted. I have no problem with it. Again, I look at this legislation. I said there are some good things that I saw. I saw the fact that when I looked at the fact that section 20, which looked at the review of evidence, and 20, part 3A, notwithstanding section 91 of the Children's Act, where a statement is made by a child under the age of 14, such statement shall be supported by a statement from a probation officer, a child psychiatrist, and before it had or any other persons qualified. Now, we hope to add child psychologist, social worker, counselor, other persons who is similarly qualified to make an assessment. So I totally agree with this piece of addition. And again, I look at also 20, I look at part DA, where we want to add now, where the statement is made by a person who does not speak English fluently, the statement shall, 1, be taken in a language which the person speaks fluently in writing or by video or audio coding. Again, when I look at part of that section, DA, as it goes so, it again shows the fact that we are aware that with the influx of the migrant population, other people here, there's a need for this. So I commend the Attorney General for putting that in this piece of legislation. I want to also make mention to the fact that the fact is the part of this piece of legislation where I think it caused some contention before was the idea of the anonymous document. And this is section 32B, which is being put into this bill here. This was not in the parent legislation. And this caused some sort of I'm hearing on one side that it is really for documents only. It's not for the witness. And 32B reads, the register may on application or in his own discretion anonymize any document filed or issues under this act, if necessary. And it's for part A, for the protection and safety of a witness or the accused. Part B, to prevent serious damage to property. Part C, in cases involving witnesses who the court considers to be vulnerable by virtue of 1, the age or immaturity of the witness, the physical disability or mental disorder, any trauma suffered by the witness fear of intimidation, or the nature of the offense, including the sexual offenses, for which the witness is the virtual complainant, or in the interest of public safety. So if we are going to if it's not really the individual that we are trying to protect, and it's really the individual's any sort of documentation. I just want you to get some ideas what it is, some examples, what sort of documentation that we would deal with. Because you see, we are looking at anonymous witness, which is one thing, but to have the persons who give these documents in and being protected, I would want some more examples of that. Because remember, if you had remember the Scott Drug report, Mr. Vice President, this report was a public report, and a lot of the persons who gave evidence in that report were criminals, known criminals. So therefore, we have to make sure justice is done, that if certain persons come here and decide to take advantage of the law, and you don't know if they hide behind this to cause some sort of mischief. So we have to be aware of this. Now, if it's a document, like let us say, I see that if it's a document but any trauma suffered by a witness, if I'm a witness and I'm going through post-traumatic stress disorder, I have that in a medical file. I wouldn't want that document out there because that's my personal medical file. So I can relate it to that. So I would just need some other examples if the Attorney General will give us that example, so at least make me sit a little easier in this, because I was getting the impression that even in the lower house there was some discomfort, but I think it was clarified that it's the documents that we would be looking at really, and not the persons themselves. The other aspect I would want to say is I have tried to figure now, is it that it's only we in Trinidad who have this problem? Is it we that have this problem with delay? And I said no, because I looked at other countries and I see there's delay. The UK has the delay in their cases, also there are attorneys there who are also complaining. And in every single jurisdiction there are challenges. And there's a need to improve. And you see, when I saw that there was a case in Canada, and I would like you to permit me to please to just mention this case, sir. This case in Canada actually shows that there was a court case where we found that it's called a decision in 2016, a Jordan decision in Canada, where the Supreme Court actually found that cases were coming too long to them. And they imposed a time limit on the Crown to bring criminal cases to bring criminal cases to trial. So that Jordan decision actually found that the delay is unreasonable after 18, they give a period of 18 months in the provincial court or 30 months in the superior courts. After the delay, the Crown now must prove why there is a delay. So that case rocked the Canadian criminal system, because right now the court, they had now no choice after to try and expedite. They had to see how they are going to get these cases, because the courts actually put that direct mandate on them that they had to do it. So what did they do? Well, they had to try to expedite cases. And what they actually did, they utilized the system where they started using direct indictments more. So what we are trying to achieve here via legislation, they were directed via their courts, the superior courts, that they had to do something, and they chose that matter. Now, when they chose that, did they get any sort of criticism? Because remember, did anybody say that, going straight to having direct indictments more would have any sort of problems? And they did. And this is what I'd hope you'd let me to read in, sir. And this is something from the March the 27, 2017, where the Canadian Bar Association said eliminating preliminary hearings isn't the answer to court delays. So they were against it. So this was in 2017. So they came, and I just want to put what they said here. They said cuts, however, justifiable they may seem at the moment, can end up creating more problems down the road than they were supposed to solve. So they were a bit critical of the fact that, that more cases were now being channeled through the direct indictment route. And they said, and they gave a whole set of different recommendations how we could somehow improve on the system, how we can somehow mitigate against the delay. So they had things in place that they suggested. And they also suggested police could be resourced to hire experienced counsel, support staff to help them in the cases. But we are hearing now from the government side that some of those police officers who are qualified in law would be assisting in the matter down in the lower courts. We also hear now that they were saying they actually had another release, and there was a release now by a different attorney now, where he said the problem of delay, a pragmatic approach, and this is by A. Scott Reed, and it was published in 2019, and some of the recommendations he made. So these are persons who in the Canadian system who will now be looking at the reasons for delay. And why I want to quote this is some of the things that they suggested are some of the things we already have implemented here. And this is something here, because they looked at reducing court delays, and it is by a group called Justice on Target program, and they aim to reduce delay. And what they said, and some of the guidelines they gave, and some of the suggestions they gave, was to hire more judges. But we have done that. So we have to commend the Attorney General and the government for doing this. So their recommendations, we already had that here. They said, however, the government there had to invest in courts, courtrooms, court staff, court reports, cell officers. They said judges need chamber days where they write rulings, so other judges need to preside in those days. But we have done that. So we were ahead of the Canadian system by what the Attorney General and the previous Attorney General had mounted to try and improve our system. Another option, they said, is to allow electronic remands, a form of non-attendance for simple remands. And they think we have to shift where even a defense counsel could stay in his chambers, he could touch base with the Crown, they could adjourn a matter without appearing in court. That would allow counsel to be actually in their office to prepare their cases, to review disclosure, to prepare trial applications, meet with clients and witnesses. But we already did that. During the COVID, we realized that remand yard, we had to come online. Some of the courts they are online courts. So again, the Canadian system, we seem to be having like a checklist ticking out their recommendations. Now, another recommendation they made was the fact that they found their offenses in terms of impaired driving and what they call over 80 offenses were taking up too much time in the court. But we already went to the Road Traffic Act, and we already have this system where we moved offenses from offenses to violations. And the Attorney General and the previous Attorney General must be commended for the fact that we freed up 104,000 cases from the court. Now, that is progress, and this is the same thing the Canadians were suggesting. One other thing that the Canadians actually suggested too was that the Crown screen minor offenses for prosecution. So minor offenses, they would say that something like shoplifting, personal disputes that end up with one party charged with a minor assault where there are no injuries were suffered. They were thinking they should free up that the courts from that. Well, we did free up the courts from the marijuana charges where people were charged with marijuana before because of the changes in legislation. But they actually were looking at other minor offenses for prosecution, shoplifting, etc. But this is something I wouldn't recommend because New York, California, persons are going into shops now and causing havoc, and the business persons are actually taking offense and closing their business because they find that if you don't prosecute these minor offenses, they just come back and reoffend, and it's difficult to run. So therefore, my point in bringing this is really to commend the government for the fact that a lot of these recommendations that were suggested in the Canadian system, we already have it on board. So we already have it on board. So that had to think that we were thinking ahead. We were trying to get this. I consider it as a dream that our last Attorney General was trying to peddle. But I mean, everything he has done so far, it seems to be coming on board. But we need to see the practicalities of it manifest where people actually start to move. We need to see the practicalities where figures will show that when somebody now is charged, it reaches to that point in a much quicker time. And that is how you really judge success. So in conclusion, I want to say that the Privy Council case, Hilroy Humphrey, said there's really no right to a preliminary inquiry, but there's a right for a free trial. So once we put that right for a free trial, once we ensure that the victims would be able to, the victims will get a free trial, the accused will get a free trial to make sure his rights is not infringed. Then I'm saying we would be doing a justice to our citizens. So once we can expedite matters, it is to the benefit of citizens. As I say, Canada was actually forced to try to go this way because of a court case. We are doing it voluntarily. We are following a plan of action, and it was set in motion before. And I see good things before. The judges raised from 36 to 64 in the High Court, 12 to 15 Court of Appeal, more courts. And I'm saying that I commend the government for this. Trying to expedite cases. It's to the benefit of the citizens. I also say the cautions that were raised, please go into it and allay the fears of persons. Also, I'm saying that the real test really is when we look at the figures from start to finish, then we would say, hey, we have done something for the benefit of the people. Thank you, Mr. Vice President.
Senator Welch.
Mr. Vice President, thank you for giving me the opportunity to speak on this bill and to make a few brief observations of certain aspects of it which I consider to be most important. This bill, which is before the Senate today, seeks to amend the Administration of Justice Indictable Proceedings Act of 2011. The act which this bill seeks to amend has a very impactful provision, which is Section 33. If that act comes into being, Section 33(1) of that Act reads, the Indictable Offences Preliminary Inquiry Act and the Indictable Offences Committal Proceedings Act 2014 are repealed. So the important act is the parent act in that it abolishes preliminary inquiries. And what we are dealing with today amendments to that act. But my concern, though, is that the government has advanced the importance of the abolition of preliminary inquiries. We have been hearing of the need to abolish preliminary inquiries for a number of reasons. It will bring a number of advantages to the system, etc. And yet still, although this act was passed in 2011 and assented to on December 16, 2011, we are now approximately 12 years later in 2023 with an act which was said to be important and which act has still not been proclaimed as yet. And what we are here to do today, without that act even being proclaimed, further amendments are being made to something which is in disuse and non-functional. There have been, I have counted it, there have been 4 amendment bills with the same name: Administration of Justice Indictable Proceedings Act, Amendment 2012 to the Act. 2019, there were 2 amendments. There was another one in 2020. And here we are again, without the Act ever being proclaimed or put into force, amending it, another amendment in 2023. This Act, since it has been passed in 2011, has existed through 3 different administrations: 2010 to 2015, and 2 of the same from 2015 to 2023. And none has effected it. But we keep hearing about its importance. We need it. And at every debate, I wasn't here for the previous debates, but I am sure the same thing was said when amendments were brought in 2012, the 2 amendments in 2019, and the other one in 2020. That is 4 before the one of today. I was thinking of what is the best analogy to describe this situation. And you may find, Mr. Vice President, that I have not begun by talking about the provisions of the Act, its advantages and disadvantages, etc., because a lot of senators have already done so. I am now looking at the wider picture of paying lip service to the matter, because the Attorney General, at the end of his contribution, indicated, and after it is passed, if it is passed, we will take some time again to allow for comments on it before it is proclaimed. So based on that statement, there is no indication of immediacy even after this 4th process. The best analogy I could have come up with is like, you know, the PTSE buying a bus in 2011, never deploying it or putting it on the road. It has never made a trip. It has never carried anyone anywhere. But every 2 years, you're refurbishing it. You're painting it over. You're decorating inside. You're replacing the seats with leather. You're air conditioning it. and the bus is going nowhere. If this proposed legislation is as important as the government advances that it is, then let this not be another paint job. Do something if one is serious. And I speak very vociferously and forcefully on it because being a criminal lawyer who has been part of that system, I fully know, appreciate, and understand and have experienced the serious disadvantages of the system of preliminary inquiries. Because with a preliminary inquiry, and I don't need to repeat myself in detail, a lot of the speakers before me have addressed it. With a preliminary inquiry, it's not the trial. For an indictable offense, you call witnesses, they are cross-examined. The witnesses has to testify over several days sometimes. There was a time when their evidence even had to be read back to them and they had to sit there and listen for hours while their evidence is read back to them. After the matter spends about 2 years in the magistrate's court, and that's at best, especially if it's a murder, after it spends about 2 years in the magistrate's court, the notes have to be typed up. Even with the present digital system, the notes, someone has to sit down and type up the notes after. That takes time before it can be transmitted to the office of the DPP and to the High Court, which is another length of time. So at best, before it is transmitted, I can tell you, because I am in practice, I have clients who have waited 8, 9 years before the arrival of proceedings from the magistrate's court to the DPP's office. And part of the problem is the albatross on the criminal, around the neck of the criminal justice system, and it is only one of the albatrosses. It is only one of the burdens, was the preliminary inquiry and the length of time that it lasts. Now, I'm not saying it's totally useless. I've heard some persons speak that there is some usefulness to it, there is some advantage to it, and I agree. But the disadvantages of it outweigh any advantage that is to be derived from it. I heard temporary Senator Karuma Singh, forgive me if I don't, in her very able and articulate address, mentioned matters such as it gives the opportunity, it is a sifting process, and it saves useless matters going to the High Court. And while that is true, I maintain that that is the minority, because in a preliminary inquiry, the threshold for committal, all us criminal lawyers know, the threshold for committal is very low. The magistrate simply has to find that there is evidence. So the whole business of you lose the opportunity to cross-examine and destroy the prosecution's case, and you lose the chance of an acquittal, that is more illusory than real. Because a magistrate would tell you in making a ruling, I am not concerned about the credibility of witnesses, I'm not concerned about the effect of cross-examination. That is essentially a matter for the High Court. So in any event, the advantage which has been spoken of that is to be derived to an accused from holding preliminary inquiries is not one which is often realized. So I have no hesitation, therefore, in expressing the view that any advantage is grossly outweighed by the disadvantages of it. And to that extent, I commend the government, the Attorney General, on the assumption that we are serious this time, on this Fifth Amendment occasion, for advancing it, hopefully making it a priority on this occasion. So in principle, I support any legislative attempt and effort which involves the abolition of preliminary inquiries. My difficulty, as I have said before, is that there has been an unjustified legislative lethargy in the approach to it. And I do not buy that we need to put things in place and we need to put the refinements in place, etc., before proclaiming the act. From 2011, when the act was passed, there had been enough time for that. Having stated that, my issue is whether this is the most effective approach. And that is my cue for stating I agree with those views which are to the effect that there is a strong possibility that all this approach amounts to is shifting the backlog from one place to the next. So while the philosophy and the idea is well-intentioned, and I support the thinking behind it, the approach which has been adopted, I do not think will realize the full benefits of what one is hoping for. I believe it would be underwhelming in its effect. And when we look 2 or 3 years down the line, we would realize that. I am suggesting a somewhat different approach with the same objective in mind. They abolish preliminary inquiries. I am with that. Initial hearing and sufficiency hearing. I am also with that. Where I differ is shifting that process from the magistrate's court to masters. In the same way that magistrates conduct the preliminary inquiries now, and they have to determine whether there is a prima facie case and so on, I submit they no longer will abolish the preliminary inquiries, that long form, no cross-examination, no calling of witnesses, none of that. But the system which is being introduced at the master's level, leave it at the magisterial level and let magistrates deal with it. And the reason why I say that that is to do otherwise would constitute a shifting of the backlog, because I heard the Attorney General say there are currently 18 masters, if I have gotten it wrong. I believe it is the Attorney General who said that, or perhaps the former Attorney General. Some of those masters, if there are 18 masters, some of them, I presume, would be assigned to the civil jurisdiction. But certainly, there are not as many masters as there are magistrates. Magistrates already have the facilities, the magistrates' courts, and the buildings, etc., and they are spread throughout the districts of Trinidad and Tobago. Masters, I am not quite sure where they operate from. The magistracy system already is in place, with accused being brought to them when someone is charged. With masters, under this proposed bill, accused persons charged with serious indictable offenses have to be brought before masters. As to where that would take place and how, I don't know. And exactly how are they going to be distributed with masters, I am not sure either. Because if it is, as the government has indicated, you have about 8,000, I believe is the figure, 8,000 indictable offenses on average every year. And you have about 18 or 20 or whatever masters. How is that not shifting the backlog? How are they going to manage? How are they going to master that quantum of work? It is impossible. It is not feasible to think that it can be properly managed. And then under this bill, they are going to be vested with even more responsibilities as well. They would now, masters now have to determine whether to issue search warrants, issue warrants of arrest, listen to police complainants come before them, decide whether there is reasonable suspicion. They have to deal with a whole host of things. And mind you, they already have a function which to me some of them seem overburdened with, which is case management conferences. I have been in some case management conferences, in fact quite a few, with masters, and they last half the day, sometimes more than half the day, and there are quite a number of matters on their list. Case management conferences relate to matters in which indictments are already filed and you are preparing it for trial to send it to the judge of the High Court. So a master who is already beset with a number of case management conferences now have to be taking on these 8,000 annually indictable offenses among their small numbers and having to manage that along with the several other responsibilities they are going to have. It seems to me impractical. I know it's perhaps too late for the suggestion I am making, but it needs to be said. Magistrates are equally qualified to do the work that masters do when it comes to indictable offenses, because they are the ones who are doing it now. They are the ones who have been doing it from time immemorial. And therefore, I support a view that abolish preliminary inquiries, but a new system be conducted by them. All the initial hearing, sufficiency hearing, scheduling orders, etc., etc., etc. And I think of the greater good. So I would love on this occasion to be proven wrong 2 years down the line. But somehow I feel I would be proven right. And I would have no joy in saying I did say so. Another concern I have relates to the situation with the Office of the Director of Public Prosecutions and his powers with respect to this amendment bill. To me, there is going to be a change in the law which is only going to contribute to the backlog and which is counterproductive to what is the whole purpose and the philosophy that has been advanced for these changes. Clause 25 of the bill allows for the discharge of the accused. If a master is satisfied that there is insufficient evidence against the accused, it provides that if the DPP is not satisfied by the decision of the master, he can appeal the decision of the master to the Court of Appeal. It would seem to me, I ask the question, why are we introducing a new layer of litigation in this process? You are appealing a decision of a master to discharge someone on an indictable offense, and that is going up to the Court of Appeal. So we now have to schedule a hearing in the Court of Appeal about what essentially is a preliminary matter. You're going to have arguments on both sides. It's going to be a full panel of the Court of Appeal. They may have to issue a written judgment. There is a case against this individual. A case to be tried. The master was wrong to discharge him. If the Court of Appeal issues a written judgment to that effect, and that man is now to go on trial in the face of a written public judgment after a public hearing before the Court of Appeal, isn't there a potential to prejudice him at his trial if there is a danger, if there is a decision from the Court of Appeal which is to the effect that there was a case against him and a master was wrong to discharge him? Why is this being changed? Because look at what is the present provision, which is more workable and which ought to stay and remain the law. Where did DPP, under section 23(5) of the Indictable Proceedings Preliminary Act, if the DPP is of the opinion that the accused ought not to have been discharged, he may apply to a judge of the High Court for a warrant for the arrest and committal for trial of the accused person. That is far simpler than lining up litigation before the Court of Appeal with both sides, submissions, etc. The DPP currently, what the DPP currently does under present legislation, and which is a far simpler process, is make an ex parte application to a judge who may issue a warrant for the accused. There's no filing of any skeleton arguments. There is no counsel on either side. There is no going before the Court of Appeal. There is no waiting for the Court of Appeal to fix a date. There is no public decision issued on the matter which can potentially prejudice the accused. Why is this being done? This in itself is a process which is going to take far longer than a DPP saying, you have discharged, okay, tomorrow I go before a judge, no arguments on either side, judge reviews the papers, judge issues a warrant. The issuing of a warrant is a simple process. So if this approach is being maintained with masters and so on, I've already expressed my view on it, but given that my view is hardly likely to change the fundamentals, at least that clause 25, get rid of it and replace it with a clause similarly worded as 23, as section 23, subsection 5 of the Indictable Proceedings Act, and put that into your administration of justice act as the remedy that the DPP would have in the event that a master discharges a person on an indictable offense and he is not satisfied with it. It is a far more sensible approach. There are other matters which, and I don't propose to go into them in detail because they have been touched on already. There are other matters which I believe were raised. I believe it was opposition senators that raised it, and it was something which I am in agreement with and which I myself had already earmarked. I think it is a bit awkward that the DPP, who has ultimate responsibility for criminal matters and so on, has to file an indictment so early in the process. If it is the government's concern that indictments have been taking too long after proceedings reach the DPP's office, I do not know that bringing forward the time for the indictment will speed up the process. It may make it even longer, especially if the department is under-resourced. It is going to put an even greater strain on them, and it will not achieve its purpose if it's the same reasons which have caused the delay in filing of indictments exists. It is the same reasons which would cause them to be unable to be filing an indictment ahead of the completion of a hearing. And it is a bit awkward as well. I see it speaks to the master speaking of amendment of indictments. As a trial lawyer, I would say, unfortunately, I have the advantage of wearing both caps, prosecution cap and defense cap. As a high court trial prosecutor and defense lawyer, I share with you my view that questions of amendment of indictments essentially belong before the judge who is trying the matter, and questions of amendment of it should perhaps remain there as well. It is a neater approach. It is more a trial issue, as far as I am concerned. And the issue with respect to this whole process, you can try to fast track the process, but since the DPP's office is going to be heavily involved in this process, and there has been, from what I observe, a history of the relevant authorities using the DPP's office almost like a training ground for masters and magistrates and judges, and therefore depleting it, leaving junior prosecutors, inexperienced prosecutors, etc., then it is either the powers that be increase the incentive and the salary to encourage people to stay there, or the other powers that be a little more circumspect in its deletion of the department, so that they would have the resources and the personnel to advance matters such as this new bill. Because it is not right for an important institution to be treated as a training ground. And that is what has been happening for quite a number of years. Resource it, give them the financial incentives so that it can properly function, because it takes more than one hand to clap. You cannot introduce this bill and expect results unless the other matters that are affecting the system are properly taken care of. And there has been that very long complaint relative to the DPP's office. There is another provision which I have some issue with in this bill. And it is unclear, it is vague, it is uncertain, and it really provides no guidance, and it needs to be firmed up. This is the clause 5, which deals with proceedings which have been commenced in the magistrate's court before the act. It says proceedings which have been instituted in the magistrate's court before this act comes into force, the magistrate will determine whether the case is to be determined in accordance with the new act, or whether the magistrate will continue to hear it. Well, if we are saying that there are a number of such matters pending in the magistrate's court, then let the policy be consistent. Don't leave it up to the individual views and thoughts of each magistrate from one case to the other.
Senator, you have 5 more minutes.
Make it a default position. If charges have already been laid, but the proceedings have not yet started, then it seems to me the approach should be to provide that those matters are to be dealt with under the new system, as opposed to just leaving it to a magistrate to decide, and there is no guidance in here. If there are so many matters in the magistrate's court, if the proceedings have already begun, let the default position be that the proceedings are now, rather than go through it for the next 2 years or 3 years, if the legislation is in place, let the default position be that those proceedings which have already begun also be transferred to the masters. unless, put the burden on either the defense or the prosecution, unless the defense or the prosecution can demonstrate that it would lead to unfairness. But let the default position be what you are currently advocating as the ideal way to go forward. As it is, as I said, it leaves it up to the magistrate, and it gives no indication how the magistrate is to decide. It merely says this very illusory and vague term, which seems to be the new style of the drafters, or perhaps not the drafters, the policymakers. In the interest of justice. In the interest of justice means nothing unless you specify what the criteria is and what are the factors to be taken into consideration in deciding whether a matter is in the interest of justice or not. So I consider this not to be very useful provisions that just says the magistrate will decide in the interest of justice whether to transmit it or not. That is totally unhelpful and provides no guidance and really means nothing unless criteria is specified. Let me further suggest, and it may be somewhat radical, let's not wait for the Privy Council to tell us that persons who are in custody over 15 years, as they did with Pratt and Morgan, people who are waiting 5 years and the death sentence, let's not wait for them to also tell us people who are in custody over 15 years or 18 years, it would be cruel and unusual or a breach of the constitutional rights to be proceeding to try them or sentence them to death. Let's be radical and do something about this. You need to cut down on backlog, and you need to deal with these matters where persons have been in custody for that length of time. And you need to deal with them by some kind of radical provision which says such persons shall be offered a plea agreement and specify the circumstances, or offered some alternative something and leave it up to them to choose or not, so that we can get rid of this backlog. I was very embarrassed when I was prosecuting a matter in a foreign jurisdiction, and I told them I had to get home because my trial is about to start and my client has been in custody for some time. And they asked me how long. I said about 14 or 15 years. All the lawyers looked around at me and said, no, you must be mad. You could not be serious. And that was from Jamaica, Antigua, and somewhere else. Because this is unheard of anywhere else. We need to find a way to deal with it effectively. And it requires innovation, intuition, and pushing the envelope. Thank you.
Senator, your time has come up to an end. Attorney General.
Thank you very much, Mr. President. Mr. President, I'm pleased to take the podium to wind up this debate on this transformative bill and acknowledge the contributions which have been made today. may I address some of the issues which were raised by my senatorial colleagues on the other side. The removal of cross-examination has been raised as an issue before this honorable chamber. Curiously, there is a very recent case, the State against Curlin George, criminal appeal number 2 of 2011, decided in February 2023. February 2023, this year. Practicing criminal attorneys at law ought to be aware of the well-established position that a preliminary inquiry in our current disposition, a magistrate is not entitled to consider the credibility of witnesses and their account of facts. That was the decision in the State and Curlin George. So I fail to understand the insistence by criminal practitioners who stand here today recommending the precedent of their experience to suggest that by this bill, reducing to very limited terms any entitlement to cross-examination is somehow unfair to the accused, because in the current law as it exists, decided at February 2023, that is not a relevant consideration. And what this bill is simply doing is to codify into law the misuse of preliminary inquiries by removing the process of wasteful cross-examination at the pre-trial stage. Another area, Mr. President, which has been flagged for attention is the fact that I've spoken to the proclamation of the legislation, and it has been said that, well, the government passes laws but are not proclaimed. Senator Lachmedia cited one act, the Evidence Act, as being unproclaimed. That is ungenerous, if I may say so, with respect to the massive work which has been undertaken by this government and justice sector agencies to implement several laws which have been passed and are in effect. In fact, by legal notice number 99 of 2022, section 12AG in section 4 of the very Evidence Amendment Act and sections 6 and 7 of the Act came into operation on Monday, the 2nd of May 2022. My office has worked with the Trinidad and Tobago Police Service, Mr. President, to support the service's preparation for the intended operationalization of this act. That support commenced in 2021 and included the provision of draft regulations to the act for the consideration of the police service. The police service would require the implementation of requisite processes and procedures in order to achieve full compliance with the act. And in this regard, the Office of the Attorney General remains committed in the provision of support to the police service for work that is being done to support that service's preparation for the intended operationalization of the Act. The proclaimed provisions deal with admissibility of CCTV recordings, the admissibility of electronic evidence in any criminal proceedings, and ensuring the prosecution has an independent right to give a closing address. Those are the proclaimed provisions of the Evidence Amendment Act. Beyond this, if I may remind Senator Lachmedia of some of the major laws which have been implemented as part of this government's ongoing and comprehensive approach to justice reform. The criminal procedure plea discussion and plea agreement legislation. My office has a working committee of all justice stakeholders, Mr. President, including representatives from the Office of the Director of Public Prosecutions, the police, the prisons, the criminal bar, the law association, and the judiciary, who meet regularly to ensure successful implementation of that law. We also have the Miscellaneous Provisions Trial by Judge Alone Act, which is already law, and there is a bill before this Parliament to improve that law. But it is already in effect, and under that law, which was proclaimed, over 60 judge-only trials were elected by accused persons since proclamation of the law in 2019. And importantly, judge-only trials were the only mode of trial which was possible during the pandemic. So the country did not grind to a halt. The justice system continued to work as a result of improvements implemented under the watch of this government. The Criminal Division and District Criminal and Traffic Court Act transformed the operations of the former Magistrates Court and created the position of master. The Miscellaneous Provisions, Age of Retirement for Judges, Interpretation and Chief Judicial Officers Act 2020 raised the age of retirement for judges from 65 to 70, thereby ensuring longer judicial service of able men and women with agile minds and a commitment to doing justice for the citizens of this country. The Miscellaneous Provisions Supreme Court of Judicature and Children Act 2018 amended 13 pieces of legislation to allow for the streamlining of the processes as it relates to the treatment of children and children matters, all of these being proclaimed and in effect. The amendments also made provision for an increase in the complement from 13 to 36 High Court judges, 9 to 12 in the Court of Appeal. This is the largest increase to the statutory complement of judges since this country became independent in 1962. The Family and Children Division Act 2016 created the Children's Courts, which provides specialized expertise and resources to address the unique complexities of family and child-related legal matters, ensuring better protection of their rights and their welfare. The Administration of Justice Electronic Monitoring Amendment Act 2020, which created a system of enhanced supervision and accountability through remote tracking and surveillance and is in effect. The Electronic Payments Into and Out of Court Act 2018 allows for electronic payment of all fines, all fees, and trust accounts, example, maintenance payments. Physical cash is no longer needed. Mr. President, these are just a few of the laws passed by this honorable Parliament at the behest of this government, which are in effect. And I said at the beginning, when I commenced the piloting of this legislation, that we should avoid politicizing a worthwhile endeavor. And worse than that, we should avoid misleading the listening public that the hard work of this legislature is not being implemented. It is implemented, it is proclaimed, and it is doing better for the citizens of this country every day. And that is what we are here about today. Heavy weather, Mr. President, was also made of the perceived lack of resources and training with specific emphasis on the DPP's office. Of course, I acknowledge that I am an easy target for persons who think that I make an easy target to the extent that there are perceived differences between myself and the Honorable Director of Public Prosecutions. But without prejudicing the ongoing engagement that continues between myself and the Director, I can say without fear of contradiction that several processes, infrastructural and human resource efforts are underway to enhance the capacity of the Office of Director of Public Prosecutions. And I am not going to speak of it beyond this because I don't want it to become part of a political circus before it brings the results home that this country deserves. We ought not, Mr. President, as a parliament, allow persons to cause unfounded fears of insufficient resources to prevent this law from coming into effect. I can't understand, frankly, how responsible persons can stand here today and say, because of all of the teething pains that we are experiencing as a maturing country, we must not take steps to improve our condition. I simply do not understand it. I fail to follow the logic of that myopic approach to government. This very law is meant to ensure that resources are better utilized in the justice sector through a more streamlined and efficient system, so that in the virtual court system that we now have, I heard Senator Welch, the last speaker, speak about the fact that the preliminary inquiry should be left with the magistrates because we have magistrates spread across the country and he doesn't know how many masters there are. But in the High Court, and I pay tribute to this, the superior quality of efficiency that is taking place in the High Court right now, we have a remarkable digital justice system that is allowing for courts being held, matters being heard, persons being given trials virtually across the nation without having to physically locate people in a particular place or places. That is why the country's justice system did not come to an end with the start of the pandemic. I just returned, Mr. President, from an eye-opening experience in Spain. Compliments of the IADB, I visited Spain with a group of 6 other countries. We were Trinidad and Tobago was the only English-speaking country to participate in Spain's digital justice tour of Spain to learn from and understand what is taking place in Spain, Uruguay, Chile, Peru, Panama. And I was very proud to come away from that experience to recognize and to have other persons recognize that Trinidad and Tobago's digital justice system is on par with, and in some cases ahead of, some of those other countries. And it is the future. Digital justice, electronic documents. Just today, my daughter wanted to make an application for a particular document. She was able to go on her computer and make the application and have the document downloaded. She did not have to get into a car and deal with the traffic and drive to Sangre Grande or attempt to get to Sangre Grande for the document she needed. That is the present, which is now our future, that our judicial system is engaged in. So when we speak about the masters of the court dealing at the initial hearing and at the surveillance hearing to process the pre-trial stage in 6 months, I fail to understand the comparative attractiveness of saying we have magistrates in all of the districts who are not yet digitized. That's a work in progress, so let us leave them with the job because that's what I'm accustomed to. That is not progress. Mr. President, as a parliament, we must acknowledge that the current preliminary inquiry system does not serve its purpose. I said that at the beginning, I say it now, and I will continue to say it. It is detrimental to accused persons, to victims. It wastes precious judicial time and resources. and causes unjustifiable delays in the resolution of serious criminal matters. Senator Welch himself said when he uttered to his colleagues abroad that he had a case that was 15 years old, they thought he was joking. Well, that's what we're trying to fix. Does the system need a change now? The answer is an unqualified, all capitals, Y-E-S, yes. Does this bill provide a workable solution? And that the answer again is a resounding yes, Mr. President. If I can clarify to move to another subject, some issues that have been raised in relation to the interpretation of Communications Act, Clause 7. That clause proposes to insert references to sections 13 and 14 of IOCA, the Interpretation of Communications Act, into this bill. But it is introducing references to communications data, and stored communications, which already exist under the present law that is now being amended. It's not new. The only amendment that was introduced, and I introduced it in the House earlier this week, is because we had left out the term stored data from the group communications data and stored communications. But that's already the law, and we simply added in stored data because by an error it had been left out. That's not new, that's not now been introduced. That is the existing law. And more than that, scaremongering, the idea that communications data, and stored communications is to be said to be synonymous with intercept is just wrong. It's plain, patently wrong. Access to stored communications data does not have anything to do with intercept, which is another definition in the IOCA legislation, and I'll read it. It appears, with your leave, Mr. President, in Section 5 of the Interpretation of Interception of Communications Act. Intercept in relation to a communication means listening to, monitoring, viewing, reading, or recording by any means such a communication in its passage over a telecommunications network without the knowledge of the person making or receiving the communication. Well, nothing in this act is adopting or borrowing from IOCA the term intercept, and it is not introducing that in this act. It is significantly different, if we take the time and the trouble to read and to understand what we read, different from communications data, and stored communication. So under Section 5 of the Act, the master will issue a search warrant to seize a mobile phone because he suspects that there may be something stored on that phone. It is not going to be given the police or anyone, the registrar, anyone, the power to seize that, to listen to anyone's communication, but simply on the definition of the power of search and seizure in Section 5.2 to give the police power to seize the instrument, to see what may be on that phone that is relevant to suspicion of the commission of an indictable offense. Nobody is going to be listening to anybody's conversation. Another critical issue raised is the requirement for the filing of the indictment at the start of the pretrial process, Mr. President, instead of at the end. I heard concerns uttered of the fact that there is a likelihood that the charge may be changed, by the DPP when evidence is led in the pretrial stage. I don't understand. How are we criticizing, allowing the indictment to be laid at the beginning as a criticism on improving our justice system? The time has come for a culture change and a process change. It is to the benefit of the accused to know and to be ensured that before he is charged and brought to the courts and deprived potentially of his liberty, that all relevant state agencies are mandated to comprehensively prepare to charge and move this matter through either to acquittal or conviction, as the case may be, at the first stage. What is there unfair about that? That an accused at the beginning of the process has the confidence that the indictment will be filed so he knows what he has to face. And we have to also understand what is the purpose of an indictment. It is meant to inform an accused of what they are charged with, particulars of what they are charged with. What justifiable reason is there for not allowing the accused to know, in the legal language, ab initio, from the beginning, what he is charged with? How can that be objectionable? Mr. President, the new system ensures that the police gather all the necessary evidence against the accused before a charge is laid, and therefore the indictment can be properly informed based on the evidence against the accused. In the event that the DPP must amend the indictment for whatever reason, the DPP powers to review, amend, or change his mind about charges is, of course, supported by the evidence provided for in Clause 26, 25(1)(b). Concerns have also been raised about the either-way offenses and the right of the accused to elect the mode of trial. The mode of trial, Mr. President, as we are reminded in Hilroy Humphreys, is a procedural element of the pretrial process which does not impact the accused's substantive right to a fair trial. We are not depriving the accused of his right to be heard or of a fair trial. What we are doing is streamlining processes and upholding the DPP's Section 90 power of prosecution. The court in which a matter is to be prosecuted ought to be left to the DPP who brings the case, brings the charge before the court. Mr. President, there is a remarkable suggestion that this bill is simply moving the bottleneck to the High Court. This is a gross underestimation of the decades of consultation and policy development which has been undertaken through my office and my ministry by all those who are committed to perfecting this bill for more than a decade. There has been, and I've spoken to it, a consultative process that has involved the Office of the Director of Public Prosecutions, the Judiciary, the Public Defender's Department of the Legal Aid Authority of Trinidad and Tobago, the Trinidad and Tobago Police Service, the Law Association of Trinidad and Tobago, the Criminal Bar Association, the Criminal Justice Committee chaired by the Chief Justice, which has all of those personalities I've already identified as part of that committee, added to which there is the Office of the Attorney General, the Chief Magistrate, and the Commissioner of Prisons. Are we seriously suggesting today that one or two attorneys' personal experience of how they conduct their practice is superior in wisdom to a decade of consultation of all of these organizations who have worked with my office to perfect this bill to bring before this Parliament? Let us get real. This bill is intended to work in tandem with other legislative amendments. It's not a standalone one-trick pony or a magic wand. It is intended to work with a suite of other laws that have already been passed, that are on our books as we seek to perfect our system, and it's a work in progress. With stronger, better prepared cases, Mr. President, we anticipate that the system will not be inundated with trials and instead will operate like other systems in other countries where the majority of matters are disposed of fairly and expeditiously at an earlier stage, even before the full trial commences. And that is going to benefit, as I said at the beginning, the accused, the multiple accused, the victims, their families, persons who languish in remand yard for 2 to 3 to 10 years. What advantage can there possibly be for us to tell ourselves that we must not at least try? I was asked, Mr. President, to provide Thank you, Mr. President. I was asked to provide examples of what documents may be the subject of anonymization. Mr. President, let me first of all underscore that the anonymization which is spoken to in this bill is not a new concept that is being introduced by this bill for the first time. When we read the bill, we see that anonymization, by its definition, is taken from the definition of other existing legislation. It is already part of our law. It is already part of our law in relation to sexual offenses cases and documents which give details of children. It is to protect the identity of persons who are vulnerable. Another example is the need to protect the information that involve state witnesses and those under justice in protection programs. In anonymization, the court and the parties, including the accused, are aware of the names and details of the documents, but the essential protection which is being afforded under this bill is to protect against public distribution of the information. That is what the anonymization is geared towards. It's not to make for and keep secrets and expose people to charges and not know who their accusers are. Let's read the bill. Let's understand it. Mr. President, in order to ensure stakeholder readiness, the government has for the last 12 years engaged key stakeholders. I've been over that more than once. I'm not going to repeat it, but I say it only to reassure Senator Welch that I did not speak to the time between the passage of the bill here today and proclamation to engage in further public consultation. The consultation has already taken place. What I said was it would prepare us to sensitize persons who have to work within the system. And I can give this court the assurance that my office is working even as I speak. Well, not as I speak, it's after 6. But in the course of our normal work days, we are having training sessions with the police. We are supported by the UNDP and other international agencies in sensitizing the stakeholders who are going to work to deliver the justice system that this bill is going to contribute to. I think I've said enough, Mr. President. I would ask this bill to support the government in passing this bill into law, and therefore, Mr. President, I beg to move.
Honourable Senators, the question is that a bill entitled An Act to amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011.
Attorney General.
President, in accordance with Standing Order 66-1, I beg to move that the Administration of Justice Indictable Proceedings Amendment Bill 2023 be committed to a committee of the whole Senate, forthwith to be considered clause by clause.
Senators, the question is that the Administration of Justice Indictable Proceedings Amendment Bill 2023 be committed to a committee of the whole Senate, forthwith to be considered clause by clause. Those in favor say aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Okay, honorable senators, this bill has 45 clauses. There have been no circulated amendments throughout the debate and prior to this committee stage, so we shall now begin. Clerk.
Clauses 1 to 45.
Honorable senators, the question is that clauses 1 to 45 stand part of the bill. Honorable senators, the question is that clauses 1 to 45 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 1 to 45 now stands part of the bill. Honorable senators, the question is that this Senate agree with the committee's report on the administration of justice indictable proceedings amendment bill. Is it something? I'll start again. Honorable senators, the question is that this Senate agree with the committee's report on the administration of justice indictable proceedings. Right. Honorable senators, the question is that the bill be now reported to the Senate. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate. Attorney General.
Thank you, Mr. President. I wish to report that the Administration of Justice Indictable Proceedings Amendment Bill 2023 was considered in the Committee of the Whole and approved without amendments. I now beg to move that the Senate agree with the committee's report.
Honorable senators, the question is that this Senate agree with the committee's report on the administration of justice indictable proceedings amendment bill 2023. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Attorney General.
Mr. President, I beg to move that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a third time and passed.
Honorable senators, the question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a third time and passed. Those in favor say aye. Aye. Those against say no. No.
Dr. Brown.
Aye.
Mr. Amo.
Aye.
Ms. Gopiskun.
Aye.
Members, allow the division to take place, please.
Mr. Sinanan.
Aye.
Senator Mark and members on the other side, please allow the division to take place in silence.
Mr. Hussain.
Yes.
Ms. West. Mr. Mitchell.
Aye.
Ms. Cox.
Yes.
Mr. Bacchus.
Yes.
Mr. Singh.
Yes.
Dr. Ibrahim.
Yes.
Mrs. Sagram Singh Suklal.
Yes.
Mr. Sukai.
Yes.
Mrs. Lizama Leasing,
Yes.
Mr. Hislop,
Yes.
Mr. Mark,
Abstain.
Ms. Lakshmi Diyal,
Abstain.
Mr. Naked,
Abstain.
Mr. Lider,
Abstain.
Mr. Roberts,
Can't say I'm being disturbed by the other side.
Abstain.
Yes, yeah.
Ms. Bisram Singh, Dr. Richards.
Yes, ma'am.
Yes. Mr. Vieira,
Yes.
Dr. Diyal Singh,
Yes.
Ms. Dionarine,
Yes.
Mr. Timal,
Yes.
Mrs. Thompson-Aye,
Aye.
No. Dr. Dylan Remy,
Yes.
Mr. Welch,
Yes.
Mr. Drayton.
Yes.
Mr. President, the result of the division is as follows. 24 members voted for, no members voted against, and 6 members abstained from voting.
Senators, the results of the division is as follows. 24 members voted for, 0 members voted against, and there were 6 abstentions. As such, the question is put and passed.
A bill entitled An Act to Amend the Administration of Justice, Indictable Proceedings, Act 2011, Act number 20 of 2011. Private members' business motions.
Senator Mark.
Thank you, Mr. President. Mr. President, I beg to move the following motion standing in my name. Be it resolved that the Industrial Relations Amendment to the second schedule, Order 2023, be annulled. Mr. President, I do not know how many citizens are aware that on the 26th day of May 2023, legal notice number 163 was issued by the government entitled the Industrial Relations Act, Chapter 8801, Order. May I read this legal notice for the record? Made by the President under Section 67(6) of the Industrial Relations Act. And when we say President, it is not the President of the Republic. It is a cabinet headed by the Prime Minister and his members. Subject to negative resolution of Parliament. the Industrial Relations Amendment to the Second Schedule Order 2023. This order may be cited as the Industrial Relations Amendment to the Second Schedule Order 2023. And the Second Schedule to the Industrial Relations Act is amended by inserting after item 10 the following item, and I quote, liquid fuel pipeline facilities and network services, dated the 26th of May 2023. Now, Mr. President, this legal notice, like a thief in the night, was issued by the cabinet headed by the Prime Minister and his members, arbitrarily, whimsically, capriciously, simply declaring, Mr. President, liquid fuels as an essential service. No explanation, no discussion, no consultation with anyone in the country. But it has implications, which I will demonstrate. Mr. President, bear in mind that, and let me repeat for your edification again, the government has declared as an essential service the liquid fuel pipeline facilities and network services. I would like the Honorable Minister of Labor, when he's responding, to explain to Trinidad and Tobago, what does network services entail? What does it mean? Does it mean National Petroleum Marketing Board or company? We need clarification very early on this matter. Mr. President, what does this mean? When we talk about an essential service and when we talk about an essential worker, what do we mean? Mr. President, who works in an essential service? Without rather defining what is an essential service, we have to look at the existing law to be guided, Mr. President. So, Mr. President, I take you to the Industrial Relations Act, Chapter 8801, and we go to what is called the Interpretation and Definition section. And on page 8 of this act, essential service means the services set out in the second schedule. So when you turn to the second schedule, Mr. President, what do you see? What is located? You have in the second schedule, Mr. President, electricity service, generation, transmission, distribution, water and sewage services, internal telephone service, external communications, including telephone, telegraph, wireless, fire service, health services, hospital services, sanitation services, including scavenging, public school bus service, and what is called the civil aviation service. So, Mr. President, under this particular measure that is before us today, the government has defined liquid fuel pipeline facilities and network services as an essential service. Now, there is also in this piece of legislation something known as an essential industry. That is in the Industrial Relations Act. But when you go to the essential industry definition, it simply tells you, Mr. President, that an essential industry means an industry specified in the first schedule. So you go to the first schedule of this act called the Industrial Relations Act. And you find, Mr. President, some 13 industries outlined. I wouldn't spend too much time on these industries. Suffice it to say that the government has taken a decision to debar workers in the liquid fuels company of Trinidad and Tobago as essential workers. Mr. President, if you ever travel near the Caroni crematorium, you just look opposite and you see a lot of white tanks with pipelines. That is known as the Liquid Fuels Company of Trinidad and Tobago. They store, that location stores fuels, whether it be diesel, super unleaded, premium, kerosene, or jet fuel. All are stored at the Liquid Fuels Company of Trinidad and Tobago. So the government has declared that service that is offered by that company as an essential service. Mr. President, may I inform this honorable House that the employees located in this particular service industry, Mr. President, because of what we are debating now, there are over 100 workers or employees at the Liquid Fuels Company of Trinidad and Tobago. By this decision, what the government has done is to debar, to deny the workers of the Liquid Fuels Company Limited of embarking or taking or undertaking industrial action. Because by the definition that I have given, and by placing that particular service under an essential service, it means, Mr. President, that the government has taken a decision to declare these workers as essential workers. What this means, Mr. President, is that these workers cannot, under the law, withhold their labor. Your only right as a worker when you are involved in an industry that is not an essential industry is to embark on strike action in order to gain benefits or improve your terms and conditions of employment. But, Mr. President, it does not stop there. With the definition that I have given you of essential service, what it means, Mr. President, is that if any worker and unions were to embark on industrial action, which would include strikes, lockout, go slow, work to rule, etc., Mr. President, the workers under the law can be fined and or jailed. Their trade unions can be decertified. Their leaders can be fined or jailed. That is what an essential service means. It takes away the rights of the workers to withhold their labor. So what we are dealing with here today, Mr. President, is what the government has decided to do by defining this particular liquid fuel service and facilities as an essential service in Trinidad and Tobago. Now, Mr. President, we need to understand when we talk about industrial action, when we talk about essential services, what do we mean? What are we talking about? Mr. President, there is no definition of essential services under the legislation. I had to go to the International Labour Organization to outline for me, so I could outline to this Honorable Senate what an essential service really means. Mr. President, your only right as a worker in an industry that is not defined as an essential industry is when you decide to embark on action to improve your terms and conditions of employment. you are able to do so without any repercussions, meaning you are not fined, you are not jailed. The officers of the union are not fined, they are not jailed. And your trade union certification is not removed from your trade union. However, if you are an essential service, Mr. President, you cannot take strike action. You cannot withhold your labor. If you withhold your labor, there are consequences. The key point I would like to emphasize, Mr. President, is that fundamental right of the worker to withhold his labor. But when you place that worker under an essential service, he cannot withhold his labor. And what has happened is that when we go to the International Labor Organization conventions, both 87 and 98, we see, Mr. President, where under these two conventions, workers have the right to withhold their labor because it is a fundamental right. These conventions, 87 and 98, the right to organize, the freedom to organize, and the right to engage in collective bargaining have both been ratified by the government and people of Trinidad and Tobago. Mr. President, may I remind you that it was under slavery that the slave did not have the right to withhold his labor. When we come to Trinidad and Tobago in 2023, the worker cannot, under this particular company, because of the declaration of this company's service as an essential service, cannot withhold his or her labor. And Mr. President, that is extremely sad. It is troubling. It is worrying. Because why would the government, Mr. President, go to cabinet and declare liquid fuels and facilities and network services as an essential service without any consultation, without any discussion, without any kind of negotiations? We had to read this thing, access this information through a legal notice because it was subject to negative resolution. And because of our vigilance, we were able to discover what the government had done. Hence the reason we are here today to have that motion annulled. We have come here today to have that motion annulled, Mr. President. Mr. President, so the government has proceeded in a very stealthy way, almost engaging in subterfuge by secretly declaring a service.
Senator Mark, two things. One, just be careful about the line that you're going down and the statements that you're making. And two, your main point has now come full circle with many concentric circles in between. So I would ask you at this point to move on to a brand new point. If you have one, we've heard all about what you stated in relation to essential services and what happens when an industry is put under essential services. So if you have any other new points to bring forward at this point, for the other half of your contribution, I invite you to do so.
Mr. President, I brought to your attention earlier that I searched far and wide for a definition of essential service, and I couldn't find one. It is not in the Act. So I had to journey to the International Labour Organization. So let me explain to this honorable House what an essential...
Members, could we have a little bit of silence while Senator Mark is making his contribution?
Mr. President, let me explain to this honorable House what the International Labour Organization has defined as an essential service. Mr. President, I'm quoting from a document by the International Labour Organization on essential services on page 9 of this report. And what has been defined as an essential service? And I quote, "What is meant by essential services in the strict sense of the term depend to a large extent on the particular circumstances prevailing in a country." It continues, "Moreover, this concept is not absolute in the sense that a non-essential service may become essential if a strike lasts beyond a certain time or extends beyond a certain scope, thus endangering the life, personal safety, or health of the whole or part of the population." Mr. President, I want you to pay attention to these words. If the action taken via a strike contributes to the endangering of the life, personal safety, or health of the whole or part of the population, then the government can deem that particular service as an essential service. It can then, Mr. President, issue what we have here as a legal notice, as a rationale for justifying its actions. But in the legislation that we are dealing with, Mr. President, the government has provided no justification. The government has provided no rationale for its decision to declare liquid fuels as an essential service. Mr. President.
Mr. President, on a point of order, please. 53(1)B. I think this is the third circle back now.
So, Senator Mark, the point of order put forward is upheld. I have cautioned you once before. We've heard this argument before. If you have something new, I invite you to bring it forward now.
Mr. President, I want to ask you to look at the Industrial Relations Act. Because when we talk about essential services, it has to be seen in the context of the definition of worker within the meaning of the Industrial Relations Act. And when we look at the Industrial Relations Act, Mr. President, you will see what is defined as a worker and what is not defined as a worker. So under the Industrial Relations Act, a worker is not defined in the context of those citizens who work in the general labor force of the nation. So there are certain categories that are not defined as workers. What are those categories, Mr. President? So that we can understand this concept. Police officers are not defined as workers, Mr. President, and therefore they cannot embark on industrial action. Members of the public service cannot take industrial action, and they are not defined as workers. Members of the fire service, members of the teaching service, members and employees of the central bank, Mr. President, members who are defined as domestic workers, persons who are defined as apprentices cannot be workers under the law. It means to say, Mr. President, that when you are not a worker under the law, you cannot embark on industrial action.
Mr. President, it's a filibuster now. It's a proper filibuster now. 53(1)(b), please, and 46(1).
So, Senator Mark, on 46(1), I listened intently to the point that you're making now, and I'm not exactly sure where it lies in relation to what is before us, and therefore I uphold 46(1) in relation to relevance. I think you need to think just a little bit more about that argument that you're bringing, because it doesn't fit with what is before us and what you're trying to do. So if you have anything else, I invite you.
Many more things. Mr. President, let me just explain to you what has occurred in this situation that we are faced with. Mr. President, the reality facing us today is that a union known as the OWTU represent the workers of National Petroleum. They have just applied to the Registration, Recognition, and Certification Board for recognition status for the workers represented or working or employed at a company known as the Liquid Fuels Company of Trinidad and Tobago. It is that very company that I referred to earlier, whose services have now been deemed an essential service. Mr. President, it is passing strange that as soon as the OWTU submitted their application for recognition to the Registration, Recognition, and Certification Board, sometime in May of 2023, as soon as the company was written to by the Recognition Board, 2 days after, before a reply could be given, the government of Trinidad and Tobago, through this legal notice number 163, declared those services provided by that company to be essential. Now, Mr. President, is the government seeking to deny those workers and their trade union the right to organize as is their right under the law? Is the government seeking, Mr. President, to use this particular legal notice placing those liquid fuels as an essential service, to deny those workers who work at NP as we speak today to be also an essential service. That is why I've asked the Honorable Minister, when he's wrapping up, when he's making his contribution rather, if he can define for us what is network services. That is what I would like him to define for us. Mr. President, I would like to bring to your attention the historical evolution of this situation that we are facing, that I'm speaking to. Prior to 1965, in Trinidad and Tobago,
that is way outside of the boundary line. No, Senator Mark. Number one, this is a motion to annul. What essentially is required is reasoning as to why it should be annulled. You've given that reason for the first 21 minutes. The second point that you've made bordered but did not properly cross imputation of improper motives, which cannot be used to give a definition to annul what is before us. So for the third time, I'm going to ask to bring a third point, if you have it, whilst you have a few minutes to complete your moving of this motion.
Mr. President, I am putting a simple point forward. And the simple point I'm putting forward is that the government of Trinidad and Tobago, without any consultation with the relevant parties, went behind the back of the workers and declared a service an essential service. And I am putting to you and to this honorable House that you cannot simply overnight take such a decision without any consultation with the workers involved and their unions. And in this instance, because you're talking about the fundamental rights of the worker, you are talking about the Industrial Relations Act that defines what an essential service is under the second schedule. The government has simply used negative resolution to give effect to this notice of 163, taking away the rights of the workers to withhold their labor. That is what the issue is. The government cannot whimsically just take away people's rights. And we are saying that the workers should be able to get an answer from the government of this country. Why are you seeking to place these workers back into slavery? That is what we are concerned about. The workers fought against the slave masters in order to be free. And why should we, in 2023, have new slave masters seeking to take away their rights? This is a fundamental issue. This is an issue, Mr. President, that goes at the heart of the people's rights to determine their quality of life and their standard of living. Mr. President, I want to tell you, when we talk about essential services under the Industrial Relations Act, you have within the Industrial Court two important institutions that these workers can go to because of their refusal, because of their being debarred the right to take strike action. So what are these two divisions? There's something called the Essential Services Division. That division, Mr. President, is the division that all essential service workers have to go to. And there's another tribunal within the Industrial Court called the Special Tribunal.
It's getting to a certain level inside the chamber where I cannot even hear Senator Mark. Continue.
Mr. President, when the workers cannot take strike action, they are supposed to be treated in a special way. So they can go to the Essential Services Division in order to execute and in order to prosecute their case. That is what the Essential Services Division is about. Mr. President, you know what is happening? The government, through the cabinet, deny workers the right to withhold their labor. And that is, it doesn't end there. The government, Mr. President, establishes these two divisions. But you know what? All the members of these two divisions, including the chairman of the Essential Services Division, is appointed by the very cabinet led by the Prime Minister. So imagine you take away the rights of the workers to protest and to withhold their labor, and then you send them before a tribunal and an Essential Services Division.
Mr. President, 46(8), please. Mr. President, 46.
There's a point of order. 46. No, so I won't uphold 46(8). Continue, Senator Mark.
So, Mr. President, the government, the workers, Mr. President.
Senator Mark, you have 5 more minutes.
Mr. President, the workers are being placed in chains by this government. That is what is going on. I was making the point, Mr. President, that the people who head the special Essential Services Division, they are appointed, the chairman is appointed by the Prime Minister and his cabinet. All the members are appointed by the government. And there's something called the Special Tribunal. And the members of the Special Tribunal are appointed by the Prime Minister and the cabinet. So here it is, Mr. President. You deny me the right to withhold my labor by declaring this to be an essential service. And you tell me at the same time, Mr. President, if I am to take action, I have to go before a tribunal. And the tribunal members are appointed by you. So where's the independence? Where's the justice? Where's the fair play? There's no fair play. And Mr. President, a classic example of the uneven playing field is the imposition by the government of 4% on these workers. You put 4% on the workers and you send them before essential services.
So, Senator Mark, again, you're outside of the boundaries. You have literally just a few minutes again. I invite you to wrap up the moving of the motion now. Don't even bother to repeat what you've said before because you repeated it many times. So that is in and of itself a kind of wrap up. So summarize as best as you can to end off at the allotted time. Please.
Let me just summarize what I've said. The reason why I have brought this motion for annulment today is to ensure, Mr. President, that before the government embarks on action against ordinary workers, there ought to be consultation, there ought to be discussion among the parties. In the absence of any discussion, where you are fundamentally eroding and subverting the rights of the workers, Mr. President, we are saying that that ought not to take place without proper debate. We are debating the matter now. And because the government did not find the opportunity or took the time to engage us and engage the movement, we are saying, Mr. President, the government should not be allowed to pursue this legal notice number 163. And therefore, Mr. President, we are calling on the Senate to support the annulment of this motion. There has been no justification put forward by the government for this invasion, incursion, subversion, undermining of the trade union and the workers in question. So we are calling on the Senate, when you are seeking to take away the rights of the workers, to withhold their labor, Mr. President, you must have good reasons for doing it. And if you don't have good reasons and you cannot justify it, you should not embark on that course. And therefore, we are calling on this honorable Senate to send a message to this government. Do not trifle, tinker, tamper with the fundamental rights of the workers of our country. And we are saying to the government in closing, this essential service concept has to be reviewed, because tomorrow morning, Mr. President, the government can get up and say taxi drivers are an essential service, and that is it. The Minister of Labor can get up the next day and say all the workers in his ministry are essential workers, and therefore that is an essential service, because it is done whimsically, it is done arbitrarily, it is done maliciously and capriciously, and we cannot allow that to continue. And therefore, Mr. President, I have brought this motion in defense of democracy, in defense of the trade union, in defense of the workers, and we are calling on the Senate to have this motion annulled, negative, and not go forward. Thank you, Mr. President. I beg to move.
Who is seconding the motion?
Mr. President, I beg to second the motion and reserve my right to speak later in the debate.
Honourable Senators, the motion has been seconded by Honourable Senators, the motion has been seconded by Senator Lakshmi Dayal. Honourable Senators, I shall now propose the question for debate. The question is, be it resolved that the Industrial Relations Amendment to the Second Schedule Order 2023 be annulled. Minister of Labour. One second, Minister of Labour. We have Senator Dayal Singh first. Senator Dayal Singh.
Thank you, Mr. President, for allowing me to present on this motion raised by Senator Mark. Now, this motion basically serves to look at the reasons why government would have seen it fit to put the natural gas in the category of essential services, an essential industry or an essential category. And I would like to start by saying that I looked at the Industrial Relations Act, and the first schedule lists the essential industries categories. And one would be electricity service, generation, transmissions, and distribution. Two would be water and sewage services.
So, Senator Dayal Singh, let me just state from the outset, I hope it is not your intention to repeat everything Senator Mark has said, because he has done so ad nauseum. The comments that you're making right now in terms of the Industrial Relations Act and all of the essential services, Senator Mark spoke to them. He called them out. There's really no need for you to go over them. What I'm looking for at this juncture is anything new by way of reasoning as to why this motion should be approved. If you have something new, not stated by Senator Mark, I invited you to bring it forward now.
But I'm trying to get some clarification from the minister who would be soon be addressing us about some misconceptions.
That is all well and good, but there's really no need to repeat anything Senator Mark has said. You don't need to read out what is an essential service, what is under essential services by the way of the Industrial Relations Act. All that has been stated. You would be in breach of tedious repetition if you do so. So if you have questions for the Minister of Labour, by all means.
Thank you, sir. But I just wanted to read number 7 in that category that I want to expand on. Number 7, besides all the others,
So, Senator Dayal Singh, there's really no need to read out number 7. There is one that is being added by way of this order to that essential services list, which forms the boundaries of this particular debate. You get where I'm coming from?
What is being argued in this act is already included in this, and this is what I'm trying to say, right? So I'm looking at number 7, where an essential industry would be oil, gas, petrochemical, exploration, exploitation, refining, manufacture, distribution, and marketing. So then I looked at this and I'm wondering if it is already gas, oil and gas, and we are already speaking here in this first schedule of manufacture and distribution. I was under the impression that it may have already, this liquid gas may have already fallen into the ambit of this, listed on the 7th schedule. You see, so I had gotten some correspondence from the OWTU where they questioned this legal notice number 163, and they actually had letters given to the independent senators asking us to study this, to give an opinion on this. And so therefore I wanted to figure, you know, their questions, what they actually wanted to do as a union in terms of this new, of what was being proposed here. So according to their letter, they actually spoke on the fact that they would have been disadvantaged in terms of their workers. And Senator Mark did say it's 100 and something workers. And I must say, the protection of citizens' rights, I think, is important, workers' rights. And I mean, so we were just on from Labor Day, and we heard all the good things we heard about the oil industry, the strikes, the Uriah Butler, what he did, he stood up for the rights of the workers. And similarly, if we are looking at of the concerns of the OWTU, who I must say served the oil industry well and actually helped the rights of the individuals working in the oil industry, they do have some concerns. But I am really trying to figure, you know, if we already have this part 7, I'm not seeing the problem here, because according to what I am reading into this, is already covered under this schedule. So my take on this is that if you have the workers taken out from the protection of you know, being under a service that is deemed essential or non-essential. If they are essential service, now they are not allowed any sort of legal strike action. So my problem is, will that be at a disadvantage to the workers? And I have to say, sir, I think that the worker disadvantage, if they are at a disadvantage, is there anything in place that could come about to alleviate that? We went through the arbitration bill here recently. So I'm seeing if there's a worker that is disadvantaged, this is something that we probably would have to look at the government meeting with the workers. As I think Senator Mark said, there were no consultation. And this is the only thing I have a little concern about. If there was no consultation with the 100 plus workers, I think this is something that doesn't augur well. We were just from another bill where the AG said there were widespread consultation in some other pieces of legislation. So I'm thinking if this is so, we may have fallen short on this. So the question is if you have an essential service, and the fact is essential services are there in case you have any sort of problems in the country, you have, you need these services to run. Jamaica has health, water, food, electricity, public works, firefighting, civil aviation, telecommunications. And we know that natural gas is essential for us to run our electricity plant. So even all the other countries that I looked at, UK, water, gas, electrical, if somehow there is action taken and we are not afforded the free flow of natural gas, we may be disadvantaged in terms of our electricity supply. So this is where I want to form the connection that even though it was not on the schedule, and my interpretation that it is in the schedule, I would have thought that if it is vital to provide electricity, which is an essential service, I would have loved that connection to be at least explored further. Because we would be in a country where we would have had a great disadvantage if suddenly we are cut off from electricity due to some legal, strike action. So the workers' rights, I think, could still be entertained by consultation with them, arbitration agreement. I think also the need for us to realize that even though we are moving away from natural gas as our main source of power because we are going into the natural energy supplies, I would think that moving into other energy supplies, we would have played a less importance to our natural gas. But as it is now, it is still part of our whole spectrum of getting foreign exchange. It's part of our fuel that we need. And even though we would say we'd move to other renewable energies, presently, I think it is definitely an essential service. And one thing I just want to bring up, sir, is that even in Iran, Iran runs on natural gas. And they provide 10% of the world oil reserve, 15% of the gas reserve. So, but Iran, there's an all global union. And even on 26th of April 2023, they allowed Iran, which is a country where this is very draconian, they had allowed their contract workers at the oil and gas fields in their south area to be able to strike for increased wages and better working conditions. So my point is, if Iran could do that, we would not want to appear to be put in any sort of draconian sort of what I'm saying, put in some sort of measures in place where our 100 and something workers could feel disadvantaged. It wouldn't look well. So I'm saying I would rather government consult with the workers, form an agreement, but as it stands now, I am thinking for the benefit of the country, we would have no choice to, I would have no choice to not really support Senator Mark's motion, because I definitely think that natural gas is essential for us, essential for electricity. Thank you, sir.
Minister of Labour.
Thank you, Mr. President, for the opportunity to contribute to this debate. Before I actually outline government's position with regards to this, I need to make some clarifications based on what a number of members would have asked. In the first instance, I believe that Senator Diyal Singh is confusing oil and gas and chemicals with what we're dealing here today, which is liquid fuels that are really gasoline, which is super premium diesel and aviation fuel. And therefore, they both belong to two different industries, and they are not essentially the same. I listened intently to the spirited contribution of Senator Mark, and, and what was very interesting is that I wasn't too sure at one point who he was arguing for, in that he sold his product and then he bought it back. But I will address some of the issues that he raised as I move along, Mr. President. We are here today to essentially discuss the amendment to the second schedule and its annulment for the liquid fuel pipeline facilities and network services. Section 67(9) states that the President of Trinidad and Tobago may, by order, subject to negative resolution of both houses of Parliament, vary the second schedule by adding thereto and removing therefrom any service. Therefore, it stands to reason that the second schedule can be amended by adding or by subtracting various services. And that is why we have exercised that right, given the issues that I'm about to raise with respect to the liquid fuel pipeline facility and network services. The question was asked, what is the network services? And Senator Mark indicated that if you do go to Caroni and you look opposite the crematorium, there is a large facility there with a number of tanks. And they don't bring fuel to those tanks to fill them. When fuel is brought into Trinidad and Tobago and it goes to the point of Pierre, Paria, that is then pumped from Point of Pierre to Central, and there are other pipelines that take aviation fuel to Piaco and then back into Port of Spain. That is several miles of pipeline that is considered a network. And therefore, that is where the network services come in as distinct from the plant itself that does the receiving and the distribution of those fuels to tankers for distribution. And therefore, that is why it is called network services. There seemed to be an issue with what is an essential service. And the concept of essential services have been enshrined in our laws for a very long time. An essential service is one which is so vital to the day-to-day existence of any population that it is necessary to preserving life, health, public safety, and basic societal functioning, as well as to ensure an uninterrupted flow of such services, for example, water, electricity, hospitals, etc. Whether they are delivered by public or private providers, services may be considered to be essential because they are public goods that sustain the well-being of each citizen and help the development of society as a whole. The International Labour Organization was quoted, and within the ILO, various member states have adopted a variety of measures to ensure the continuous delivery of basic services. So yes, it is part of the ILO thinking, and many member states have adopted the use of essential services as a tool to ensure that their citizens are serviced as best they can, especially where it can lead to shortages and poor service. So the ILO supervisory bodies have included measures that balance the needs of the public good with the fundamental right of workers to participate in the determination of their conditions of work in a meaningful way. Honorable members will observe in a previous amendment a new category of essential service was added, which was the public school bus service. Historically, some of us might recall the addition of transportation to the category of essential services due to a strike in 1969 that impacted the citizens of this country. Liquid fuel and pipeline services, liquid fuel, pipeline facilities, and network services are clearly critical infrastructure and essential services. These facilities and services are a critical part of the energy infrastructure of this country, responsible for the storage and transportation of motor fuels and aviation fuels. Mr. President, the Liquid Fuels Company of Trinidad and Tobago provides services that are pivotal and play a key role in its transportation by virtue of its capacity to distribute 75% of the country's petroleum fuels. A disruption in these services can therefore result in a disruption to the supply of gasoline and aviation fuel, which would severely impact the day-to-day life of citizens. The effects would be detrimental in the case of aviation fuels, as it would affect not only the airline industry, but it also will create some reputational risk for Trinidad and Tobago. The 10 essential services are now the 11th that we listed. If we were to just examine for a moment, and I urge you to consider a week without petroleum products available for distribution, what would that impact be? What will happen to the fire services? What will happen to the hospitals? What will happen to almost every aspect of our life? Well, electricity is more natural gas. But if you consider that disruption and what it could possibly do to Trinidad and Tobago in a meaningful way in terms of turning back the clock, we will be in a very bad place. Let me just put it like that. Let me debunk the issue that this thing became an issue overnight, and sometime in May, somebody met surreptitiously in some back room and decided to move it from where it was. This issue started since in 2018. The Ministry of Labor since then was asked by the energy and energy industries to comment on the inclusion of the following provisions. We considered it then, and as you know, by the time 2020 came around, we had the COVID-19 and a number of things got put on the back burner. And in any event, it did not take a day for us to decide that this is what we needed to do. Given when Senator Marks said that the OWTU would have applied for recognition, which was sometime in May, and we began this discussion in 2018, the math's not mathsing. So we, at the Law Review Commission, which was called on May 15th, the entire issue, we had not received anything from OWTU by that time. The entire issue was discussed and the decision was made in the public interest. And we seem to be caught up, Senator Mark, that is, in the issue of workers' rights. But what about the public good? There are mechanisms in place to deal with workers in essential industries, and Senator Mark himself did a very good job in outlining the industrial court and the essential service arm of the industrial court, which treat with these issues in a very quick and timely manner. We all know, it's just common sense, we all know that you cannot have an essential service and issues relating to those essential services and workers prolonged for any period of time. It's shooting yourself in the foot, it's committing public policy suicide. So when workers have issues in essential services, they usually come to the Ministry of Labor and we go through a conciliation exercise. Thereafter, if we cannot meet and treat and arrive at a conclusion that is satisfactory to all, it may be referred to the industrial court, and in that case, the essential service department will take up that. So it's not like we are trying to somehow take workers' rights away, as is being suggested. We are quite mindful that those workers do in fact need a special kind of treatment, and it is one that we will actually give. Senator Marks asks, what about consequences? And I will put the question back to him. What about consequences? You spoke of consequences to the workers, but what about the consequences to you and me? What are the consequences to children not being able to go to school? What are the consequences of the fire services not being able to arrive at a scene, or an ambulance not being able to take your loved ones, your children, your father, your grandparents, to the hospital because they don't have fuel? What about those consequences? So it seems that the entire argument that was being put forward was one to support the OWTU's quest for recognition, ignoring everything else except the rights of what we refer to as the workers. I have no problem, and I can speak for the government of Trinidad and Tobago, we have no problem with unions. We're not trying to bust anybody. We're not trying to create an issue. And I ask the question rhetorically, by doing this, do we harm workers? Do we mash up the union by 100 workers not being able to be represented? not to be represented. Let me roll that back. All workers have the right to representation. That does not mean that those workers don't have the right to representation. What it means is they cannot take industrial action or strike in an adverse way that impacts on the public good. Therefore, the issue, I think, and the herring that is not being put out there is that if it becomes an essential service, then OWTU may not be able to represent those workers having already been a representative in another essential service. And therefore, it seems that we are talking about the impact of the bottom line to the union and whatever else goes with it. So the Act provides for strikes by every other classification of worker except essential service workers. And that impact is really pales in comparison to the possibility of what could happen 1 week without fuel. Just 1 week. And the provisions within the IRA, the Industrial Relations Act, for treating with workers and essential services is quite clear. I am confident, Mr. President, that a very large majority of the people in this country will agree that the burden of duty of any government is to protect the vital interests which members of the public have in being spared hardships caused by work stoppages, which could cause severe damage to not only the economy, but to the daily lives of citizens. It has always been the tenet of good industrial relations practice that industrial conflict in areas which stifle the flow of essential goods and services should be avoided. While I maintain a firm stand against industrial relation action in essential services, I pledge with equal vigor to pursue the settlement of disputes which may arise in such instances. It is therefore not reasonable to annul the amendment. As Minister of Labour, I reiterate the commitment of the Government of Trinidad and Tobago to good, fair, and collaborative industrial relations practices. This addition simply recognizes that liquid fuel pipeline facilities and network services are essential to the day-to-day running of this country. Mr. President, I want to thank you again for the opportunity to contribute to the debate of this motion, and I thank you.
Senator Mark.
Thank you. Thank you, Mr. President. Mr. President, I want to thank Senator Varma Dayal for making his contribution to this annulment motion. I also like to thank the Minister of Labour for clarifying that issue of the network services. And I want to elaborate on some other points that you have raised as I bring the proceedings to a close. But before I do so, Mr. President, may I indicate that there is a difference, and I think Senator Dayal was seeking to clarify, And I think the minister was also attempting to clarify. To some extent, he did. But under the Industrial Relations Act, when we look at the first schedule, as well as the second schedule, Senator Yelsing spoke to the issue of oil, gas, petrochemicals. And he was saying, as if this issue of an essential service was already captured. But I want to make the point, Mr. President, that an essential industry the workers and their union in an essential industry can take industrial action. So in the case of the OWTU, before your government politically assassinated, decapacitated Petrotrin, the OWTU, Mr. President, could have taken strike action. So even though it is captured under industrial, essential industry, it does not necessarily mean that you cannot take industrial action. But whenever you fall under an essential service, you cannot embark on strike action. So there's a difference. There's a difference between the essential industry and the, so like for instance, National Petroleum, they could take industrial action because they are not captured under essential services. We know, based on what the Honorable Minister has said, that National Petroleum Marketing Company is going to be transformed according to the budget statement of 2021 into a real estate landlord operation. And what the minister also said, innocently but quite powerfully, is that the attempt by the OWTU to represent the workers of the Liquid Fuels Company Limited will not be successful. And the minister said in his contribution that the OWTU already represents workers in an essential service. So all that the minister did not say is that, listen, you see that attempt, Mr. President, for recognition status by the OWTU to represent the 110 workers of the Liquid Fuels Company, Liquid Fuels Company of Trinidad and Tobago, Mr. President, you are going to fail. Minister, through the President, could you clarify for Trinidad and Tobago that the OWTU will not be able to represent those 110 workers of the Liquid Fuels Company of Trinidad and Tobago, because the OWTU, Mr. President, I may have misinterpreted him. So, Minister, I am prepared to take my seat for a few seconds for you to clarify for the country. Can you clarify?
Mr. Senator Mark, you, better than me, know the industrial relations rules with regards to essential services and how many essential services any union can represent. Right? So I don't need to say that OW2 will not. The IRA is very clear on that.
I understand what you have said without saying it. I understand what you have said without saying it. Mr. President, I want to make it very clear that we need to review the entire process governing industrial relations in Trinidad and Tobago. We cannot continue. No, I'm responding not to you. You didn't speak.
Senator Mark, yes. Senator Mark, have a seat. You are a seasoned senator in this chamber, and I know you have the ability to ignore and continue your contribution.
Yeah. So, Mr. President, I was hoping that the Honorable Minister would have been able to provide us with some perspective as it relates to the future. Mr. President, democracy is a messy. Please, 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 I can't talk. I hear myself. Only disturbing me. Yeah, Honorable President, the reality is, and the Honorable Minister alluded to it, and you made a very good point. How do we balance the interests of the worker or the working class with that of the society? That is the issue. No, in France, every day in France, workers, if they are only attacked by the government or the employers, the airport shut down. Because they have the right in France to strike. They have the right to strike. Because you know why? In France, Mr. President, the reality is countries and governments that have a respect for the rights of the working class. Without workers, there will be no production. And therefore, Mr. President, there's always a battle between capital and labor, always a conflict between capital and labor. So the question that we have to deal with, and I agree with the Minister, how do we seek, Mr. President, to balance that interest? You cannot put or pull the scales in one direction. And that is what the government of Trinidad and Tobago has been doing. You have to balance it in the interest of the workers. And that is what the Minister was arguing in his contribution there. And he was making the point about, if my family gets ill and have no fuel in the country, what will happen? Are they going to die? Who's going to provide ambulance services? Who's going to provide? Mr. President, the reality is, before...
So, colleagues of Senator Mark has the floor. He's the only one that I need to hear. Have a seat, Senator Mark. He's the only one that I need to hear. When you speak, you're actually speaking over him. So I would ask you to just temper. Continue, Senator Mark.
So, yeah, there's no problem. So, Mr. President, the reality is that since the government appeared on the political stage in this country, there has always been an attempt by this government to shackle and to handcuff labor in Trinidad and Tobago. I want to remind this Honorable Senate, Mr. President, through you, that workers had the right to strike in any industry in Trinidad and Tobago. They had that right, but Eric Williams removed it. I want to remind this Honorable House through you, Mr. President. Yeah, just, you want to speak to? No. You go ahead.
Thank you for giving me. Senator, I know you were interrupted a short while ago, but you were on the point of ambulance services and ill persons getting to hospital and other connections using fuel. I don't know if you had completed that point.
I had gone past that because that was developed. That was developed in balancing the interests. Mr. President, I passed that point. I was trying to deal with the interests. So and that is why that is why, Mr. President. No. That is why, Mr. President. That is why I was about to indicate to my dear friend that we need to have a conversation on this issue. How do we balance the rights of the workers and the working class against the rights of the state and the interests of the public? And that is the kind of conversation. So when they talk about ambulance, fire, it doesn't matter. Let us sit down as a nation and discuss this issue, Mr. President, because I was about to develop the point that in places like Italy, Mr. President, and in France, and in the UK, you would know, Honorable Minister, through the President, just recently nurses and doctors went on strike in the United Kingdom. In Trinidad and Tobago, that is outlawed. It is outlawed in Trinidad and Tobago. You can't take strike action. So, Mr. President, I want to say that it is important that if the government is taking action, and I must indicate, Honorable Minister of Labor, through the President, you gave us a very, very succinct, sharp definition of what is an essential service. Mr. President, you know, I looked through this Industrial Relations Act, and there is no definition like this. Honorable Minister, through the Honorable President, can I propose to you that you bring an amendment to this act where the definition of essential services can be defined in law? We don't have it in law. We don't have what I have to go to the ILO. And I saw where you took your definition as well from the ILO. So we're on the same page. But the question here is that, Mr. President, I'm not displaying, right? Right. Why we cannot place in the legislation the definitions of what is an essential industry and what is an essential service. Why? Why we can't do that? Because, Mr. President, right now, why I brought this annulment motion, Mr. President, is because we did not know that the government of Trinidad and Tobago had taken that decision. When the OWTU knew about it, was like when we discovered it. There was no discussion with the OWTU. I'm not saying that the government had a duty or responsibility, but I'm saying, Mr. President, just out of courtesy, you have a stakeholder who has applied to the recognition board for certification as the majority recognized union to represent the 110 workers. And whilst that is taking place, Honorable President, I just want to share with you the chronology so that we can have it on the record here, so that everyone could appreciate what has transpired. It caught everybody by surprise. And that is why I made the point, Mr. President, the Minister of Labor has a responsibility and a duty to keep the stakeholders together, to inform them, to communicate with them, so that they will know what is happening, Mr. President.
Senator Mark, one moment. Leader of Government Business.
Thank you, Mr. President. Mr. President, in accordance with Standing Order 14.5, I beg to move that the Senate continue to sit until the completion of the business at hand, inclusive of matters on the adjournment. Thank you.
Honourable Senators, the question is that the Senate continue to sit until the completion of the business at hand, inclusive of the matters on the adjournment. Those in favour say aye. Those against say no. I think the ayes have it. The business of the Senate. The business of the Senate will continue until the completion of the business at hand, inclusive of the matters on the adjournment. Senator Mark.
My honourable friend who wants us to curtail our debate. Yeah, Mr. President, yeah. I just wanted to share with my honourable colleagues, right, the chronology of this whole situation. And that's what generated the concern, and concerns, if I may say. Mr. President, it was on the 20th of April, 2023, that the OWTU made an application to the Registration, Recognition, and Certification Board for recognition at the liquid fuel company
Point of order.
Trinidad
Standing
and Tobago.
Order 53(1)B.
Okay, so Senator Mark, once you are responding to the comments that are made before, you should be within the standing orders. Same thing, Leader of Government Business. Is something else to say?
Yes, Mr. President. Mr. President, Senator Mark is literally repeating the sequence, the chronology that he gave during his contribution. So I didn't take it as a response.
So, whereas that may be true, and understandably so, he does have the right, as the mover of the motion and wrapping up, to respond to comments made by the Minister of Labour and Senator Dayal Singh. So it is in that context, Senator Mark, I'll allow you to continue, but obviously be mindful of tedious repetition within your wrap-up itself.
Yeah, thank you. Mr. President, as you rightly said, the Honourable Minister, did make reference or mention to this recognition attempt by the OWTU. And it's against that background I'm just giving a chronology of how this thing actually occurred, so that at least members of this Honourable House would be aware of the sequencing of this whole process. So if I may go on, Mr. President, on the 20th of April 2023, the union wrote to the company that is the Liquid Fuels Company of Trinidad and Tobago, informing that company of the application it had made in accordance with the IRA, and they had copied same to the Honourable Minister of Labour. On April the 28th, a notice of application was issued by the Registration, Recognition and Certification Board in the context of the application that was then made. Mr. President, on the 24th of May 2023, it was the Recognition Board that sent a letter to the Liquid Fuels Company of Trinidad and Tobago, informing them that the OWTU had an application before it. And before they could have responded to the Recognition Board, the legal notice of the 26th of May, 2023 emerged. So within 2 days of the recognition board communicating to this company called the Liquid Fuels Company of Trinidad and Tobago, indicating that they have an application from the OWTU for recognition status for the 110 workers. Mr. President, within 2 days, the legal notice was issued by the government. And it caught everyone by surprise. And now we understand why the government has chosen to take this particular course. Well, Mr. President, I want to indicate to Trinidad and Tobago, and I want to indicate to the OWTU, that a united National Congress government will review this whole issue of what is and what is not an essential service. You have, and the ILO has warned this government, you know. I have several pieces of correspondence from the International Labour Organization warning this government, I shouldn't say warning, seeking to encourage the government to make certain changes to the law. Mr. President, the ILO has called on this government to bring about minority unions in workplaces. Forget this 50+1.
Senator Mark,
right?
don't expand too much into all of that. Try and keep it to what is before us. Continue.
So you see, if you recall, the Honorable Minister of Labour spoke to the issue of ILO supervisory committees. He did make mention of ILO supervisory committees, or supervising committees. But the reality is that when you look at the various components of the ILO, our country being a signatory to the International Labour Organization, and we being a member since 1963, all I was bringing to your attention is that the ILO has been advising the government every year through their experts on the various labor committees, looking at conventions 87, the right to organize, and 98, freedom of collective bargaining, and calling on the government, Mr. President, to allow minority unions to represent workers. And you know how many years this government has committed to doing that, Mr. President, and they have done nothing. Now the relevance of it, Mr. President, is that teachers have not been defined. No, we're talking about essential services, Mr. President. Essential services. That's
Again,
all.
hold on. One second. So you have to be very careful because the boundaries in this is very tight. Yes, essential services are relevant, but it's a specific body or industry falling under those essential services by way of this order. Anything outside of that will put you in breach of Standing Order 46.1, which speaks to relevance. Senator Mark.
Now, if I may journey to 2018 that the minister referred to, the minister indicated to us that this event, this whole issue of determining whether this particular liquid fuel arrangement ought to be essential or not began in 2018. That is what the minister said. That discussion started since 2018. And he said he said COVID intervened and they had to deal with it sometime in 2020. Right? So I just wanted you to take note of that particular statement that was made. So the government, Mr. President, had begun to contemplate deeming that service as an essential service since 2018. And Mr. President, no consultation, no discussion, at the end of the day, Mr. President, the government will have the last word. And that is why, Mr. President, I'm calling on the Honorable Minister of Labour to look at this issue of taking decisions in the way they have taken without any consultation with the workers or their unions. We should be able to have consultation. Look, we will review the Industrial Relations Act on this issue of essential service and what is an essential service and what is not an essential service. I think it has been abused. Mr. President, let me give you an example of what I'm talking about. Mr. President, let me give you an example of what I'm talking about. You know under this act that we are dealing with here, the government has put in civil aviation as an essential service. Pilots, aircraft. But you know, under the International Labour Organization, the International Labour Organization, to which we signed on in 1963, is saying that that is not an essential service. So in other words and so on, the government of Trinidad and Tobago has deemed civil aviation pilots
Senator Mark,
as an essential.
we're not dealing with the civil aviation unless in some way, form or fashion, you're going to tie it to the industry that is spoken to in relation to this order. So once again, I'm calling upon you to move forward to any other point that you have to ensure that you remain within the Standing Order 46.1, which is relevance.
All right, Mr. President, I believe that I've made my case on behalf of the workers, on behalf of the unions in Trinidad and Tobago. Mr. President, democracy can only flourish and grow and expand, Mr. President, when freedom reigns supreme. Yes. I want to remind this, Mr. President, I want to remind this House before I take my seat that we are here today in this honorable House because of the blood, sweat, and tears of the working class that we voted in 1937 in this country, that brought about self-government in this country, that brought about fundamental reforms, the right to vote. Those are fundamental advances that were brought about by the labor movement, the trade union movement, led by Butler, Rienzi, and all these heroes.
Senator Mark, even in your final comments, members, even in your final comments, you would still need to be relevant. So I understand what it is you're trying to say. Keep it as tight as possible.
You know, Mr. President, I must tell you something, and just in a passa. I, as a seasoned politician, said, sometimes without casting any aspersion on anyone, including your good self, Mr. President, I have more freedom of speech outside in the public than here in the parliament.
That way, yes.
But I cast no aspersions. I cast no aspersion on anybody.
And if you say you cast no, you cast the aspersion, and then you say you cast no aspersion, it doesn't.
Because I don't want you to take it personally. So
have a seat. Okay, I withdraw. And I apologize to my president. Okay, members. Okay, I'm on my legs. So, just again, Senator Mark, you don't say you cast no aspersions and then begin to cast the said aspersion. That is not how it works. You just don't cast it at all. Continue.
So, yeah, Mr. President, I brought in closing, I want to close off, right? Because I don't want to go further. I don't want to go further. No, I think I have made my points. I think the issues have been cleared up. I think the people of this country would have witnessed what has happened today. And I can only hope, Mr. President, that the government of Trinidad and Tobago would appreciate, for instance, the hurt, the injury, the harm that they have brought to the workers of Trinidad and Tobago by that action that the government has taken. And I want to just say, Mr. President, that this is a matter that will be the subject of review by an incoming, may I repeat, this is a matter that will be under review. We will revisit this matter in consultation with the stakeholders in this country, including the OWTU, to ensure, Mr. President, that we have a democratic, united approach to addressing critical, sensitive issues impacting on our society, economy, and citizenry. So with those few words, Mr. President, I thank you and I beg to move.
Honourable Senators, the question is, be it resolved that the Industrial Relations Amendment to the Second Schedule Order 2023 be annulled. Those in favour say aye. Aye. Those against say no.
And the working class come to in this local election, Mr. President, in this local election, is sabotaging a division.
Please, when a division is called, I expect the chamber to fall to silence so that the clerk can call the names and the answers can be heard properly. Continue, clerk.
Dr. Brown.
No.
Mr. Armour.
No.
Ms. Gopi Schoon.
No.
Mr. Sinanan.
No.
Mr. Hussein.
No.
Ms. West.
No.
Mr. Mitchell.
No.
Ms. Cox.
No.
Mr. Bacchus.
No.
Mr. Singh.
No.
Dr. Ibrahim. Mrs. Sagram Singh Suklal.
No.
Mr. Sukai.
No.
Mrs. Lazama Leasing.
No.
Mr. Hislop.
No.
Mr. Mark.
Yes.
Ms. Lakshmi Dial.
Yes.
Mr. Lina.
Absolutely yes. Shameful PNM.
Ms. Bisram Singh. Mr. Roberts.
Yes.
Mr. Nakid.
Yes.
Dr. Richards.
Abstain.
One second, clerk. Senator Leida, I know I'm speaking English. And I know you understand the meaning of the word silence. Continue, clerk.
Dr. Richards. Mr. Vieira.
No.
Dr. Dial Singh.
No.
Ms. Dionarine.
Abstain.
Mr. Timal.
No.
Mrs. Thompson.
Abstain.
Dr. Dylan Remy.
No.
Mr. Welch.
Yes.
Mr. Drayton.
Yes.
Mr. President, the result of the division is as follows. 8 senators voted for, 19 senators voted against, and 3 senators abstained from voting.
Honorable Senators, the results of the division is as follows. 8 senators voted for, 19 senators voted against, and 3 senators abstained. As such, the motion is not carried. Leader of Government Business. Just because we are at the end of the proceedings do not mean that I do not have the authority to control the decorum in this chamber. Leader of Government Business.
Thank you, Mr. President. Mr. President, I beg to move that this Senate do now adjourn to a date to be fixed.
Honourable Senators, before I put the question on the adjournment, leave has been granted for a matter to be raised on the motion for the adjournment of the Senate. Senator Mark.
President, in the interest of our democracy, and seeing that we have all worked as a family, I am going to defer this matter to the next sitting of the Senate. And
Honourable Senators, the question is that this Senate do now adjourn to a date to be fixed. Those in favour say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to a date to be fixed.